Excuse me. At the last hearing, Hannah, my associate, left the charger cord. Did you guys find something?
Let me see.
It was like a computer. Here, she'll show you.
Leader, they want to hear from the mayor. If y'all ain't learned that yet, the mayor, not the trustees that don't do nothing, that only run their mouth.
Hide the money, y'all. There's poor people around. With your broke ass.
All right, all right. Blessings, blessings, leave our family. So what we're going to be watching is the Thornton Township Election Board hearing that is hosting the evidence hearing for Napoleon Harris. We watched the first one where they were contesting the validity of his address, and they were in between two locations. So what we're going to do is listen in. I want to send a shout out to Critical Smoker. He's out there on the scene. His information is at the bottom. Check him out. We have a clear picture. We're going to see how this go down. Sending love and blessings to you guys. I'll be here in the bushes with y'all. And yeah, we'll talk about it. We'll talk about it, and I'll make sure that we don't interrupt. Please hit the like button and definitely jump in the comments because that's where I'm going to be. What's his name? Osteen? No problem, Tina. Thank you for being here with me. I appreciate all you guys and the new subscribers. I really appreciate you guys taking the time to get to watch the content from a different perspective. Definitely, I love y'all insight too. Y'all see things that I don't see while we're waiting. And you remember the fight video and people kept saying about him, your head, her head on. I didn't see that. And y'all brought that up. And then I saw it like, wow. So I appreciate y'all insight. That's what I want to build here. Critical thinking, unity. And we're going to talk about this law and these crooked politics. Please hit the like button. Thank you. I hope they start on time. And I think they're just gonna be hearing Napoleon's case. And guess what? It's gonna be people there that's gonna be testifying. I do want to clarify something. In my last live, when we were talking about this, I had mentioned one of the ladies, I think her name was Janice or something. And I was like, ooh, that could be Napoleon's girlfriend. I was correct. I corrected. That's the lady from the school board that Tiffany was yelling at. Yeah, I remember when Tiffany was yelling at them because she didn't let them have a party. So that's the lady that's going to be testifying hopefully today. So we're going to watch and keep our eye on these people who are testifying. I just wanted to clarify that. Y'all know if I ever give y'all mix up information, I'm going to come back and clarify. So yes, that's the lady when Tiffany was yelling at her on the phone. I'm like, Janice, we can't have a party. What about the kids? Let's put our infamous mayor on the screen. Because she's behind most of all this contesting that's been going on. You definitely know that, her and her goons. And y'all remember what happened to Thicker Than a Snicker, KP and Smith. They were so embarrassed and they, withdrew their petition. And they was giving them a hard time, just to give y'all a little flashback to remember what happened on the last meeting. And get ready. This is probably going to be drawn out because Napoleon lawyer, he liked to take it for a ringer. Not, and like I told y'all, no disrespect. You got to do what you got to do when you're getting paid. But he petty. He petty. Is he? And they changed the location. They having it downstairs. Blessings, blessings, and welcome. Good morning, everyone.
My YouTube channel, Critical Smoker. Critical Smoker.
Yes, shout out to Critical Smoker. His information is at the bottom. I didn't know he was going to show up. I'm glad he did. And bear with me, y'all. My energy a little low.
Yes, sir.
I'm a little under the weather a little bit. First time, y'all.
Is it like a thing with soccer?
Ooh.
It is? Okay.
Just different, jazzy. Yeah, that's all.
Yeah, because it was like, ask him what kind of socks he has.
Oh, Olison. Olisten. Am I saying this wrong? Olison. Tell me his name, y'all, because I don't remember it. But that's the lawyer. I wanted to see was he saying something. The lawyer that represent everybody. Told y'all there's only 4 lawyers in the whole Dalton and Thornton Township. I'm cracking jokes. Let me press my mute. I'm about to over here talk stuff, y'all. I ain't got too much patience. I'm trying to have patience. I want them to start. Yeah, I just basically take vitamin C and garlic. I don't really get sick. Like I made it through the whole pandemic without getting the thing. And I think my son passed a little bug to me. So it was funny while we watched. Yesterday, I just took 1,000 milligrams of vitamin C just on GP, just because I wanted to. You know what I'm saying? And I did my little 1-2. And I don't go out much. But yeah, I'm feeling much better because I woke up and my chest was hurting when I was coughing. I'm like, I'm coughing, my chest hurt, but I feel all right. I hit it like a nurse. So I am a little tired right now, but my body not achy. So thank you. And I definitely will get some of that tea. I just got some green tea and some detox tea. I hit it. I'm over here acting up. Love you guys. Thank you for being here. What y'all think is going to happen, though? Get in the comments. I know everybody be like, great, you so pessimistic. I try not to be, but, let's see what's going to happen. I would like it to be good competition in Thornton, but this contest is very serious. That's why I definitely knew that when they contested Nate, it wasn't going to go too far. Wasn't going to go far because it wasn't valid. But this right here, now Napoleon has to prove, and also the people who are contesting has approved. That's why they're trying to do subpoenas. And I hope right now that that lady in the middle, the lawyer, is back looking at all of the subpoenas, because that's what she was supposed to do, to kind of redact pertinent information. Remember they were talking about that? Augustine. Thank you. Augustine. I'm gonna try to remember it. Thank you so much. Odison. Okay, I think that looked better. Odison. You see, I'm a memory person, so I think that's it. That's his name. But I think him and Delgado got a war against each other from something that we may not know, and they're using these towns. Bert Odison. Thank you. Appreciate you using this town against each other. And that's one of the things that Tiffany tried to say, but there's a lot of lawsuits filed. Also, you heard when she shut down the town, KP came on talking about, yeah, the lawyers suggested us to shut it down. It wasn't. It's like they just playing chess against each other, and the people are suffering too. This is a main factor in this as well. That's why our youth gotta go to school and go be lawyers and stuff, for real. It sound corny, but then we be in bonds like this. These people been in here for hundreds of years doing the same damn thing. Oh, I had this on the screen for a long time. I like it. I don't use zinc too much because off the top of my head, zinc is, and I can't, it's information educational purpose only. YouTube be giving me a hard time, but I know zinc is not water soluble. So you have to be careful so it won't get toxic in your body. I know don't take it every day. It's like vitamin D, the unnatural vitamin D, where you take it and it's not water soluble, meaning that it can work on your kidneys and liver. So like vitamin C is cool. Fish oil is cool. They don't build up toxins. So just remember when you're taking these natural supplements, look to make sure if they're water soluble. If they're water soluble, that means that you could pee it out and they won't build up toxicity. So I just gotta throw that out there. I'm real funny. I don't play no games. I'll be taking vitamin C this is how I survived the Ovid while we listening. I used to put eucalyptic oil inside of my N95 mask because that's an antiviral. I'm saying allegedly here because YouTube weird. Go look it up. So I used to inhale that on top of my mask, and then I used to take 1,000 milligrams of vitamin C, garlic, and then I was dealing with my heat, my Judah people. Judah was taking sea moss. They put me up on sea moss. So I had that. I'm like, I broke that down. That was cool. Started using that a little bit. And that's actually what I used throughout the Ovid. And I was right there in the middle of the fight. And I didn't get it. I didn't use a lot, y'all. So, and then I used to take like hot showers, hot baths. I used to strip, not to be fresh. I used to strip at the door, make sure I ain't bringing allegedly the COVID in. And I need the hot baths. That's another thing. The steam and the hot, it increase your macrophages. That's a part of your immune system. So yeah, guys, I'm on it. I'm here for y'all. Y'all know God been letting me put in the work. Thank you guys for joining me. I really appreciate it. I love this channel. I love what I do. I love this. Y'all know I be getting excited of court cases. I used to be arguing at work. I'll be at work at the nursing station listening to a court case, and I'll be like, hold a nigga temp, and all the nurses will look at me. I'm like, no, not y'all. I'm like, okay, if y'all see me arguing with my phone, I'm listening and working, and I said it's like watching football. I promise you. So I said, why not just take it to YouTube? You know what I'm saying? Make it fun, educational, and hit it. So yeah, just a little bit more about Grace. Thank you for your prayers and your suggestions. I'm on it. Come on, y'all. When is about to start?
He was speaking to you. He was truly
And
speaking.
then my mom begged me not to come.
Really?
Shout out to
She
Grace.
said I got a bad feeling.
You knew it.
Oh, and that sounds like Nicole. I know her voice.
So I smoked the joint and stayed home.
It was a good plan. It was the right plan.
Uh-oh.
You know, a lot of people went viral on that. But
My mom's friend said she saw
saw me on Inside Edition.
People think,
I
people
was
think,
like, I don't want to be on Inside Edition.
people kept calling me. You were at that. Nope.
We're being nosy. We're being nosy. We eavesdropping.
All views ain't good views.
I mean, the journalist in me went out the window, and I was just wanted to protect myself. Honestly.
Turn this up.
I mean, I was fine, but you know what I mean.
Oh, we eavesdropping tonight. I thought that was Nicole. Yeah, I see her there. Critical said that he stayed home because he didn't want to be part of that. He felt like something bad was going to happen. Honestly,
Are watching this.
Everybody ready to go? All parties ready?
Yes.
Yeah, 1,500
all right.
Convening the Township of Thornton Electoral Board. I'm Ellen Raymond, the chairwoman.
Madam Chair, would you like me to take over?
Yes, please.
You got it. All right, we're gonna do the roll call right now. We've got Chair Raymond, Member Osfeld, Member Swanson.
Present.
We have all members present. We do have a quorum. Today we are here to hear the case of Supervisor O2C, Keith Price, Michael Smith, and Julian Harris versus Napoleon Harris. And are the parties ready to proceed?
Yes.
I do have one quick order of business. We do have 2 decisions to issue. Would the parties prefer that we issue the decisions at the end of the meeting, or we can move that up to now?
I think we should push it to the end.
Is that okay with everybody? Okay, we'll do that. That's fine. Okay, so we are here to start off the hearing on that case. The objector has filed objections, just for the benefit of the public. The objector has filed objections challenging the residency of Napoleon Harris III, and it is the objector's burden of proof, so the objector can get started.
We do have some preliminary motions.
Okay,
The first would be a motion to exclude witnesses. This matter is also being live streamed right now by YouTube, and I see witnesses that are going to be present. So how does this board seek to exclude them from using and viewing YouTube while this matter is proceeding?
no, that's a fair point.
What?
I guess we could, is there room available at the township that we could possibly sequester the witnesses in and ask them to leave their electronic devices someplace? Anybody in the township? Okay, let me take a quick break and see if I can figure this out. Just bear with me one moment.
I don't like that.
I hope they don't try to give me the stop.
Well, that's not what they're talking about immediately. They're talking about sequestering witnesses, so that the ones that are waiting don't hear the testimony.
Because I have the right to live stream.
Right. No, I don't think that's in question.
Yes.
It has more to do with what the witnesses are hearing.
Yeah, 2,000 people.
I'm not waiting. You can judge for 2 sheep.
And we just talked about that, right? I just talked about wanting to hear the witnesses and see the witness, and all of a sudden they must be watching us or something because they like, yeah, YouTube are streaming this, but they know Critical Smoker. We want to see who these people are. This ain't no murder trial. Why they gotta hide? They got going on. They starting the riffraff. So if you don't know what's going on, they're trying to find an area to sequester the witness that don't want to be on YouTube. So this is what's holding it up. I don't understand why. This is a public forum and the public example. It's weird. And I won't be talking when they're on. So take a break and do this nonsense. We could talk about it, but this is a little off. So I wonder what the people have to hide. This is not like, you know, a terrible case. What's the problem? Oh, or it can be that people scared for their lives. I gotta keep that in mind. What's going on in Dalton and Thornton is. Hold on one second, yeah. Go ahead.
It's very hard. I don't know. I worked in a lab. I don't know. I don't trip over.
Yeah, right, just stay there.
They could, I know they have one, up in the water. And
Hey, Phoebe,
then,
you still doing well?
instead of this
Because I
one,
know
my
that
father
COVID
was
can
the
start.
But I had me messed up for about a month.
Yeah,
first thing I-
yeah,
the
that's a long time to be sick.
downstairs was
That's a long
horrible.
time.
It was mostly that cough, and I didn't want to come around anybody with that cough,
Yeah, yeah, right on.
you know, because like 21st century, coughing in public is like shitting on yourself. I'd rather shit on myself in public.
It's a little much, but I dig what you're saying, yeah. Yeah, no, I mean, people look at you as the head snap. I do it to people. They're like,
Yeah, I'd be like, it's sinuses.
it's allergies. It's here, take a clear. Stop coughing.
So we do have a room that we can put witnesses in. What we can do is have them lay their cell phones outside on this table before they go in and sequester the witnesses. I'm sorry?
Maybe just have them admonish not to do that, because there are people back there for hours, they might have other things they need their cell phones for.
What do the parties want to do? Because I do understand the concern, you know.
And if they have children, you can't not have yourself.
Okay, that's fair. What is the board want to do? Do we want them to allow them to have their cell phones? Or just tell them that they can stay off social media, stay off YouTube, do not watch anything related to this hearing? Okay, is that fair?
Okay.
I have an issue with it, is that, the events of Thornton Township seem to be one of the top rated things on social media. We are here today in this room because of security concerns. And quite frankly, people could text stuff to people. I've had cases where witnesses have received virtual text messaging from a hearing telling the witness what's going on. I'm sorry, the phones need to go away.
If I could hop onto that, some of this is being recorded live stream. So even though witnesses may be in another room, the witnesses that are here are being live streamed to the public where people can watch it. It's problematic.
Well, let me ask, how many witnesses do we have that are here right now? Yeah, you, and what's your name, ma'am?
My name is
Jolene Harris, okay, you want
and
to
I'm
be,
gonna need a soft-seated chair.
well, you're one of the objectors, so you're a party. So actually, as a party, she does get to stay here throughout the whole time. Mr. Smith also would get to stay here throughout the whole proceeding because they're parties to the litigation. So are there any
Mayor
other?
Clark is the only witness that is not a party. That's here.
Okay,
And Mayor Clark is in our case in chief, which would lead to my next is, if you've not disclosed Mayor Clark, right?
Yes, we did. He's my first witness.
Is that Mayor Clark, the candidate for supervisor?
correct,
Same one?
correct.
Also Harvey resident.
So would the parties be okay if just Mayor Clark went in that room, if he's the only other witness?
That's fine with me.
Okay, Mayor Clark, would you mind going in that room and maybe giving your cell phone to your attorneys, and if there's an issue?
Yeah.
As long as you understand that if the city burns down, you guys are responsible.
Well, that's why we're telling you to give it to your attorney's office.
And for the record, Mayor Clark has tendered his telephone to his attorney, Carrie Lynn Peercrafter.
Also meeting Mr. Subbett, which you can put him back there also.
Okay. All right, is that agreeable? And then Mr. Supper also. You want us to hold it up here?
Coffee.
Yeah, I'll put it on this table over here.
Who was there with this?
What was,
His name is Richard Subbett.
it's pretty comfortable.
We don't see it on this witness list.
He's not on the witness list because he's actually a person being produced in response to the preliminary motion that we didn't receive until last night. It alleges that checks were not served. He has knowledge about that.
So you could put him in the room at this time until we argue the motions.
Did anyone deliver to me any hard copies of witnesses, subpoena documents, because I didn't get them?
No, we were told to bring them here.
So are you giving them to us now?
When we start the hearing, we will, as far as introducing exhibits.
Thank you.
Okay. Go right ahead.
Had some discussion about that, just for the record, so it's clear. I will, just so the record is clear, we've had a motion to exclude witnesses. We've had a discussion on the procedure for that. And so I make the formal motion. The witnesses will be excluded until the end of their testimony by all parties. Cell phones are not allowed back in the room, so there's no way of getting in. So the motion is to grant the request to exclude witnesses pursuant to the terms that were arranged.
Do we have a second on that motion?
Second.
All in favor?
Aye.
Motion carries.
One other point, we've kind of staggered the arrival of our witnesses based on when we will be calling them, so there might be people that are arriving. So if they come in during the hearing, they should be directed to be excluded also.
Yes, if you can indicate to us when they come in.
But then we have the same problem, right, that you brought up, that Steve brought up, that they're at home watching the live broadcast, so they're not really excluded.
That's a matter for cross-examination, and then come on, have they done that or not, and then go to wait any testimony.
Yeah, I mean, if they're not here, we can't
I know.
do anything
I'm
about it
just
right now.
pointing
So, but
out
yeah, I mean,
that's
I do
didn't
think that,
fall in what we just granted.
well, as the board, you guys can always start off the examination and say, have you been watching any of the proceedings today? And, you know, we as a board can ask those questions. So, and you guys can put that on the record. And I think that would be a fair way to proceed.
Okay,
Agreed.
is that okay with candidates council?
We will have to, if someone walks in, we'll deal with it and cross-examination.
Thank you, everybody.
The second topic I had was scheduling for today. We have witnesses that, you know, I don't want people to be swarming this place and sitting around for hours. So we get a sense of Mr. Mullen's schedule as to the number of witnesses and how long he thinks he's going to take.
I think that's fair. I think we should ask that honestly of both sides, you know, to have an idea of, you know, how many witnesses do you guys intend on producing? How long do you think your case in chief is going to take? And then, you know, obviously we'll ask the same question of the candidates.
And then like last week, we'll cut them in half, and you did a great job shortening it.
So we have at least 4 witnesses that we will be calling today. There are several others who we believe have told us they will attend, but I'm not certain they will. And then we'll have some documents that we're going to ask to introduce into evidence. So I would say a couple hours.
Okay. And candidates council, how long do you think you're?
I don't know how long cross-examination is going to take.
That's
for each
fair.
of these witnesses.
How many witnesses does the candidates council intend on introducing? And I know that might change depending on, of course, what happens in the case in chief.
Right. We know that we have subpoenaed 4 witnesses. One's going to be their first witness. And then we have Mr. Dorf. I'm more concerned about him traveling down here, especially how bad the weather is, and there's flooding on 94 and
In 290.
in 290. There's flooding everywhere.
The Bishop
now.
Ford, the Dan Ryan,
So
yeah, it's kind
I
of a
just want
hot
to give
mess.
him enough time.
Okay, all right, do you know, did you schedule a specific time for him to be here, or are you
I
gonna
was,
be contacting him? and-
I'm contacting him
Okay.
now to tell him maybe like 4 o'clock, but how long are we going till today?
5. Is that an agreement? And so you need to also remember, we need to discuss between ourselves and render a decision, hopefully by 5, so that doesn't mean evidence until 5. Also, for disclosure's sake, I'm not sure what role Michael Dorf plays, but you can see in his resume that you provided, I share a ICL chapter that we write together. So I don't know if I need to disclose that or if that makes any difference.
I don't think that makes any difference one way or the other. I mean, I think it's completely independent of this situation, so.
I don't know what he's being called, but I was happy to see his name. A brilliant writer.
Well,
Read his half.
Manager, I also think on the CV, you also shared, I think, an article with Mr. Mullen, so.
Oh.
Mike Dorf.
Co-author of the election law chapter on ethics.
Oh, and
There we go.
ours, oh, state and federal remedies, sorry, election chapter. I guess he's writing the whole book.
So I will tell Mr. Dorf to get here by 3:30.
Yeah, I would say that should be fair. Okay, so any other preliminary matters before the candidates, before the objectors start their case in chief? Yeah, we have
Yes,
motions,
yeah.
correct?
Yes, yeah, we have 3 motions in regards to the evidence. For the record, that Bert Odelson, one of the attorneys for the candidate, and I think Mr.
Are these
Seckler.
microphones working? I'm having trouble hearing you, Bert. I'm sorry. That's all.
That's right, I think you might just have to move it a little closer, Bert.
We have 3 motions. I think Mr. Seckler's going to do the first one on 237 motion, and then I'm going to do the one to asking the board to strike the submission of all the hearsay unmarked exhibits. But I would yield, if it's okay with the board, to Mr. Seckler to argue the first motion. We have hard copies if the board would like hard copies.
Yes.
There's 3.
Which are we hearing first?
The first matter, this is Ross Seckler, SCCLER, on behalf of the candidate. The first matter that we would like the board to address is the untimely and frankly invalid Rule 237 notice produced. We've filed a response and objection there too. And this gets to the fact that on a document that was entitled a Rule 237 notice produced was emailed to the council, the electoral board, as well as council to the candidate from the objectors council. That was on January 29th at 9:41 p.m. saying that they want Napoleon Harris III to be here and to produce all these documents. As the board is well aware, the objectors requested and were issued a subpoena, among others, a limited subpoena for Mr. Harris to come. And under the board's own rules, service of those subpoenas have to be done as the same manner in the circuit court. The objectors failed to do that in any way, shape, or form. The objectors, in proving that, the objectors on the 28th of January tried to reach out to counsel and said, will you accept service of these subpoenas on behalf of Mr. Harris as well as his wife? He said, no, you have to follow the rules. You have to follow the law. Just like they did not accept service or didn't volunteer to accept service on behalf of the objectors, and for the subpoenas that we were granted as the candidate and we issued and did properly serve, they did not, would not, just agree to limit the rules and allow them to shortcut the mandatory procedures to compel someone to appear here. The board's rules of procedure are clear on this. I believe at the first initial hearing, and I apologize that I was not here at the initial hearing, but at the initial hearing, there's a long discussion about notices to produce as well as subpoenas. And the key and clear thing was all of that had to be requested in advance and at the same time, within the agreed upon timeline. They did not request a notice to produce. They requested a subpoena. They issued a limited subpoena, and they did not serve a subpoena. They attempted and are going around. They're trying to backdoor and compel someone's appearance here when it does not have proper service and notice of those to be here with those documents. This is it is just an it exemplifies, and as we'll be discussing the other objections and responses, as was mentioned and discussed at the last hearing in this matter, this exemplifies the malicious mischief of this case. They don't want to input the resources to actually do and comply with the board's own rules. They don't want to comply with the Supreme Court rules. They want to just shortcut that and spend as little amount of time and resources as possible in order to waste this candidate's and this board's and this township's time, money, and resources. That is it. They don't want to do the work. They want you to do the work. They want us to do the work, and that's it. And that is my big problem. They have the burden of production, and they have the burden of proof. They have failed there, and this request is demonstrative of the bad faith nature of this objection, and we request that it be denied and rejected. And further, we part of that is
your major point.
Yes, thank you.
And objector, did you bring us hard copies of that supplemental request? We have these hard copies of their objection.
Copy of the notice to produce.
I have a copy of the notice to produce. We emailed them to the board. We don't have copies of the notice. All it is a notice to just produce Mr. Harris and request the same documents as were approved by the board in the subpoena.
So if I can just ask a question before you speak, I thought a lot of the documents you asked for in the supplemental request were already in the list to be provided by the candidate.
They are. We got the subpoenas on Saturday. We had our service processor go out Sunday, Monday, and Tuesday to both addresses, the one in Flossmoor and the one in Harvey, and they were unable to effectuate service. There was no one present there for multiple attempts. And at the Harvey location, I believe the door would not be answered. There was someone there. That's when we asked them if they would accept service, and they said they would not accept service. Mr. Harris is a party. We talked about doing a 237 notice at the last hearing. There was no deadline set for that. We agreed to do a subpoena instead. And we made multiple attempts to serve it, and were not successful. And the problem here is that Mr. Harris is a party to this case, right? He's not some third-party witness that is not outside the jurisdiction of the board. And it is unfathomable to me that the candidate not appear to be cross-examined to testify on his residency. And he's proffered an affidavit that they are seeking to admit. So basically what they're trying to do is have their cake and eat it too. Have him come in and provide us an affidavit setting forth what he believes to be the facts about his residency, and not come in and be cross-examined, and he's a party.
Is that because of our expedited timing that the senators in Springfield doing official?
Well, he
business?
was not in Springfield. We had people looking for him in Springfield. We had two senators who,
Excuse me, I have to interrupt because he was in Springfield. And I talked to him in Springfield, and I talked to aides in Springfield. So that is a misstatement by Mr. Mullen.
well,
The senator was doing his job in Springfield.
We also produced. the records.
several of the senators said he was not at the caucus meetings. We had someone trying to find him and serve him in Springfield. I had two senators text me, and I have the text saying that he was not at the caucus meeting. He was not at any of the hearings.
And we produced the Senate calendar, and the Senate is not in session today. So really, their motion is arguing that our request is unreasonable. What the board needs to look at is its rules. It needs to consider if there's any bias here. We believe there's actually prejudice to the objector in this matter, and whether or not we're acting in good faith. And I would submit that, first of all, this case is not happening in a bubble, right? I mean, the bench knows this because one is a practitioner who's handled election cases, two are other election attorneys, and we're in the middle of an election season right now. So we received the subpoenas on Saturday. We had to disclose our evidence and witness as of yesterday. So that gave us 5 days to effectuate service of the subpoenas on this. Now,
Why did you not anticipate the difficulty, given Mr. Harris's time in Springfield, and pursue initially a 237 request, which under our rules could have been allowed had you done that?
well, the election bar is generally collegial, and we are very familiar with and have numerous cases against opposing counsel. And we voluntarily were producing everything. We didn't receive a request to waive subpoenas. Our people were making themselves available. We did contemplate it could possibly be hard serving him, so we hired 2 different process servers, and we had people looking for him in Harvey, Flossmoor, and Springfield. And I mean, we can produce affidavits to that effect if the board wants them. But it also, it's a party to this case who has been very vocal in trying to claim that he lives somewhere other than where he does. We fully expected him to come to court and testify.
So this has been why I filed the motion to strike and dismiss. The burden is on the objectors, okay, to come forward with some evidence. And I keep using the term malicious mischief. And when you go through the evidentiary materials, if they want me to stipulate that Mr. Harris has a lovely family, I will stipulate to it. But there are photographs upon photographs of their children. And I'm supposed to weed through that. I sent them, and this is what becomes very important here is I sent them an email. Let's talk and go through these exhibits. They didn't do it. We asked for subpoenas for their witnesses. All right. The only way you can compel appearances of people by statute is by the issuance of subpoenas. I went over the Daniel versus Daly case. That's the only way you can do it. The burden is on them. Collegiality, excuse me, no one responded to my emails about, but what I'm sitting here going is they had a time period to submit the request. They requested a subpoena. The senator has been in Springfield. In fact, I believe there are actually, because I watched one, a session where he's sitting where he sits. So I don't want to hear this nonsense about, oh, he's in Springfield, we couldn't catch him. These are expedited proceedings, extremely expedited proceedings.
And to go back to my question, isn't there a lot of duplication in your request of documents we already have on the document list from the candidate that they're providing?
They have not provided them. That's what we were requesting them pursuant to a subpoena. We did not believe there was a deadline established by the board for notices to produce. I believe the case management order we had was a deadline for the subpoena requests. But I will also point out that under the board's rules say, hey, we permit discovery, we follow the rules of civil procedure, and we will not strictly follow these rules because we know these are expedited proceedings. So I believe in this instance, we have good faith for requesting the documents that we requested here. There's been.
Can you confer with Canada and see how many of these documents overlap with what they're already providing?
Well,
I don't have a hard copy to check it off.
But the candidate isn't here to testify and be cross-examined. So they want to introduce an affidavit of the candidate
Yes.
indicating the facts that he believes are true relating to his residency without being cross-examined. And he's a party to this case. It's not a third party. The board has jurisdiction over it.
So just the whole statement and the whole argument that we follow the general rules of civil procedure and civil practice, that's true. It does say that except as modified by board rule. And the board rules explicitly talk about subpoenas. And frankly, section 10-10 of the election code gives the board one explicit power in this regard. It says you can issue subpoenas by majority vote of the board. It used to only be the chair, but they changed it to majority vote because for other reasons. But by majority vote, that's how you can compel. And then if people don't follow those subpoenas, those can be enforced in certain. That is how this board has power to compel attendance. At the initial hearing, is my understanding, if there was a video, that there was discussion about notices to produce as well as subpoenas. And I believe, Madam Chair, you said that's fine as long as they're all submitted by the deadline. So that is the key. They did not submit a notice to produce. They submitted a subpoena. They failed, and that is by its nature more adversarial and frankly has a sharper tooth to it. You can enforce that if he wasn't here. They did not serve him with the subpoena. They attempted to file an untimely and bootstrap something labeled a 237 notice because they could not and would not serve him. As the rules provide for it, the statute provides for it, and all of this other argument is just irrelevant.
Has everybody made their position and we're ready to discuss?
Well, I would just add that Rule 9 actually says that it does apply the standard traditional rules and, quote, because of the nature of these proceedings, the electoral board shall not be bound by such rules when appropriate. Now, I would disagree that there's more teeth to a subpoena because there's a consequence under the code of procedure for a party's failure to be produced pursuant to a notice to produce. And we would be prejudiced by this failure to show up in response here, and we're entitled to a negative influence both under that and under the pattern jury rules, which albeit are not necessarily disclosed here, but when you have a notice to produce and a party is not responding in conjunction with that, then there's a negative inference that may be drawn from it. There's nothing in here prohibiting us from issuing this. And we are prejudiced in his ability to be there. And if they're arguing that we were not diligent in service, notwithstanding their refusal to provide involuntarily, then we would request additional time to suspend this to reduce the rest of our case, but for leave to have additional time to serve them with the subpoena. Note though, one of the constraints that we had wasn't due to the parties, it was due to the unavailability of one of the members of the electoral board. So we kind of were under a highly compressed schedule because of that. And I know people are doing a public service when they serve on these boards and have pre-planned vacations and other conflicts, but just putting that in the record because that is, if this case spilled into the next week, we would have the opportunity to the additional days to attempt to serve this. But the fact that we didn't get the subpoenas till Saturday, and then there was a deadline for us to disclose all our evidence within 4 days, when we are also election law practitioners that have had briefs during the appellate court and the circuit court over electoral board hearings, everything else during those 4 days. It's not a lack of diligence. It's not a lack of good faith. And this is not a case of malicious mischief. It's a case of carefully designed deception. And that will become apparent as we proceed with these proceedings when you hear some of the testimony we do have available to submit. So we think that because of the prejudice to us in this instance, because of the compressed timeline, because there's been no evidence of bad faith, and because we have been acting with due diligence, that we should be allowed to have the party produced. It's not, like you said, it's not some third party witness that we don't have access to, it's a party to this litigation.
And do you have, for the record, for us to enter the proofs of attempt to service and the failure to serve?
We did attempt to have our process server today, but he was subpoenaed in a different case that he had to depose in. If we can get that though, and see if we have it here.
For the record, we filed our proofs of service of our subpoenas, which is what's required. We've not received any proofs of service or affidavits from the objectors.
Well, we couldn't file proof of service for someone who couldn't serve. That wasn't what you asked for, right? You were asking if we had evidence from our process server that we attempted service.
Yes, don't you get a paper saying the date and time?
Well,
And we filed those too when you're not able to do attempt service.
Right.
Well, we were trying through till this morning to still effectuate service, so we're checking our records.
I'm sorry, hold on one second. Ma'am,
I didn't want to interrupt.
are you a witness?
Is that your, yes, no, I'm sorry.
That is one of
But I don't know if
the
it's supposed to.
Okay, so we do have a, order, basically by the board, that any witnesses testifying in this matter will need to be sequestered. So unfortunately, you can do one of two things. You can, well, pretty much one thing. And it's basically go in that room back there, but you'll have to leave your cell phone out here because these matters are being live streamed on Facebook, YouTube, and everything else like that. So there's a concern as to, somebody hearing somebody else's testimony and then adjusting their testimony based upon that. So, well, we do have a witness room basically that we've set up back there.
There's two witnesses.
Yeah, there's already two witnesses in there.
There's a desk here where you can leave your cell phone.
Or you can give it to the attorney.
Well, the problem is, we do want the cell phone, the concern is that somebody's gonna go, like, you're gonna go on you, and, maybe not you per se, but somebody's gonna go on YouTube, somebody's gonna go on Facebook Live and view these proceedings, and again, that could impact their testimony. So I guess, the board, she doesn't appear to want to put her cell phone there, so does the board want to issue an admonishment that she cannot view Facebook or anything else related to these
I
proceedings?
think we should have the rules consistent for all of the witnesses.
I understand, I'm gonna go put it somewhere.
Okay.
That
You
you
have
have
a
ours,
safe place?
Okay, and then when you come back in, we'll have you go sit in that room. Thank you. Okay, my apologies, parties, you can continue. Thank you for letting me know that the witness was back.
The other point is they keep saying, well, we were under the gun to disclose witnesses and evidentiary, and our evidence on time. First of all, Candace was able to do that, so I don't know what the problem is for the objectors whose burden it is. But beyond that, just disclosure of witnesses, which they did, doesn't preclude them from continuing to try to effectuate service. So it's irrelevant in that regard. And the entire argument that 237, under 237, you can have an adverse inference or finding, that's for a timely issue, Rule 237 notice. The problem here is this was untimely and not done in accordance with this board's rules and procedures.
Okay, is the board ready to deliberate and rule on this request? Okay, so the parties have presented argument as it relates to the objector's request for Rule 237 to be issued to the candidate. They did send that over late Wednesday. I think the time was about 9 p.m. And we now obviously have an objection to that. That was also filed yesterday, so the board has begun some deliberations. Does the board have any other thoughts or questions?
Well, my question, and which Mr. Mullen, I think, attempted to answer, but the answer wasn't clear as to why on the 24th when we were here, you didn't specifically request 237 for a party that is that important to your case that the process of serving that instead of waiting till late in the week.
I think the real reason is we wanted to avoid the objection, and we didn't, Mr. Ladisinski raised an objection to the ability to do that at all, and we wanted to avoid that objection, and that's why we didn't do it at that time.
Does the board have any questions of me?
Do you have an opinion? Or advice?
I mean, I would say that as a general rule, in my practice, in my experience practicing before the Cook County Officers Electoral Board, as well as the Chicago Board of Elections, I have issued Rule 237s. And in some cases, they have been complied with, in some cases, they haven't been complied with. I do think a lot of it, though, has to do with the timing. And those were situations in which I didn't issue a subpoena. I issued the 237 in lieu of the subpoena. So personally, I think that, that there was a subpoena issued. If at the time they had any inkling that they were going to potentially have issues with service, they could have argued the 237 issue. And there were some arguments going back and forth on whether the board had the authority to do the 237, but no ruling on that was requested at that time of this board on the 24th. So I do have a concern that less than 48 hours before the hearing, basically about 36 hours before the hearing, to have something sent to a party to say, here, get these, 10, 15 things together. And by the way, you have to be here. I feel that after, either at the hearing on the 24th, there should have been a request, an official request, and a request for a ruling from the board as to whether it was going to issue or allow the issuance of 237s. Because it's not clear under our rules that you guys will allow 237s. It is a discretionary thing. So at that time, they should have been asking you, as the board, can you please exercise your discretion and give us the allowance to file 237s? And that was not done. So I do have a concern related to, something coming in of this nature 36 hours before the hearing. Now, I completely understand that we are under a very expedited schedule, but that's the nature of this practice. We kind of all know this coming into this. I mean, I don't think any of us has gotten a good night's sleep in 3 months, except maybe on the weekends when we don't have hearings, but then we sometimes have hearings on the weekends. But anyways, I just bring all that up to say, a lot of us are working around the clock on these cases. And while it is sometimes difficult to get everything done and, see everything, have that foresight to see what's going to happen, you got to try your best to have that foresight. I think the better course of action would have been for Objectors Council to ask for the 237 on the 24th, argue that issue, and the board could have said, yes, you can file 237, or no, you can't. You're stuck with the subpoena. The board could have made a decision one way or the other. This feels like an attempt to, we didn't get it this way, so let's try that way. And if they wanted to do both, they could have done both, but I feel like they should have made the request and asked the board to rule on that request last Friday when we were here. That's my personal opinion.
The issue for me is one of timing, and that is concern, and I understand the objector's point of suggestion of an attempt to hide the ball, which I disagree with. It's a matter of timing, and because of the timing of when the 237 was attempted to be served, that was too late. It should have been raised soon, and so I moved to grant the objection and quash the 237 rules.
Do we have a second on that motion?
I'll second.
Any further discussion, or would the board like me to call the roll?
What bothers me about it though is I'd feel better if I saw the proof that Senator Harris was trying to be served the subpoena and failed, because when I sit on the city of Chicago, like as a hearing officer, we always see the failure, the process server couldn't serve or whatever isn't done. We see that, and then we can order it again or decide where to go from there. So I have a hard time with this, because if he's not here, and of course, for me, it would have been great to look Senator Harris in the eye and ask him questions. I wish he was here. But if he's not here only because he avoided the service of the subpoena, then I don't think that's an out we should give him. But I don't see any proof of these multiple service of the subpoena and the failure to find him and where they were and what time they were and what day they were. So I have no record before me of that.
And as they said, we did intend to get a process server here today to testify about that. We just alerted us this morning. that
Deliberation.
it could be sooner.
Well, I did ask that for that.
I think when I've been involved with the hearing officer, we've always, excuse me, made the arrangements. It was always given at the end of the initial hearing, whether the candidate or the objector would be here. So there wasn't any issue, and we were on a faster schedule in some respects than what has been done here.
Yes.
You know, and so the problem for candidate is we can make assumptions also based on his not being here. You know, so it can go both ways.
True.
So in one respect, I think it's too late. That should have been arranged initially to require the candidate, whether in person or by Zoom, we now have that capability. And the fact that he's not here, there's some assumptions that could be raised as to what that means. And he's not able to answer questions, so.
Okay, is the board done with its deliberations? Would it like to?
I'd just like to clarify also that the expedited schedule is really not based on one of our members' time away from the hearings, but on the early ballots being sent out, the schedule. We're expedited because of the election. Pardon me?
That someone was unavailable on
Yeah,
that.
member Osfeld is unavailable
But we can
next
meet
week, so
just
yeah, the
two of
board can
us.
still.
We have a quorum, it's just we are, already weeks into this hearing. So for the election schedule, we need to finish.
Okay, so is the board ready to rule then?
I'd like to repeat what we're rolling on.
Okay, all right, I will read back the motion. The motion made by member Swanson was to move to grant the objection to quash the 237 request filed by Objectors Council. And that motion was seconded by you, member Osfeld. So is the board ready for me to call the roll?
Yes.
Okay. All right, Chair Raymond?
No.
So just to be clear, so you're voting no against the granting of the motion to quash
Correct.
the 237. So you would
I
issue,
would
you would allow the 237. Okay, I just wanted to make sure that it was clear because I was, based on some of the things you said, I wasn't sure. So, okay, so you're saying no. All right, and member Swanson? And member Osfeld?
Yes.
Okay, motion carries 2-1. The Rule 237 is quashed. Okay, so the next item I believe we have is I'll just let the candidates council, they had two other preliminary motions that they were presenting. Which one would you like to proceed with next, candidates council?
The motion to strike submission of all hearsay unmarked exhibits. We've tendered a hard copy to the board. It is a very short motion in answer to voluminous documents that I don't know that the board has seen them yet, but they are unmarked. There's no exhibit numbers on them. They're uncategorized. They violate the rules of evidence. They violate the rules of this electoral board. They violate the rules of decency to bring a man's children and wife into these proceedings. They are a violation of due process of law, being dumped on us, and I'm saying the word dumped in a document dump without any references to them at all. Our staff was up very late running them out, those that we could run out, some we couldn't run out, and categorizing them in some fashion. But I have to tell you, it is the biggest document dump that's unmarked, uncategorized, and should not be let in, as well as hearsay. They're meaningless. We'll be here for-
I understand your point. What specific exhibits are you complaining about? I know there are some that are, none of them is marked.
None are marked.
I understand that. There are some, if a witness is here, they can lay a foundation for, and they would be could be appropriately admitted.
Yes, sir.
There are others, like some of the videos, I have serious reservations about some of the others. So which specific ones are you objecting to?
It's hard to say which ones because none of them are marked. We were having that problem, and it certainly all the videos of Senator Harris's children and wife, and the pictures that are just pictures. If they have witnesses who can witnesses that can identify, that's a different story. They can show them. As you know, Judge, they can show them the document, mark the document, and get it into evidence. And how about the newspaper articles and the sports clips? And really, I mean, even though this is an electoral board and an administrative agency, we still have to deal in some semblance of the law and some semblance of order. We have to be able to defend our candidate. I mean, he has rights too, not just the objector. The candidate has rights also. So it is, I don't ever remember having to file something like this because I've never seen a document dump that we can't identify.
Objectors respond?
Sure. I have never marked in 20 years of litigating until I get the witness on the stand what my exhibits are going to be. Mark number one so far. It depends on who the witnesses are, what order they are in, who shows up. There's no reason, no requirement that we number the exhibits, and there is not a huge number of them. With respect to the photographs, those are all, they come from Napoleon Harris's Instagram page, which is his Senate Instagram page, where he has about 4,000 Instagram followers, and these are all public pictures that he has posted on his Instagram page, or his wife has posted on her Instagram page, where she has 1,500 followers. So all of these documents are in the public domain. They're all documents that show Mr. Harris or most of them show Mr. Harris at the house in Flossmoor that he says he doesn't live at. So now, I understand they may have questions about authentication, hearsay, and we'll get into that when we, pull the witnesses and try to introduce them. But to say outright that they're objectionable is premature.
They've alleged we violated, quote, rules of evidence and the board's own rules, but there's nothing in the rules of evidence that require us to disclose evidence itemized and labeled and categorized in exhibits. Neither do the board's rules do that. The purpose of, excuse me, us having to give the evidence ahead of time is to put them on notice of what documents that we have. We don't, and what we're planning to introduce, not to set forth in chronological order the evidence and what it means and what the significance is and everything like that. So yes, we've given them a lot of documents because we have a lot of evidence.
I am ready to rule, but in all fairness to Mr. Olson, as he's the movement, I'll give him a brief time to reply.
I'll stand in my comments, Judge. I think I made my points. We have a right to defend ourselves and have some knowledge of. I don't have any knowledge of TikTok, Instagram, and very limited Facebook, to be quite frank with you. So I'd like an identification of what the heck I'm looking at so I can defend my client. That's really.
I understand your point. I make a motion that the motion to have strike this evidence at this time be denied with with that in mind, it does not mean that any of it will be ultimately admissible.
Second. Okay, so we have a motion by member Swanson to deny the motion to strike, find the exact title of the motion. To deny the motion to strike the submission of all hearsay unmarked documents, and that motion was seconded by Chair Raymond. Is the board ready for me to call the roll?
Just, for discussion purposes, if we granted this motion, I wouldn't know which documents or pictures or videos were stricken. So I can't grant it, but I agree from the preview I saw that there are, pictures we wouldn't allow because we already discussed the date range, which some of those pictures seem totally inapplicable to, and the children would not be involved in this hearing. So when we go through one by one, I'm sure many of Attorney Ogilson's exhibits that he wants stricken will be stricken, but to just blank, to blanket say yes, I don't know what would be stricken.
And if I may respond very briefly to that, the candidate has submitted an affidavit or proffered an affidavit that says he has lived at that address.
I
since
haven't
2014.
seen any such affidavit, so
Okay.
I don't want to discuss that at this time, but such time as I see it.
I've seen it, but I don't think it's introduced in the record yet.
Yeah, and I would actually, caution the board, you guys are in deliberations. If we want to expedite things, we've got to stop. No offense to both councils, and I'm telling both councils, but we've got to stop, unless the board is asking a question of the councils, I think that, we need to keep these things moving along.
We're ready to
I'm ready to vote.
Okay,
I just want to clarify, because we're talking about allowing it all in subject to kicking them out. So in other words, if they start presenting something that we deem clearly hearsay, we're not accepting it.
It'll be subject to the rulings of the board as to whether the document itself is admissible, whether the proper foundation has been established, and whether it's admissible under the rules of evidence generally and under this board's own rules.
Denying this motion, that does not admit any of them into evidence for ultimate consideration.
Correct.
That comes on a case-by-case basis.
Correct.
I'm ready to vote.
I'm ready to vote.
Okay, Chair Raymond,
Yes.
Member Swanson,
Yes.
Member Osfeld.
Yes.
Motion carries. The motion to quash, or to strike submission of all hearsay unmarked exhibits is denied. The next item we have from the candidates council is a motion to quash subpoenas served by the objectors.
Yes, thank you. Again, Ross, second on behalf of the candidate, I'll be very brief. This would only come into play if the objectors try to enforce these unserved subpoenas. At least as of the filing of this, we gave examples of their attempted what service meant on some of these witnesses apparently, and that is not proper service under the rules, and therefore, really, it's just if they were to try to seek enforcement, judicial enforcement by this board of these subpoenas that haven't been served, we could just request that.
So do you want to enter and continue this?
Your motion is at this point premature. We'll deal with it on a case-by-case basis.
We're thinking the same thing, Member Swanson.
Thank you.
The last matter I have relates to the relevant time period. And so there's been a lot of dates, and this board allowed their subpoenas to go back to November 1 of 2023. It's a 1-year durational under 60 ILCS 1/55-5, and pursuant to the case of Schuman versus Fleming 261 Ill App 3rd 1062. It's 1 year from the date that the candidate signed his statement of candidacy. And the statement of candidacy is going to control that time period.
What date range are you saying we should be?
It would be from it should be in the record, his nomination papers should be in the record, the statement of candidacy. The caucus that occurred happened in December. So it ranged sometime from December of 2024 to December of 2024.
Yeah.
We had, as I recall, we had extensive discussion as to the time frame. The time frame that was entered into was discussed and was agreed upon by all council. So this is not the time to bring that up. It was already thoroughly decided and agreed upon.
That was
So
with
then-
regard to subpoenas to get documents.
I think what Mr. Ladizinski is arguing is when the 1 year time frame begins and when it ends. So I do note for the record that Mr. Napoleon Harris did sign his statement of candidacy on 12/5/24. And I can also state that as a practicing attorney in municipal township and other areas of public law that deal with residency requirements and deal with eligibility requirements, it's always been my opinion that it is, generally the 1 year from the date of signature, but you really got to look at actually the 1 year from the date that they take office. Because, there's been some arguments from prior cases about, that the clock starts ticking backwards from the 1 year of the date of the election. But I've always honestly looked at it as 1 year from the date that they take office, because that's when you actually become, you actually enter into that position.
So the time frame would be considered when they take office would be when the first Monday or early in May.
It's actually under the statute, it's the third Monday.
Third Monday in May.
Yeah, so that would be May 19th.
So what you're suggesting then is any testimony to be relevant has got to deal with the time frame of May 19th, 2023 or 2024.
To 2020, yeah, correct,
To May
2024.
19th of 2025. That's the only relevant time period.
That's how I view the law. That's my,
But what range did we originally give them?
we had given them from 11/1/23 to basically the present. And I think that was, just to allow them to capture everything that they thought that they could capture without going back too far. It wasn't to the present. It was like 12. Hold on, I have it here. Just give me a moment. We definitely did. You are correct. But it was close to the present. It was sometime, I think it was till 12/5 actually. Because I think it corresponded with the date of the submission and signature of the nomination petitions.
I thought it was about a week later in December.
December 16th. Okay.
Yeah.
So,
Thank you, Hannah.
3 years, November 1st, 23 to 12/16/24.
Yes, but that was just solely for the subpoenas. That was not for what the residency time frame is. But I think that both parties should be allowed to argue what they believe when the residency starts. But I was just addressing the arguments made by Mr. Lexi. But both parties, can certainly make their arguments and may disagree with my assessment on when residency.
Briefly, Council,
Begins.
you're looking like you wanted to say something.
Well, the statement of candidacy is a sworn statement that he's qualified to hold office as of that date. As of that date, he would have had to satisfy the 1 year residency requirement, not some future date in the future. And some of the information from that window might be, even documents they've produced to us predate that
And I
time.
think that's why Mr. Ladizinski, and I'm making an assumption here, mentioned the statement of candidacy date, which is December 5.
Right,
So
and I
then
believe the
for
case that he
purposes-
cited is.
For purposes of residency, then, I will make the motion that the applicable time period for evidence to be submitted is December 5, 2023 through December 5, 2024.
But you're saying something different.
That's my opinion, my read on the law. You guys are the board, you guys make your decision. I've always, I understand the argument, and it's a SINCUS-based argument that basically says that when you sign and file your statement of candidacy, you're saying you will be eligible, or that you are eligible at that time. But I know that there's been some recent cases. In fact, I want to say it was like 2 years ago, I believe, there was a case. It was heard in the circuit court. I don't recall. I might have a copy of the ruling somewhere. I'd have to try and track it down. But it was heard in the circuit court and involved a woman named Jocelyn Keene in the village of Dalton. There was a residency objection filed against her. And in that case, one of the things that was at issue was when was she required to become a resident? And if I recall correctly, at oral arguments, the judge, and I want to say it might have been word Kirby, but again, I have to relook at my notes. The judge had essentially said that it was her opinion that residency ran from, I believe it was either the date of the election or the date that they took office, but that residency didn't per se run from the date that you signed your state candidacy. But I would say that that's an argument for the parties to make. So I think we ruled on what you believe the relevant dates are. So I think the parties need to make their arguments as to what they believe the case law shows as to when residency is.
I think they've just done that. So let's vote.
Okay,
Oh, is there a second for the motion?
yes, I was just gonna ask,
So
do we have a second on the motion?
What is the motion?
The motion was made by member Swanson to limit the relevant dates for evidence related to residency from 12/5/23 to 12/5/24. Is that a fair statement of your motion, member Swanson?
Yes.
And which council agree with that and which disagree?
We agree with that.
Mr. Ladazinski mentioned that time frame in his presentation.
So everybody's in agreement? Okay.
Okay, so we've got a motion. Do we have a second?
I'll second.
Okay, we're ready for me to call the roll.
Yes.
Okay, Chair Raymond,
Yes.
member Swanson,
Yes.
member Osfeld.
Yes.
Motion carries 3-0. Okay, so I think we've dealt with all the preliminary matters. Are
Can
there any
we-
other preliminary
Yes,
matters?
can we please request that one of our witnesses be released, because he was merely here on the subpoena issue, if there was an issue about how the subpoenas were served. So
Okay.
if there's not an issue, if that's deferred, on 20 minutes notice, I can get him back, but instead of leaving him there without his phone, I'd like to release Mr. Summers.
What was he, I guess, what were you intending to call him to testify?
They were saying that subpoenas were delivered without checks, and he has knowledge about that, so
Is that an issue that he's gonna be called for?
if necessary, yes.
Well, if he's potentially gonna be called, he's to stay sequestered. If you're saying that's not an issue where his testimony is not gonna be required by either party, as far as I'm concerned, he can go. So that's the question, goes to you all, counsel.
They just, what was the result of their motion? It seemed like they were not, it was deferred, so we're just continuing him indefinitely in case they bring it back.
Can you explain again what issue he addressed this?
Exactly, what is the precise issue?
They filed a motion saying that people were served with subpoenas that did not have checks with them. He delivered checks to them, so he has knowledge of having the check. So if they're going to make an issue of that, then he's here to counter that particular issue. Yeah, it has nothing to do with the merits of the case or anything that would be streaming on the video. That's why I don't think he would, even if he went and listened to everybody's testimony about the Napoleon Harris residence, it's not going to impact his testimony that he was served with checks or subpoenas.
Which of your motions raised that?
The very last one.
Name it.
The motion to quash the subpoenas.
Oh.
Somehow it seems that if this is going to be an issue, let's just have him get sworn, testify that he gave check to everybody and move it on.
I kind of was thinking the same thing. We would testify for what, all about 5 minutes?
It depends which, I don't know which subpoenas they're arguing about. So it depends.
The ones where people weren't given a check until yesterday, after the subpoena was delivered, or this morning. They went back and covered their tracks and started giving checks out after they delivered the subpoenas a couple days ago.
So is that a moot issue that's dropped?
No. Subpoenas were delivered to some.
How many
without checks.
subpoenas? How many subpoenas are we talking about?
We have no idea. We don't know. We
How
know
many
that
subpoenas? 2? Why don't you just call him to testify to the 2 subpoenas? And let's just get him out.
Break him out. Break him out.
Can you raise your right hand and be sworn by the court reporter?
Do you swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth?
I do.
Will you please state your name?
Richard Seppet, S-E-P-U-T.
Directing your attention to this morning prior to 11:30, did you have occasion to visit the home of Nina Graham at 17333 Wausau Court in South Holland, Illinois?
I did.
At that time, did you deliver a money order in the amount of $25?
Objection leading.
What, if anything, happened at that time when you went to that residence? How was that question?
I went to that address, I knocked on the door, an elderly lady came to the door, I asked her, if she was Nina, and she said no, that she was the mother, and I said, well, can you please give this check to her, and she said, I'll call her, let her know you dropped it off.
And then, did you drop off the money order?
I did,
What was the amount?
$25.
Also, this morning prior to 11:30, did you have the occasion to visit the home of Carl Washington at 14638 Gibbons in Harvey?
I did.
What happened when you arrived at that location?
I arrived at that location, I knocked on the door, and then I rang the doorbell. Nobody answered, and there was a basket on the door, and I did see the court order in that basket.
When you say court order, what was it, the subpoena or
The
what was it?
subpoena. It was in a basket hanging on the door.
And what did you do at that time?
I left at that time because nobody answered the door. Then I talked to you and you said go back there and take a picture of the subpoena and the check.
Did you deliver the check to that location?
I did.
The money order, what was the amount of that?
$25.
Did you take a picture of it?
I did.
Do you have that?
I do. My phone's
Permission for witness to go through his phone?
So granted. There's only one here.
That's me. Thank you.
Can you please forward the picture to this one? Can you show that opposing counsel, please?
And to the board.
Can you please identify what that picture is?
The picture is the subpoena and the check that I was dropping off.
And that was at the,
Gibbons Court.
was 14638 Gibbons Court?
Yes, ma'am.
And does that picture accurately reflect how it looked at the time you took the picture?
Yes.
I have no further questions of this witness.
Sir, with regard to the check, let's start with Mr. Washington. When did you serve the subpoena?
May I look at my phone? I can tell you.
Do you recall when you served the subpoena?
It was about 10:30-ish
What day?
today.
Okay, so you
Not the
served,
subpoena, sir. I only dropped off the check.
okay, so you never served a subpoena on Mr. Washington, correct?
No, yes, that's correct.
And with regard to the check, you brought a check to an address on Gibbons for Mr. Washington, correct?
Correct.
And you didn't serve the check on anyone, you put it in a basket, correct?
Correct.
And with regard to Nina Graham, did you serve Nina Graham with a subpoena this morning?
I did.
And
Sorry.
you just,
I did not hear the answer.
I did not.
I did not. Okay.
and so we're clear here, when you went to Ms. Graham's home, you spoke to a mother and handed her a check,
Yes, sir.
and that's all you did, correct?
Yes, sir.
I have nothing further.
I have nothing further. I would request the ability to get having the photo off the phone printed up and submit that as an evidence.
Any objection?
I have no objection. Is it going to be marked?
I was just gonna ask the exact same thing. Objectors, are you guys marking that exhibit? Objectors exhibit 1, objectors exhibit A, how are you?
Sure. We'll do it, petition, plaintiff's exhibit 1.
Can you send me that? I will have it arranged there and probably put it up with that. No, and no further questions.
Okay, does the board have any questions of the witness?
No.
All right, no plans to recall him?
Not at this.
Okay, all right, you're excused.
Thank you.
You can keep your cell phone. Okay, so the board just heard some testimony as it relates to the subpoena issue. But that issue I think is somewhat of a deferred issue. So I think that the board can just take that testimony in, and now we can move forward with the objector continuing on to present that case in chief, unless the board disagrees.
No, I agree. I agree.
All right, objectors counsel, you may proceed.
We'll call, Christopher Clark.
You got him there.
And real quick before we, are you able to hear everything? Or do you need, okay,
As long as they don't drop their voice, because I can't see their lips.
Right.
okay. Would it be more comfortable if we move the chair like kind of right next to you? Okay, Mr. Clark, would you mind? Yeah. Oh, you could possibly change that. Does that microphone work? Actually, maybe you can just run and turn your chair and
We will need it.
just told you.
I mean, yeah, I'm pretty sure everybody in the room can hear. Let me put the chair back here.
Did I understand you intend to Clark in your case?
Yes.
Just want to make sure the court reporter can hear everything and everything's accurate.
For the witnesses' time, everything, waive scope.
I have no problem with this.
Mr. Mello? Waive scope with this witness?
Sure.
Okay.
Have you sworn in? I didn't.
Not yet.
Go right ahead, please.
Raise your right hand. Do you swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth?
Yes, I do.
Okay, would you state your name for the record, please?
Christopher J. Clark.
And the court reporter just swore you in, and even though this is a more informal setting than a courtroom, you're under the same obligation and penalty of perjury to tell the truth. Do you understand that?
Of course.
Okay. And where do you reside?
My address or
What city do you live in?
Harvey, Illinois.
And are you an elected official in Harvey?
Yes, I am.
And what is your title?
I'm the mayor of the city of Harvey.
And how long have you been the mayor of the city of Harvey?
I think 5 years now. I think I'm maybe in my 6th year.
Okay. And how long over the course of your life have you lived in the city of Harvey? Village of Harvey?
My entire city, it's a city.
City.
And my entire life, 55 years.
And prior to being mayor, what type of work did you do?
I'm an attorney by trade.
Okay. And do you have experience in any particular areas of law or?
It's general, but most of my cases range from business, family, and some municipal.
Okay. And so, other than practicing law, were you a real estate agent also?
Yes,
And when was that?
that was between, I think it was 2004 and 2006, I believe that it was.
Okay, and where did you do that work?
Bearden Warner in Portland Park.
Okay. And did you become familiar with the various, what municipalities did you become familiar with the real estate in?
Objection relevant.
Yeah, Madam Chair, we have an objection for relevance. You can either ask the board for ruling yourself. You can ask the objectors counsel, what is the relevance of the question? To do with objection for relevance.
What is the relevance?
We're going to talk about the difference between Flossmoor and Harvey and just establishing some background for that.
I mean, I think the board can take judicial notice that they're two different municipalities. I mean, I don't understand what that.
What's different? What? Well, not that they're two different municipalities, but that they have different characteristics.
What characteristics of them?
What does that have
we're talking about right now an incumbent senator who lives in Flossmoor, who is purporting that he either lives or wants to live in the city of Harvey. And we believe that once Mayor Clark describes the similarities between the communities, that raises a plausible inference that perhaps that isn't accurate. So we think we would like to have on the record evidence regarding both of the natures of both the communities and subdivisions.
I'll make a motion to overrule the objection.
Second.
All in favor?
Aye.
Any opposed? Motion carries. Okay, you may continue with the question.
Would you repeat the question for me, please?
Can you read that back, please?
And did you become familiar with the various, what types of real estate, sorry, did you become familiar with real estate? Excuse me. What municipalities did you become familiar with real estate in?
No problem. Primarily, of course, Portland Park, because that's where I was. Also, Olympia Fields, University Park, Flossmoor, Homewood, and Harvey.
Okay, great. So do you know Napoleon Harris?
Yes.
And when did you first get introduced to Napoleon Harris?
Somewhere between, I want to say, 2012, 13, somewhere in that range.
And how were you introduced to Napoleon Harris?
I first met him at Coleman's Printing. That's where we first met. Printer on 147, but I forget exactly where. I think it was in Dalton or something.
Okay. At some time, did you come to learn that Mr. Harris was running for elected office?
Yes.
And when did you learn that?
Around that same time. It was after we first met.
Okay. And when, what office did you understand him to be running for?
Senate.
And do you remember the district that he was running in?
The 15th district.
I'm going to show you what we marked as exhibit 2.
I have an objection to this exhibit. This is from 2012. And the time frame we've discussed, and this is why we had to disclose Michael Dorff, because we knew they were going to go down this path of what occurs with redistricting when there's the decennial census.
Well, first, we have a statement of what, we have a statement of what this document is. I mean, I don't have a copy. And I did, for the record, I did ask that the parties not only bring copies to the board, but as well as us, just because of the pure volume of documents that were requested. Or submitted. So for the record, I do show that these are, they appear to be nomination petitions from 2011.
What's the relevance?
The relevance is that Mr. Clark helped notarize these, and it was how he first learned about where Napoleon Harris was living at that time. So what? Well, it's relevant with respect to the affidavit that I understand you have not seen, but it is to counter and attack the credibility of that affidavit.
Does the affidavit refer to 2011?
It refers to him living in Flossmoor until 2014. And so in 2012, he's swearing under oath that he lived in Harvey, when in the affidavit that he submitted.
No characterization, it's not true.
The document says Flossmoor.
Yeah, look at the document.
So the petitions are in conformance with the affidavit that's not before us? Is that correct? I move we sustain the objection.
Okay, so we have a motion to sustain the objection as it relates to the document that purports to be plaintiff's exhibit 2, And as stated earlier, these are the nomination papers from 2011, from December of 2011.
Can
Do
you
we have a second on that?
restate the objection?
Well, the objection was to relevance, correct?
I'll second.
One question that I'm unclear on. The second page, statement of candidacy, shows references living on Dunfrey Street in Flossmoor. At that time, which was
2011.
December 3rd of 2011. The motion is to sustain the objection. Thank you. I'm ready to vote.
Okay, I will call the roll. We have Chair Raymond,
Yes.
Member Swanson,
Yes.
Member Osfeld.
Yes.
Okay, so plaintiff's exhibit 2 is not admitted. I'm sorry, I'm sorry, the objection is to the relevancy.
Objection was to the question, correct?
Yes.
I thought the objection was to the document.
No, it's
I
to the
didn't
question.
lose it.
Okay, I apologize. The objection was to the question, so that has been sustained, so can we keep going forward?
Okay, so you testified you were currently the mayor in the city of Harvey, is that correct?
Yes.
And can you describe for the board what the city of Harvey is like to live in?
Objection, relevance.
And, I mean, we discussed this before. I mean,
I would sustain the objection as to relevance and form of the question. I'd sustain it as a form of the question for right now. So,
Second?
ask a better question.
Okay, all in favor?
Aye.
Aye.
Okay, rephrase the question,
Can we
please.
Sure.
fix your area in Flossmoor in the townhome in Harvey? Is that what you're trying to establish?
that's part of it, as well as, you know, the difference between living in, you know, a country club development and living in a, you know, in Harvey, in this neighborhood.
Are we-
Some proper subject for judicial.
No, no, you're the judge. Okay.
Okay.
All right, but you can shorten this if you could, because I think
Okay,
we
I
all know
understand,
this.
I understand. So can you describe the crime rate in Harvey for the past?
Objection.
Move to sustain the objection.
Second?
All in favor?
Aye.
So the documents that about this objection indicate that you were the person that personally filed that objection. Is that correct?
Yes.
Okay. And you are also a candidate for the office of Thornton Township Supervisor, correct?
That is correct.
So you would, you know, obviously benefit from this objection being sustained, correct?
It depends on your perspective.
And what is your perspective?
I'm here to help.
So prior to filing the objection, did you review the objection?
Yes.
Okay, and why did you assist in filing this objection?
Because from everything that I knew of, it was true.
Okay, and when you say it was true, what are you basing that on?
My knowledge of Senator Harris over the years, my knowledge of where he lives, at least from my perspective, my knowledge of the alleged home in Harvey, Illinois, my review of what I had seen on several occasions things in his, you call it, Illinois State Board of Election filings and things of that nature. Driving through Entree and around that area, on occasions, not regularly, but on occasions, and having seen, either him or his vehicle, in the area, where the house is located. A variety of things have given me, have led me to that conclusion.
Okay, is there anything else that you didn't mention? You said a variety of things. I just want to make sure we get everything that you can think of on the record.
Well, going by knowing that he doesn't live at the Harvey House. I've been by the Harvey House on several occasions. Over the past 5 years. It's my usual routine to ride in and around the city, to take note of what's going on in the city. Homes that are there, homes that are living, homes that are abandoned, homes that are dilapidated, homes that need repair, streets that need repair, making those observations. So I would say probably I've been by that home more than the home in Boston. At least 50 to 75 times.
Okay, and have you ever observed Mr. Harris at the Givens address any of those 50 to 70 times that you've gone by? Do you know Jerlene Harris?
Yes.
And how do you know her?
Well, she's a Harvey resident.
Okay, and do you have any type of relation? I mean, do you have a work relationship with her, or how do you know her?
Well, I don't have a work relationship with her, but I've known her like many other people throughout the city for quite some time.
Okay, and you understand that she's one of the objectors in this case?
Yes.
Okay, and did you have any conversations with Ms. Harris prior to this objection being filed?
Yes.
And what information did you relay to Ms. Harris regarding this objection?
Objection hearsay.
What he said to somebody is not hearsay.
Do we have a second?
Second.
All in favor?
Aye.
Aye.
Motion carries. Objection overruled. The answer.
I shared with her the same information that I've just shared with this tribunal.
Okay. And you mentioned that you follow Napoleon Harris on social media. Is that correct?
No.
Oh,
I did not say I followed him. I said I have viewed.
And what have you viewed?
Posts that have been made on his Facebook page. Posts that when they link or share to his spouse's Facebook page. That's what I'm talking about. The following is a little bit different than just that's why I made the correction.
And so you are familiar with the how the house at 14633 Givens looks?
Yes.
And are you familiar with, does it have a fireplace, you know?
Objection. There's no foundation if he's been in the house.
Second.
All in favor?
Aye. Aye.
Objection sustained.
Have you observed the chimney on the house?
Yes.
Okay. And so we were talking about your review, your viewing of Mr. Harris's social media. Have you ever seen a photograph of Mr. Harris at the 14633 Givens address in Harvey on his social media? Have you ever seen photos of the Flossmoor residence on his social media?
Yes.
I have no further questions.
I understand council agreed to waive scope, so this can be considered not just cross-examination, but direct examination for the candidate's case.
That is correct. I'm assuming that Mr. Clark will not be recalled if we waive scope.
That's correct. Mr. Clark, so, Mayor Clark, so I'm clear here, and everyone else is clear. You are seeking the office of Township Supervisor in the April 1, 2025 election, correct?
That's correct.
And your opponent is Napoleon Harris, correct?
I have several opponents, but he is one of them.
And you are here testifying, as you said, I want to help out, right? You're here to help, right?
That was in reference to being the supervisor of the township.
But you're here to help out and offer testimony in an effort to have Mr. Harris knocked off the ballot, correct?
Sir.
Is that correct, sir?
No.
You're here to provide testimony on behalf of an objection that you prepared or were involved in preparing, correct?
No.
Well, with regard to the lawyers that are representing you, is it not true that Carrie Lynn Carefrafter represents the city of Harvey?
The lawyers aren't representing me.
Does Carrie Lynn Carefrafter represent the city of Harvey? Does Carrie Lynn represent you?
No.
Does she represent the city of Harvey?
Yes.
And who is paying the lawyers on behalf of the objectors?
I'm not.
Do you know who is paying them?
No.
With regard to Jerlene Harris, you went to go tell her information, correct?
I don't recall.
Well, you just testified that you went to go tell her about what you knew, right?
Not from my recollection. no.
Characterizes his testimony.
With regard to your testimony, what did you tell Jerlene Harris?
I told her about Senator Harris living in the Thornton Township, living in Rossville, not living in Harvey, and as I testified previously.
And with regard to Ms. Harris, did you ask her, hey, I need you to be an objector?
Yes.
And did you do the same thing to Michael Smith?
No.
And with regard to Jerlene Harris, do you know what she did to investigate any allegation in the objection?
No.
Now, sir, the last time you were selling real estate was in 2006, correct?
Yes.
And with regard to your investigation as to Senator Harris, did you look at his voter registration?
No.
Do you know where he's registered to vote?
Yes.
And where's he registered to vote?
In Harvey, Illinois.
And did you look at any information as to his driver's license? Did you look at any records related to his contact with Harvey, Illinois?
Not sure what you mean by that.
Well, does Senator Harris have contact with the city of Harvey?
I'm still not sure what you mean by that.
Does he own a business in the city of Harvey?
Yes, from my understanding,
Okay, and what's that business?
Beggar's Pizza
And where's that Beggar's Pizza now?
in Harvey.
And in relation to the property, the Gibbons property, how far is the Beggar's Pizza to the townhome on Gibbons?
Less than a half a block from the rear of the building.
Now, sir, you testified that based on your information, you do not believe that Senator Harris lives at 14633 Gibbons Court, correct? I'm going to show you what's been marked as Kansas Exhibit number 12. Providing objectors counsel the copy for the board and for its counsel. And witness. So if you could turn to page 2 of Kansas Exhibit number 12.
Yes.
You recognize yourself in the photograph on that page.
Yes, I do.
And this is an official mailing to the city of Harvey, right?
No.
Well, it says city of Harvey. Does it not?
City of Harvey did not mail it.
Oh, who mailed it?
Although from
But the city of Harvey authorized it, right?
He provides the address.
The city of Harvey authorizes mailing, correct? And you have them mail this to all residents in the city of Harvey, correct?
Actually, I don't, but you want to assume that it's correct. Yeah.
Well, you're the mayor of the city of Harvey, correct?
Yes.
And you make sure you want to communicate with your residents and voters in the city of Harvey, right? And you had a mailer sent to Napoleon Harris at 14633 Gibbons Court, Harvey, Illinois, correct?
No.
Well, this is a mailing from the city of Harvey, correct?
Yes.
And Napoleon Harris's name is on it, correct?
Yes.
Now, sir, you've never been inside the Harvey Town Hall, correct?
No.
And you've never been in the Flossmoor Hall, correct?
No.
Now, in addition to your employment, you're the mayor of the city of Harvey, correct?
Yes.
And you're a lawyer, correct?
Yes.
And you're also a Freedom of Information Officer for Calumet City, correct?
That is correct.
And with regard to that position, is Carrie Lynn the attorney for the city of Calumet City? Five.
Me?
I move it the other way.
We have a second.
Second.
All in favor?
Aye.
The objection overruled, please proceed.
May I ask this question?
I don't know.
You don't know if Carrie Lynn is the attorney for the city of Calumet City?
I'm just a FOIA officer.
Did you ever FOIA who the attorneys were for the city of Calumet City?
No, I'm not that I recall.
With regard to your knowledge is based on looking at some social media pages, correct?
Some of it, yes.
And with regard to any other investigation, did you do any other investigation related to Senator Harris's residency during the period of December 5, 2023 to December 5, 2024?
Repeat that, those dates again?
December 5, 2023 to December 5, 2024.
Yes.
And what was your investigation?
That is, his reporting of the Illinois State Board of Election. Actually, quite a few times on that. Went by the house again, meaning the Flossmoor house. And like I said, I've been by the, what do you call it, Harvey house on several occasions.
And with regard to the 50 to 75 times you've been by, do you keep note of the dates and times you've been by?
Not all of them, no.
Okay. And with regard to going by 1463 in the Harvey, I would just call it the Harvey residence. When you went by the Harvey residence, did you ever knock on the door?
Actually, one time I did.
And was he home?
No.
And other than that, one time, when was that?
When was what?
You knocked on his door.
I don't recall it exactly.
Did you take photographs?
Yes.
You took photographs of what?
I took photographs actually of the two vehicles that were in front that were covered with tarp.
So there are two vehicles in front of the property at 1463.
That were covered with tarps, yes.
Oh, with regard to I'm going to show you what is actually objectors exhibit. going to show you objectors 15. I do not have additional copies of their exhibits. I apologize. I did not know what this was regarding to testify to that.
Hey guys, sorry, but I gotta cut my stream. I gotta be at work in
For the record, it's marked as objectors.
Tune in
Exhibit
to
15.
Reality Check TV. He's here broadcasting live. So go over to his channel and continue. I hate to leave you guys on this cliffhanger.
Hold on, I missed what he said. He said someone else is broadcasting live. He's about to jump off. Who did he say is broadcasting live?
I'm going to show you objectors.
Lady that Jedediah is about to talk about.
Additional copies of their exhibits. I apologize. I did not know what this was regarding to testify to that.
Hey guys, sorry, but I gotta cut my stream. I gotta be at work in
For the record, it's marked as objectors.
Tune in
Exhibit
to
15.
Reality Check TV. He's here broadcasting live.
Who?
Go over to his channel and continue. I hate to leave you guys.
I'm going to show you objectors 15. I do not have additional copies of their exhibits. I apologize. I did not know what this
Can someone tell me who else is screaming?
I gotta cut my stream. I gotta be at work in
For the record, it's marked as objectors.
Tune in
Exhibit
to
15.
Reality Check TV. He's here broadcasting live. So go over to his channel and continue. I hate to leave you guys on this cliffhanger.
All of it.
Y'all, we're about to switch streams real quick. We're going to Reality Check TV because Critical Smoker said he's about to get out of there. Thank you guys for your understanding. We switched over. And thank you guys for the information. I'm still a little under the weather. Thank you for being here with me. I'm still keeping up on notes so we can rehash this.
4 originals? I believe it's on.
Yeah, I've got a couple of them.
Did you give us 2 of this? You have 2?
You need another.
No. I have four.
Just four
I
sheets
have,
of paper.
I have two of the same. so this thing is so much.
I have four. I have,
I apologize.
I have a property tax info, at night, lights on, front of the house, and then the garage.
And I got three.
Yeah, they have the same. They're missing the same.
Yeah, so there are four pages. You agree with the same.
I agree with the second.
So there should be four photos overall. We agreed to mix them with two copies of the last 50 photos with the same, so 4 photos overall, so yes.
We have four.
We have 4, so we're split.
Mayor Clark, I'm showing you 4 photographs that are part of objective exhibit number 15. With regard to those photographs, do any of those photographs portray a chimney on the Flossmoor property?
Yes.
And where's the chimney? Well, that's not a chimney, is it?
Well, it is to me.
That's a pipe, a vent pipe coming out of a roof.
Objection, you're testifying. You just said it was.
I'm at the 15705 page, sir. This is what we have. These are chimneys and we're out there.
With regard to a chimney, so when you testified before, a fireplace chimney, that's what your testimony was, that there was a chimney to be saw. You're referring to a sheet metal pipe appearing in one of the photographs of exhibit number 15, objective 15, that comes from the roof line, correct?
Chimney.
Now,
Objection to that question. He was not asked about a chimney at the Flossmoor residence. He was asked about a chimney at the Harvey house.
That's right.
is there a chimney at the Harvey house?
Like, yes.
Or what type of chimney is it?
Like that chimney, what you call the pipe, I guess.
It's in your job in real estate,
Yes.
okay, and how long were you a real estate agent?
About two, 3, somewhere
Okay,
between.
2-3 years, and the last time you did that was in 2006, correct? Did you ever do any real estate transactions?
Yes.
Okay, and with regard to real estate transactions, is it your testimony that the pipe that you're describing as a chimney is a chimney?
Yes, exactly.
And so with regard to the Harvey residence, you've already testified you've never been there, correct?
Correct.
And you've never been on the Flossmoor property, correct?
I already answered that, but yes.
The drive-bys that you took, did you ever take photographs of Napoleon Harris at the Flossmoor property?
No.
Have you seen Napoleon Harris at the Beggar's Pizza in Harvey?
Yes.
And he works there, correct?
He was working at the time that I saw him.
And how many times have you been to the Beggar's Pizza in Harvey?
That's too numerous to count.
And how many times have you seen Senator Harris there?
Twice.
There's no dispute that he owns that restaurant, correct?
Well,
Objection is to all.
We have a objection as to relevance as to whether Napoleon Harris owns the Beggar's Pizza in Harvey. How does the board know?
I don't see any relevance.
With regard to the Flossmoor residence, or sorry, the Flossmoor property, your testimony is that you drove by a couple times, correct?
yes.
And how many times did you drive by?
The line train, maybe now between 10 and 15 times
And what time period was that?
during the day.
And what time period over
years, months?
Oh, that was over years.
Any time during the time period of December 5, 2023 through December 5 of 2024?
No, I don't believe so. No.
I'm not being certain.
Any questions on redirect?
Yes, with respect to candidates exhibit 12, that has an address for Mr. Harris on it. Did you do anything to ensure that the people who received this mailer were residents of the city of Harvey?
No.
Do you happen to know what car Senator Harris drives?
I've seen the, it's kind of black.
Okay, and is there any particular license plate that you recall seeing on the car?
The state license plate, I forget the name of it, but it's a black SUV.
Okay. And in the times that you have gone by the Givens address in Harvey, have you seen that car parked there? I have no other questions.
Mr. Harris, the Harvey residence has a garage, right?
Mr. Clark.
Mr. Clark. The Harvey residence has a garage, correct?
Yes.
I know.
Council, you're moving the addition of this exhibit 12. I will be moving, yes, to the second page.
Any objection?
Can you say that, what is the second page?
Well, he's got 12, you've got, that's 15.
Oh.
Motion by the board to accept. Exhibit 12.
Second.
All in favor?
Aye.
Motion carries. Exhibit 12 is admitted. Objectors, I'm sorry, candidates exhibit 12. Any further questions for this witness? None? Any questions by the board for the witness?
I have a question now, because you say you often drive by Harvey, the property, and you don't see Senator Harris there. Is there a yard like a house would have that you might see him, or a grill, or is there any exterior that's his? Or is this more like I know it's a townhome, but is it more like a condo where there's not really outside property?
It's not much of outside. It has small frontage to it. It has a small area, but no, not much as far as exterior.
Okay, thank you.
Any other questions by the board?
And you're not looking in the windows, right? Like you have to be outside, right?
You may want to advise them.
You complete the fifth.
No, there's an answer to it if you like it. The answer is no. I just found it weird that I'm a member of the bar. I'm not conducting myself in a certain way. So when representatives have certain things to say, they're kind of, I work very hard to get where I am.
I admire you for being the mayor of Harvard, yes. Thank you for taking the time to talk to us.
Thank you.
And you're, I understand you're done with this witness.
Yes.
So you're excused, Mr. Clark.
Thank you. May I return the exhibits to the respective things?
Actually, if you could just give them to the court reporter, they will be then made part of the record.
Don't forget your phone.
Was objectors,
Only
I'm sorry,
only
Ken.
12 was admitted.
okay, so are you seeking, Mr. Ladisinski, to move the exhibits that were produced by candidate? I'm sorry, the objectors exhibit 15, I think, are you?
Not
done
at
with
this time. I
Okay.
may do it later.
Okay, so just for the record, the only item that has been moved based upon Mr. Clark's testimony is candidates exhibit 12.
We would move to introduce candidates exhibit 15 into evidence.
Any objection?
No objection.
Second.
All in favor?
Aye.
All right, candidates exhibit 15 is admitted, and just for the record, what I have here is not complete, I still only have 4 pages, so just if somebody before a
There was
written
there's-
decision.
What occurred was when they submitted their exhibits, they had 2 photographs which were identical.
Oh,
So
so
we
it is only
removed-
4 pages.
It's only 4 pages.
Okay, great, all right.
So the pictures, the 4 pages of the house are what exhibit?
Those are objectors, exhibit 15. So I'm keeping a separate list of exhibits that are being entered into evidence. And so far we have candidates exhibit 12 and object 15.
And Tiffany, also, I believe the first piece was the photo by Rick Seffett of proffering that he dropped the money order with the affidavit in the Harvey resident basket.
That's, I know it's exhibit 1 that you guys.
Yeah.
Correct. And then what is that document there again? And then this was the petition stuff that was not there. Just want to make sure I'm keeping a.
That's what I was waiting for.
Yeah.
That's
Can get out a witness and get her out here. If she needs to use the restroom, she can also.
That's.
Who's up next?
Oh. Here, I'll show you guys. Well, here, I'll show you guys. Well, the bathroom's that way, but we just did that there. Yeah, the clerk, said she was bringing some.
Thank you.
Oh, when they're breaking it, they can break it. Yeah, they are taking a break.
Right now, let me just recap a little bit. I'm not going to turn the volume down all the way. So there's a few things that happened throughout this proceeding. There was a few motions. So what we heard, just going backwards in time, is that Clark, the mayor of Harvey, the objector, was able to testify, and his testify based on what he's been told. He doesn't seem like he ever went to Napoleon home, but they did pull out pictures from Facebook, which includes allegedly a picture of a fireplace or something like that, or chimney. But that's what they were talking about when they were talking about submitting the evidence. So that was one that they allowed to come through. Just going back, one of the first witness, that guy was the server. So to start the proceedings, they had to make sure that everybody, sorry y'all, they had to make sure that everybody was served properly. So the service is very important. Now, just backtracking while we're waiting, there was a motion based on the statement of candidacy and when it was filed. So they were backtracking something that they talked about the last hearing, where they were trying to get the time frame where they would accept evidence for the objectors to basically produce evidence highlighting where Napoleon lived between this time frame. So that time frame may have been out of or some out of the range. I really don't know directly the time frame that was decided the first time that they would take evidence, but they did approve that the time frame would start from his statement of candidacy. So I guess that maybe gave them more room to pull more pictures. I'm not 100% sure, but that was the motion that I had said they got a point for the objectors. Want some water? You want some water? We saw you at the check cashing place, sir. Y'all know I gotta be having ADHD. I ain't no sickness gonna get me down, y'all. Let's just play this real quick before we get to the next motion. I'm not taking it off the screen. Y'all remember this? Keith Price. And he Now y'all just tell me what that looked like while we wait for them to continue these proceedings. Yeah, thicker than the snicker over there about to get yourself indicted. You told me, KP, you not with it. And look at you going to the check cashing, please. All right, so let's just move backwards again in time. The next thing that they were trying to exclude was actually the evidence. They were trying to question the rule of evidence. One, what the objectors submitted was not numbered and all types of stuff. But usually with court proceedings, as they're presented to the witness, they become numbered, especially when it's not a lot. So that they were saying that it wasn't numbered and they were trying to contest that. And the board didn't let them get that off. So that's where they got a point for the objectors, because that wasn't going to work at all. Then let's make sure that nobody acting weird, because y'all know, okay. Sorry, every time I see the page buffer, I get nervous. So then the second part to that was the pictures to show him in Baltimore. So again, they were trying to exclude all of the pictures that be coming from Facebook or wherever. But basically, the objector said that isn't a public platform, so you can't really do that. You see what I'm saying? So that ended up being the point for the objectors. But then Napoleon got the first point because they wanted to basically subpoena him, make him be compelled to testify. So Rule 237 is making the witness. Illinois Supreme Court Rule 27 is a rule that requires witness to appear at trials and produce documents. So basically, Napoleon won at that time because they did not present that earlier in the first hearing. Now, the issue was service. I talk about service all the time. It was such a short notice. That's why I was like, Napoleon, they won this though. I was like, they was being sticklers. Like, it was kind of unrealistic for them to subpoena people, get everybody to respond in that short time. They made a time frame for the hearing time frame, but it wasn't realistically for the subpoenas to go out. So what Napoleon lawyers were arguing was that they didn't follow the exact rules of subpoenaing, as well as hold on one second. Let me just backtrack. Subpoenaing them and also presented the rule 237. Now, the 237 will open them up to be able to make Napoleon come and testify. So basically, they were having trouble servicing Napoleon at both addresses. That's why I was like, Napoleon pulling a Hilliard, because he was not servable. So that's what they had most of the issues with. And Napoleon lawyers was like, well, that's your job. You're supposed to present the evidence. So that's why I was saying it was kind of unreasonable because of the time frame. But what that goes to say, they, Rule 237 was not agreed upon, meaning that Napoleon didn't have to come and testify. And they were using the reason of him not being subpoenaed properly in the time frame as basis for that. Does that make sense? So, shoot. My phone keep going off. I apologize. So that's a breakdown of what happened for the first hour, what's been going on. And let me know if you have any questions. Y'all know what we do here. Hold on. Let me go back just a little bit more. Are they about to start? I think it was
Give us a wave.
So one thing I would like to get clarification on, because that was one thing I was like, why was they servicing them checks? Like, why? What did the checks have to do with anything? So maybe I have to rewatch that to figure that out. But basically, we're supposed to be looking at 4 witnesses that have been subpoenaed. You see what I'm saying? 4 witnesses that be subpoenaed. I think we saw 2. First, and also the main argument was that, oh, they're on YouTube, it's being streamed live. Some of these people don't want to be seen. Well, we know the name and they're elected officials. So regardless, well, I can't say all of them, but most likely these people are discoverable. So that's why Napoleon team didn't win that point for basically dismissing all the evidence. The lady with the scraggly hair, she's been doing good. One thing she said weird was like, yeah, they didn't show us anything. Was it binded? And I was like, wait, is she getting confused? Not supposed to be binded, because she was like, basically, she can't make the decision on excluding the evidence because they didn't see. So basically, it's like excluding everything, which doesn't make sense. So let's just get back to it, see what's going on. I hope I did a good breakdown. Thank you to everybody in the audience that's supporting us, that love us. Please check out our community page. We made a post. Today is Kara's birthday, the mother of Alexis Wilson. Look at the lady right there eating. I always be paying attention to the most. What's wrong with me? And look at Smith. That lady is with Smith. That's Smith's girlfriend. I'm just playing, y'all. She close to him because her bag on the other side. You know, I've been paying attention to stuff. Somebody was like, you've been paying a lot of attention to things these days. I really do. But I just don't say anything because the way that these politics is set up out there. You know what I'm saying? They're weird. I've been fighting uphill battle, but God is good. We've been fighting through the cancellation. So I'm just saying what I see. Look at him. Look. Go ahead, KP. KP, like, listen, I may need you on my books one day, sir. Sir, let me see if you got Smith something. All right. Cool. I'm trying to monitor their relationship because I think KP possibly in trouble. But y'all did see Henyard come and talk to KP. I'm watching everything because this thing is crazy. Henyard, she turned on people like stray dogs. So you never know who's next. You see what I'm saying? Who would have thought that her and her main man right here would be at odds? You see what I'm saying? So I'm waiting for this. Because KP, very quiet. He minded his business. You saw him in the video having leg problems, barely could walk. He like, I'm not about to do this. So let me get to y'all comments. Y'all want to add anything? Yeah. Let's see. You know, right now, the fact that they couldn't serve him at both locations is a major factor that you guys got to consider. So that's something that they're going to make a consideration on because he's supposed to be servable in the Thornton Township address, which is Falsemore. Is a portion of Falsemore that's part of Thornton. So I guess they're showing pictures of the other location. Hold on, let me just make sure. I don't know if his home is inside the boundary of Thornton, though. Let's see if they start. All right,
I'm sorry, could you respell it? I apologize.
They starting, y'all.
ENCJARC-S Got it. Thank you very much.
And where are you currently employed? City of Harvey. And what is your position there? Supervisor in the water department. How long have you worked for the city of Harvey?
Over 37 years.
How long have you been a supervisor of the water department?
Probably about 10 years. About 15 years.
Prior to being supervisor of the water department, what positions did you hold at the city of Harvey?
When I started, I was a cashier. I went to regular clerk. I went to accounts payable. I went to payroll. I went to supervisor of accounts and finance. And then I know in 2000 I switched to water.
And are you familiar with the water billing system in the city of Harvey?
Yes.
What are your other responsibilities as supervisor of the water department?
With the water department, I actually send out the bills, make sure the bills go out monthly, communicate with the villages, make sure the readings are coming in. Several different ways we try to bring in readings.
So can you explain the process to us for how the meters get read and then generated into bills in the city of Harvey?
Yes. We have different meters. So there's some that are very old. We have ABB meters, AMCO meters, and then we have census meters. The old ones that are Rockwell, we still have to visually read.
So what does that entail?
That entails us going there and actually looking at the meter and getting a reading on it. Then we have the AMCO or ABB meters. Those were all installed in 2000. At least the ones that we could exchange in 2000, we did. Those were set up to get remote readings from a vehicle. We make flash drives in the office at the first of every month. The gentlemen come in, pick up a flash drive. We put different books, which we call areas, on the keys, separate flash drives. The gentlemen go out and read each book or route. We bring the keys back in and we upload the readings that they retrieve into our billing system. There are census meters that we've been installing and trying to exchange since 2019. They're smart meters, they're hooked to a tower. So on the 10th of every month, I actually communicate with census and I can bring all the census meters that are communicating with the tower into our billing system.
Are you familiar with the property at 1463 Vivian's Court?
In some way or another. I mean, I know now more familiar, but I mean, there's over 6,000 accounts, so yes, I'm pretty familiar with a lot of them.
Do you know what kind of meter is at that property?
Yes, it's an older meter. I don't know if it's ABB or AMCO, but it is located on the inside of the property, which used to would drive by and pick up the reading. It's not accessible for us outside.
So generally, after someone picks up a meter with the truck, what's the next part of the process?
After we pick up the readings with the trucks and bring in the census meters, we run AB reports.
What is an AB report?
These are AB reports, and they are actually all the accounts in that particular route that didn't get a reading, whether it's census or ABB.
So when you say AB report, what is AB?
Abnormal report, which means that it will flag any account, whether it's a negative reading, a positive reading, a high usage reading, a zero reading, anything that's abnormal to the customer's previous reading or history, it'll flag it.
Then what, if anything, do you do when you receive the abnormal reports?
Well, we prepare the AB reports in our office when we bring in the readings from the flash drives you guys go out there. We prepare them and we send them back out with the gentlemen that read meters at the pump station. And they try to obtain as many readings that are outside in the parkway as possible. We also try to contact customers either by yellow card, phone call, sometimes big yellow card saying we need access to the meter for visual inspection of the meter. But they try to get as many readings on this as possible.
So why would you need to follow up on a property that's on the AB report?
Because either we haven't received a response, we send out little yellow cards for people who have meters on the inside. They can write a reading down, drop it in the Dropbox, or they can call it in. We send big yellow cards saying to please call the office schedule. I mean, we have a lot of people's meters that are not communicating, but that doesn't mean they're not working. So the meters that were installed in 2000 have what's called ERTs on them, they're electronic reads. That piece may be not responding or communicating with our system, but the meter may be working well. When those were installed, they were only foreseen to be, the battery in those only were seen to be lasting 8 years. Some have lasted 10 and some have lasted 24. It just depends on where they're located, how they're located, so. The other ones have ERTs or MXUs on them. We have some troubles with those too. Those are the communicator. Sometimes the meter will bring us over the same reading over and over, but it may not be. It may be a false reading because the communicator's not responding.
Okay. All right, I'm going to show you what was attached to the objector's petition, exhibit number 3. I already given
What exhibit are you using related to yours?
the objectors.
No, I understand. I agree. Ms. Chairman, agree.
Oh, all right, so yes. All right, we're going to show you what I marked this. And I can do 2 copies of the same thing. Right. Do you recognize this document? Yes. What do you recognize this to be?
It's a history of a water account, an address water account that has the billing dates on it, the penalty dates, the payment dates, and on the side of them, it will also have the readings and the consumption.
Is this something that's regularly generated in the course of business for the city of Harvey?
This is monthly generated. This is a history of somebody's account.
And this property is for 14633 Gibbons?
Correct.
What customer is this, Dennis?
Napoleon Harris.
What does the customer name indicate on it?
Either the
Foundation.
Second. All in favor? Aye. Objection sustained, please restate the motion.
Okay, does the service address indicate your customers?
Yes.
Who is the customer?
Napoleon Harris.
Now, sometimes when you generate reports, do they indicate the word vacant on them next to the customer name?
I have a few.
And in what instances would that occur?
The customer would notify us that they still want the water on to their convenience. They don't want the water shut off and their account finally closed. They want to continue keeping their water account open.
Now, directing your attention to the third page, I'd like you to just kind of explain this document, particularly the second to right line. If you look at page 3, for example, the top says S6278, S6164, it goes down and it says auto below that. What's the difference between the entries that say EST and that say auto?
The EST.
Where are you specifically looking on page 3?
The second to right column at the top, it says EST 6278. And going down to further, it says auto, and just asking what the difference is between those entries.
In the system we coded whether it's an estimate reading, which is EST. Some are auto, which would have been picked up from the truck, in this case, driving by. There's customer readings on here, or maybe customer readings on here as well.
Okay, so can you just walk me through on the time entry, on the top of page 3, it says 6/30/23, what would that date tell? Like, why would that be indicated here?
Objection beyond the relevant time.
Well, but right now, I just want the document explained. It's not, that is not any type of business in mind, I just want to put it and explain what the document is. If you want, or we can look it up.
Move we allow it for that purpose.
Okay.
All in favor?
Aye. So what would that date be?
The bill calculated on the first line,
Yes.
that would be an estimate bill based on a previous reading we filled it on.
And what is that number, 35647 above it?
That would be the reading,
And then that fourth column, what are those numbers?
the dates.
And
And
then,
the consumption is right above the date.
so where it says 93,
Correct.
what does that mean?
93 cubic feet. We estimated this particular account for 93 cubic feet.
And roughly how much water is that?
93 cubic feet is about.
You don't know how many
I
gallons?
didn't hear that. I didn't hear
No,
that.
it's 7.5 gallons to a cubic foot, so.
Okay, so then, directing your attention to two of this exhibit, the entries in the second to right column either say EST or they say, there's some that say, there's one that says CST, third from the bottom.
That would be customer reading.
What is that?
That means the customer called us a reading or gave us a reading on yellow card.
So then, going back to page 3, let's see, I just want to see if I understand this correctly. Page 3 that we were looking at one point it goes from auto. Auto would have been when the truck read the meter.
Correct.
Then it goes to EST. That means that that would have been starting with estimates on the reading. How do you decide, like, what would have made that change from a reading to an estimated reading?
In the event that we don't retrieve a reading or the PERT is not communicating with the system, instead of it sending over us a reading, we will estimate it. Sometimes after several attempts of trying to contact the customer, we do estimate the accounts to get their attention to see if we could possibly try to want them to call us, to communicate, to let us in.
So is there a bill generated every month and based on, is there a bill generated every month, even if you can't get a reading on the meter?
Yes.
Okay, so am I correct that the truck read you approximately April 23rd, and then thereafter, at least on page 3, going up to the top, those are the estimated readings, correct? What would be at the top of page 3 and the bottom of page 2? So then what is that entry that you said it was a customer, and that's, the date is October 25th, 2023?
That's the customer's reading. Somebody gave us a reading of 35461.
And is that reading the same as it was all prior to that, going through the next page, or did that would show there's no water usage, correct?
Correct. When the reading stays the same, there shows no water usage.
Okay, so then a customer, do you know who that would have been on this meter, if the customer called and actually gave you a meter read on October 25th?
We can only take it as a customer read based on whoever has access to inside the property would be calling it in. I don't know.
Then what does that negative 186 represent?
That the previous estimates were overestimated.
So that was that, so then was there an adjustment made to the meter read at that time?
Sometimes if it's less than the minimum bill, it does not get adjusted, but sometimes it does, so yes. In this event, it was adjusted because the next bill was $14.74, and at that time, the minimum bill was $62.78.
So was the truck ever able since October of 2023 to get a reading from that unit?
The ones that say auto, that was the reading that they picked up. In some events, if it did pick up anything, then it was estimated.
So what happens when the truck doesn't pick up a reading? Do you take any action with respect to the property?
We try to contact the customer. We try to send out, like I said, the little yellow cards, the big yellow cards. We call a phone number that is listed on the customer's account to try to speak with somebody to call us back, and occasionally they will. Sometimes they don't. Sometimes they put a little note with the reading on it. Sometimes they bring them up and deliver them, but we try several ways to contact them.
When you send out bills, do the bills match the information at the top of this history registry as far as the address and the customer name? So this bill would have been going out 14633 Davis Court in Napoleon Harris vacant?
Yeah, well, not the whole time, but yes. Before it was Napoleon Harris, and then it was Napoleon Harris vacant.
When was it converted to say Napoleon Harris vacant? All right, do you know, can you answer that question without referring to anything?
The abnormal report.
Okay, so can you, when I asked you that question, can you answer that question with me without referring to a document, or do you need to look at a document to refresh your recollection?
I would need to look at that document.
Okay. So, can you show me what you're looking at?
There's 2 months, 2 separate months. But the only one says February to March. The other one says March to April. This one was good on both of them. And one has it without the rate, and one has it. That one is the first bill that went out.
Well, hold on, is this on the record or off the record?
No, this off the record. I'm just trying to figure out.
Just trying to figure out which
what document you're looking at.
We'd like to figure it out too, so we can.
I know she's got one.
Right now, if the council gets
This
through,
one is from
tell
our
me what they
this
want to say.
one is
Can we
from.
see what they're looking at?
Yeah, I'm trying to figure what she's looking at so I can give that to everybody. I got a stack of documents that I just been given by her.
Whoa, wait a minute. Back on the judge.
Okay.
So these documents were not in the records that you
No,
forwarded. to
no,
us.
they just asked what she's reading from. I haven't had what she's reading from. They were just produced to me now to refresh her recollection. So, well, I did not know of this evidence until now. And it was at your request that she identify what she's looking at. So that's what I'm trying to piece together to refresh her recollection.
These are the monthly.
I'm gonna object to this going on. They've done their evidentiary disclosure. Those are the documents that we have. And any new documents that have come in, it's just totally inappropriate.
I think
I totally agree.
have a chance to look at them before we rule on the objection.
I'm looking at, I've been handed 2 sheets of documents that just don't have this address on it. It has other people's information, their account numbers, for water usage in the city park.
And I'm not necessarily giving you to admit this. You just said she needed them to refresh her recollection of everything. So, can you tell us what are these documents?
Did we get a chance to see what you?
Yeah, hold on, I still gotta pass these over. Oh, they're multiple copies, nice. Ms. Are you marking this?
Wanted to see it, so,
Well, I think it should be marked as with some form of identification.
okay. So let's mark this as Plaintiff's Exhibit 4. Okay. Can I ask you questions about this one? Can you read the question that I asked her?
So I'm confused, why do we have so many copies if they were just provided as?
I didn't know how many. Are you asking me? Can I answer that?
No, I'm asking the board because I'm kind of taken aback is that if she's refreshing her recollection from her records, it would just be the records that she brought with her today.
Do you guys have a response, or how did you guys get all these? You brought the copies, you brought extra copies of everything?
I was at work till 9 o'clock last night signing out bills. And while I was there, I was going over my ad reports. And I went to go see back when the vacant lady came on here. It was late, so I made just random 6 or 7, I think 6 copies of each one of these, which I didn't have a chance to discuss with this board. And I just thought that I would make some, if it could even be admitted if you can't.
Okay.
Well, it's cost. Because I think that the information is relevant. Unfortunately, the candidate's counsel didn't have a copy. So I am just followed.
Well, normally in an evidentiary situation, if there's later discovered evidence,
I would also, so if the references, there's one reference on each page for Napoleon Harris. And they are outside the time limit that we've been discussing, December 5th, 2023 to December 5th, 2024.
the only question
I think the purpose of her bringing this in, and correct me if I'm wrong, is to establish when the coding on the account went from regular to vacant.
Exactly.
It just said Napoleon Harris, and then it changed to say Napoleon Harris.
That was the question that I asked her. And she didn't know without looking at this, the data of what it was converted to Mark Bacon. That's what I wanted her to answer.
My question then is, it's still coded as vacant.
That's on the previous exhibit that I gave you that was attached to the. When did it get Mark Bacon? She couldn't recall without looking at these documents.
Hey y'all, I don't know what's going on with his channel right quick. Mm. Yeah.
Can you answer that question without referring to anything?
Thank you, y'all. I apologize.
When
Some issues.
it was converted to saying Napoleon Harris vacant.
No, I cannot. I don't remember off the top of my
Okay,
head.
do you know, now that you've looked at the document, do you know what date or what time period it was converted to say Napoleon Harris vacant?
This doesn't show an exact date, but I will state that May 1st bill of 2023 indicated the name Napoleon Harris vacant. And the previous one that was dated April 1st of 2023 just said Napoleon Harris.
What is the reason that the city of Harvey would mark a vacant designation on somebody's water bill?
Because somebody wants the water left on, and we may still get the same reading, so somebody would inform us that it's vacant, but don't close my account.
Would that information come from the customer or would it come from someone else?
Objection as to whether or not this witness had been testified that Napoleon Harris called them to shut off the water, call it vacant, do it automatic.
I don't think it matters who called, but the fact is that that address, so I can have somebody.
I think your objection is premature, Mr. Levis.
Can you answer that question? Would that information come from the customer or someone else?
Over the phone, I can't tell you who it came from, but it would be somebody that would have something to do with that property. They wouldn't know to call unless we sent them a card out.
So I guess what I'm trying to figure out is when it's designated vacant, is it always originated by a property owner or is it designated by someone at the city? Or could it be both?
We won't, just as the city of Harvey, we won't put vacant.
All right, I'm going to show you what I have displayed as exhibit number 4.
This was Mark.
This would be mark 5. And I previously had given a copy of this to council. And ask if you can identify that document.
The top document is a work order.
And could you explain what a work order is?
A work order is how we communicate with the gentleman on the outside. The billing office, who bills, will prepare these work orders when we want a paper trail or when we want someone to go and do a work at a property. It's multiple reasons.
Okay, so what does this work order inform the city related to this property? And what was the date?
Yes. July 12th, it was scheduled for. It it's it's a work order for a reading only. It indicates that there's a big box, the gentleman could not get a reading. And Paul said he would email reading.
And was an email ever
No,
sent? How do you know that?
because I have no emails for this yet.
All right, can you explain us what the next page is?
A comment, and this particular comment was noted on the customer's account by a clerk, and it says yellow card issued on 3/14/24 per abnormal report.
And is there a copy of the yellow card that was issued in here, or is that the work order, or?
The yellow cards are door hangers. It's not in the file I have. Normally they go out and the guys will try to get a reading from the customer or leave it for the customer to put a reading on it and send it back.
Okay, skip the next page, which is beyond the date here, and then can you tell us what the next page is?
A picture of the meter.
Can you explain what those notations at the top are?
Hold on, so this is 20, the account number is the 008. The reading was the 035461. The address is 14633 Gibbons Court. And it looks like 62623. I'm not sure it's cut off.
Could it possibly be 10/26/23, because that would correlate with the customer adjustment, or?
It definitely cited this.
And then can you tell us what is on the next page?
Actually, this would have probably gone out before the picture of the meter. So we're letting this person know that we need to inspect the meter to see if the meter's connected, if there's a straight pipe, is there a meter there? So we want to get in, and that was issued on the 25th. And if this is the 26th, that means that somebody let us in to the property, get a reading, or to look at the meter.
26th of what?
October 26th, 2023.
So if you look at page 6 of that, is that a sample of the type of notice that goes out?
This is.
And then the next page after that, what is that document? The one that's dated 12/18/23.
That is also an inspection for us to get inside, to check the meter.
So how many requests have there been to inspect this meter since December 5th, 2023, as far as you know?
I don't know. Off the top of my head. Since 2023.
Could you speak up, please?
I don't know exact number off the top of my head.
Exact number of what? I didn't hear the question.
Jerry, let me know.
Oh, sorry. Can you read back the question?
How many requests have there been to inspect this meter since December 5th, 2023, as far as you know? I don't know off the top of my head.
And then directing your attention to the last page of this document, can you tell me what that document is?
These are the readings that were retrieved or entered on the person's account from February 7th of 2023 to January 10th of 2023.
What were those dates again?
It's the last page of this document. So it's
Last page is this.
this.
Oh.
It's at the very last page.
Last page is the file. There's stuff to do. Okay.
So then, based on this information, and only from the time period from where it says to December 11th, 23 to date here, have you ever been able to get a reading of the meter of that house?
No.
How do you know that?
These are all estimates.
And were there requests sent for a reading?
That's what the yellow card could have been. You can't tell on these, but the yellow cards mean that they're inspections requested of the meter. Some of these are red cards, which mean we're notifying you that the water could go off because the meter reading was past the amount. So on December 18th, 2023.
We only are, I'm sorry, back when I finished exhibits, you don't have to go farther back. And then, all right, so after December 18th, 2023, did Harvey ever hear from a property owner related to getting a reading on this meter? Has anyone ever requested in that time period to have the property not marked as vacant?
No.
And have you had situations before where you've sent out bills that have the vacant nomenclature on it and then people have requested to have it changed later?
Can you repeat the question? I can't hear it.
We've been in situations before where you've sent out bills that have the vacant nomenclature and people have requested to have it changed later?
Yes.
Under what circumstances does that happen?
Objection relevance.
Second.
All in favor?
Aye.
I have several people that leave for the winter, so maybe they don't want their water shut off and the property's heated. So we will get the same reading, so they know that we will get the same reading monthly. They don't want us to close their account for no activity, but they want it on for when they return. So sometimes it's from November to March, but they will call us back and say, okay, we returned home. It's not vacant anymore.
I have no further questions, Ms. Witness.
Ma'am, you're not here pursuant to subpoena, is that correct?
I beg your pardon?
You didn't get served a subpoena in this case, correct?
No.
You just have to show up. Is that your testimony? Sorry, I'll rephrase that. How did you come to be here today?
I supplied some of the documents, to the person that asked me for them, and I had a meeting with my supervisor yesterday.
Okay, who was your supervisor?
Maria?
Okay, and did anyone from the city of Harvey tell you have to be here today?
From the city of Harvey, Miss Carrie Lynn?
And she's the attorney for the city of Harvey, correct?
Yes.
And with regard to exhibit number 3, this is a printout, a summary history record for 14633 Gibbons Court, correct? I'm going off of your markings.
I didn't mark it.
Exhibit 3. And this is a document produced by the city of Harvey, correct?
It's produced by the computer system from BSNA.
And so you were talking about types of meters in which the vehicle could drive by and read the reading, correct?
Yes.
And those are all reflected as auto, correct?
Yes.
And in March of 2023, they could no longer get an automatic reading from the meter, correct?
That's what it appears to be, yes.
And from that time forward, the city of Harvey could not get an automatic reading through a drive, I'll call it a drive-by. Is that correct?
Yes, correct.
And
That's actually May of 23, May 20th of 23.
And that's indicating there's a malfunction with the meter, correct?
No.
Well, if the meter's communicating with the car that drives by, there's a transponder on the meter, correct?
Yes.
And what that's indicating is they're not getting any readings from that meter.
Yes.
Okay. And with regard to the time period, so from the period of March of 2023 forward, your equipment was not reading the signals because no signal was being sent from the meter, correct?
Okay, so the ERT, which is attached to the meter that was installed at the beginning of the time that we were installing meters, were anticipated to work for 8 years. That does not mean the meters malfunction. We have a lot of meters that are functioning well. The responder is not sending over the reading anymore.
So the equipment that was, the city of Harvey installs the equipment for the water meter, correct?
Most of them,
And the ERT, the transponder,
yes,
is also installed by the city of Harvey, correct?
correct.
And your records verify, and your testimony verifies, that there was a problem with the transponder reporting what the actual water usage was at the city, at this residence in Harvey, correct?
Objection, that mischaracterizes the testimony. She said that was one of the reasons why they're here.
Why don't you tell the electoral board all the reasons why the transponder would not be transmitting properly?
Somebody could cut the transmitter wires, especially on the inside that we have no access to. Some people have disconnected meters that do not respond to our communicating device in the vehicle. Some may be removed, some may be stolen, some may be at other properties. There's several different reasons why ERT would not send over a reading.
Do you
If
have
the
any-
wires are cut, we wouldn't get one.
Do you have any evidence that the wires were cut from the meter that is at this location?
No, not as of the date on the picture. They were not.
And the date of the picture is approximately what? You said it's 23. We don't have the first.
It was cut off October 26, 2023.
That when you say cut off, it's the number,
The
not the
number.
wires, correct? And with regard to the city of Harvey, is there any notifications in your file advising Napoleon Harris there's a problem with our equipment?
There's not a problem with our equipment,
Well, the ERT is your equipment, correct?
not inside the home. The homeowners are responsible for the meters and the ERTs inside of their building.
Did you ever tell Napoleon Harris, is there any documentation, there's a problem with the water meter or the ERT in the building?
I don't believe we ever spoke with him, but those are what the yellow cards are for, to tell them we need to inspect it. We can't tell them there's a problem until we inspect it. We were not able to inspect it.
With regard to issue testimony today, it's fair to say that the city of Harvey does not know what the actual water usage was at this address during the time period of December 5, 2023 to December 5 of 2024.
Correct.
And in fact, the water usage could be tens of thousands of gallons, correct?
Correct.
Now, did the city of Harvey send bills to this account?
Yes.
And the bills have been paid, correct?
To my knowledge, I just looked at it.
Well, one of the documents, I believe it's Objectors Exhibit number 3, shows bills going out, and the bills are being mailed to 14633 Gibbons Court, Harvey, correct?
Correct, there's a zero balance.
And it shows multiple payments during this time period from December 5, 2023 through December 5 of 2024, correct?
Yes, that's why there's a zero balance.
And with regard to vacant, you testified earlier that when you got abnormal reports, the city of Harvey would treat that as vacant. Do you recall that testimony?
Beg your pardon?
You testified that when there was abnormal readings that the ERT system would give, the city of Harvey would declare or list that as vacant. Do you recall that testimony?
We don't declare anything, I'm sorry.
With regard to vacant, you have no communication from Senator Harris in your files indicating that he requested that vacant be put on this
I
property.
can't
correct?
identify a person over the phone, sir.
Well, did you ever have a conversation with anyone with regard to this property?
I may not have, but whoever commented on the screens that were given to you in exhibits, there was, a clerk in there that commented the screen that day that she put it on there.
But there's no indication on that screen, because you've not produced the document, correct? Showing the screen report for that day?
Sorry, I couldn't hear what you said.
I'm not familiar with the whole package, what was submitted or not submitted, so if there was comments put on there, it would have been put on by somebody who received the phone call.
But there is no records that were produced so far indicating that anyone made a phone call to the city of Harvey. They have this property listed as vacant. Isn't that correct?
I don't believe there's any paperwork.
I'm going to show you what is Kansas exhibit number 7. And I'll ask you questions.
Guys, bear with me.
For the record, I'm providing.
That's not on my part. This is on reality check. His thing is changing settings. So I apologize, y'all. And shout out to reality check. Thank you for being there and letting us use your live.
Do you recognize this document?
This is what document?
Kansas exhibit number 7. Do you recognize this document? And what are these documents?
Water bill,
And what are the water bills for? What property?
14633 Gibbons Court,
And who are they addressed to?
Napoleon Harris.
And these are documents prepared by the city of Harvey, correct?
Yes.
And this is a document that you're familiar with, correct?
Yes.
And this is prepared in the ordinary course of the business of the city of Harvey, right? In the ordinary course of the city of Harvey, water department. I would move Kansas exhibit number 7. Evidence?
Any objection?
I agree. So moved.
Second.
All in favor?
Aye.
Submitted.
I have nothing further.
I just have a couple questions based on this last document here. If you turn to page 3, after the period is for the period of 2/7/2023, 3/9/2023. And the top of it says Napoleon Harris taken, correct? Correct. Do you have any indication that Mr. Harris called at any point after that date to tell the city to not mark the property as vacant?
If it still says vacant, nobody notified us of it. Nothing.
I have no further questions, and I would move to admit exhibit 3.
If I may.
Oh, sure.
Ma'am, with regard to the exhibit, I want to make sure the board's clear here. Just because it's listed vacant doesn't mean that water is shut off, correct?
No, it's not off just because it's not vacant.
And water is still being provided today to this address by the city of Harvey.
To my knowledge, yes.
I know.
Nothing further, but I would move to admit exhibit 3. And the pages of exhibit 5 that are updated after the applicable dates here.
And what about exhibit 4? Are you doing anything with that?
Sure, 4 also.
It's inappropriate, it was used to refresh your recollection.
Okay. What does the board want to- Well, let's rule on each one, or the board should rule on each one separately then, if there's an objection. Okay, so plaintiff's exhibit 3, which is the water readout. We've got a motion to admit it.
Second.
All in favor?
Aye.
Okay, plaintiff's exhibit 3 is in. As it relates to the exhibit 4, which was in fact used to refresh the recollection of the candidate. Candidates counsel has stated an objection to that, I'm sorry, move to refresh the recollection of the witness. Candidates counsel has stated an objection to that. That's that document, correct?
I'm not really sure what candidate 4 is, because I thought one of them was crossed off.
4 is this one.
Got it. Thank you.
So what does the board want to do on that?
And say if it came in late, then it is not admitted.
Okay, so motion to deny admission. Wait a second on that. If I may, the information that I think that they were trying to show on the plaintiff's exhibit 4 is, somewhat shown also in candidates exhibit 7. It shows that, I think that the purpose was to show the date that it went from showing not vacant to vacant. And that's,
That includes with the substantive record because it was used for that way. Yeah, just for the record for future review.
well, like I said, I think that information, if I may though, that information, because all plaintiff's exhibit 4 was submitted for was for the purpose to show that in February of 23, that it didn't say vacant. All right, so we've got a motion and a second to not be admitted. All in favor?
And just to clarify, is it still going to be in the record for appeal?
Yeah.
That is just-
I would hope so. That's
Yes,
what I
that's what you were saying originally.
So that anybody who looks at it later can know what the witness was referencing. It's not evidence for us to consider beyond her testimony or testimony. Move admission of exhibit 5.
Second.
All in favor?
Aye.
Okay, those exhibits have been either admitted or made a part of the record as stated. Is the witness excused?
Can we question?
Oh, I'm sorry. Yes, absolutely.
My question for this unit is there an HOA that pays any part of the water bill for that building?
An HOA, to be more clear,
Homeowners Association?
not that I'm aware of.
So there's no separate bill going to that complex of townhomes to the association? And can you clarify this charge of around $61, $62, $63? Would that be typical in a townhome?
That's a minimum bill. That is a minimum bill for having water on. And it is a typical bill from using no water to 267 cubic feet. The rate is based on cubic feet. And it is increased from 61, 62. Every time Chicago raises their increase, that might be where you see the different amount. The garbage is $26.76. The sewer is $10 a month plus 16% of the consumption. And there's an admin fee of $2. That will be the total of your $61.62.
So is there any way to make 267 cubic feet a meaningful number to me that knows nothing about quantity of water?
As far as gallons. As far as gallons, like.
Well, you have, I mean, I don't have my phone, so it's 267.7.498, I believe.
Wait, what is that?
Yeah, like,
It's
you
200.
estimate how many does it take to take a shower?
I'm gonna check.
That's a minimum amount of
Okay, so
water.
that's the
It's
question
from
that,
zero
just
to
so we can clear
267.
that, that's a question from the chair now.
Can a family shower and do dishes or use that much water?
Everybody uses water differently. And it
There's
depends
no
on what's
magic
going on at the
typical
house.
number.
But these repetitive amounts are just the basic without knowing
That's a
exactly what was
minimum bill.
used.
That's a minimum bill for having water on.
But I mean, the same thing with water, sewer, refuse.
Correct. Those are flat fees except for sewer. It's plus 16% of the consumption.
So there seems to be a gray area that please point out that we don't know if they're really using the minimum or you're estimating that.
It says
because
zero.
you're-
We never know what they're using unless we get inside and get a visual on it either.
Which you haven't done for all those estimated bills.
Any other questions by the board?
No.
Okay, may the witness be excused?
Yes.
Thank you.
Thank you.
Okay, objectors, your next witness?
Could we ask for a brief recess?
Sure. We're back at 3. It's 2:50 right now, 3 o'clock.
27 cubic meters.
Give everybody 10 minutes, get up, stretch your legs.
Come on, not another break. Okay, y'all. It's a 10-minute break, but the good thing is, if y'all can hear me, that we have one more witness because I only think it's 4. So what I'm gonna do is put some timestamps in this long video so you guys can get to when I kind of recap, because I think that'll help the audience. So this is gonna be our second recap, and it's not that long because we went over the first witness, which was the server, the second witness, which was Chris Clark, and everybody determined that he was a liar, allegedly. But his testimony was based on third party. Basically, he heard or he believed, but it doesn't seem like he actually went to Napoleon house. So what did they do? They look at Clark. Look, and no, that's not Clark. That's like Clark's brother. I was trying to figure out who that was. That like his twin. Do Clark got a twin? Look at it. Two looking devils. I'm sorry. Look at Nate Felds. All right, y'all see I be getting distracted. So Chris Clark, when he was there, they had omitted evidence of a Facebook picture of the Fossmore home property. So they went to the water district. This is the third lady, the third witness, and this is the director. I'm gonna turn it down real quick. This is the director of Harvey Water Department. That was the young lady you saw on the stand. So one of the things that Napoleon lawyer tried to establish was, wait, how did you get here? Because you already know what we talked about. The subpoena issue was the issue. Everybody didn't get it. It was last minute. People didn't even get a chance to respond. That's why I was like, it's kind of crazy to do it like this, because there's a certain time frame that people have to respond to a subpoena. And sometimes that's 7 days, 14 days. It could be different in different states. So she showed up. He was like, you showed up? And she like, yeah, basically. Y'all can rewatch that. But there were, I think, 2 documents or 3 that they were really just paying attention to. Oh, shit. Excuse me. Something happened. One of my other screens started playing at the same time. So I think they went on a break. I'm not. So just to rehash where we at, I want to make sure, because y'all know I'll be a little bit nervous about some things. Now, I don't know why he turned it off. I don't know if he leaving, but we're gonna get back to it and see if he's gonna be live. Let's just recap what's going on real quick while I troubleshoot what's going on. Hold on a second. Yeah, I know what I do. So basically, this third person was the Harvey water director, and she showed up by herself. And what they were trying to establish was, do he actually live there? So because they were showing estimate bills, estimate bills and getting estimate reading, they may be trying to like disqualify that information per se, because it was estimate bills. But at that time, I guess I don't know why it was coming up as zero readings. Does that make sense? It was coming up as zero readings. So that's what Napoleon lawyer has been trying to establish. Let me listen. Let me listen to what Reality Check TV said. I think they're taking a physical whole break where he about to get some food. He got off live, and I think he may jump back on. Let me hear what he said. Thank you for bearing with me. Y'all know I'm a little under the weather, so some of the things I haven't caught. Okay, let me listen.
Until next time, we'll see you. Right, Check TV Chicago.
Okay, so I wonder who else is here. Oh, Vivian. All right, y'all. I may have to compromise. Let's pray that Vivian don't get mad at me. Okay, we're going to see, can we stream off of Vivian live when they come back to finish this hearing? Everybody leaving because it's so long, I would assume. All right, give me a second. Y'all know what I do. Give me 1 second. Y'all know I'll be blocked some places. Cool beans. So I don't know if I'm blocked on her page, but hold on a second. First thing I'm gonna do before she find out that I'm streaming her stuff, I want to say thank you, Vivian, for being down there. One, I know it's not easy, one for any content creator, and then acknowledging your situation. So with that goes to say, we all on the same page. What I'm going to be doing is streaming Vivian's live, your favorite survivor. So she is down there and they're on a break. That's the person who we saw. Oh yeah, we're going to just get it all. I guess each person is kind of like clunking out. And you know me, I'm not going to clunk out. We're going to rock out and to get this done. Hold on 1 second. So while I edit some things and let this play in the background, shout out to her. I always go. That's going on right now. So they on a break. This is live still, y'all. Y'all know Grace gonna get it. People was on their screen trying to jump and find it. God be put me right in the right position. We're gonna get this whole thing through. Let me just edit this real quick so I could give Vivian her props for being there. Again, we went from Critical Smoker to Reality Check TV, and now Vivian. Yep. Now y'all know I love y'all because I stay away from some things so I don't have no drama. So again, shout out. I'm throwing the right white flag up so people can see the hearing. Y'all know I report different. So I'm usually the person that's kind of breaking down what's going on. You see what's going on in the audience. I am not a lawyer, but I'm a legal nursing consultant and I love to research. And as you can see, I'm also a legal real estate consultant, self-acclaimed. That's because I know how to research. So because I invest in tax liens, I use my research skills to help me. So that's why I'm here, because I love this type of stuff. I'm corny, so I know people don't understand or not understand. It just be so much mumbo jumbo going on that you kind of miss some things. So this is how I broadcast. This is why I find it very important, because I kind of break things down to a simplest form. You know what I'm saying? And I be hearing stuff. So thank you for being here. I appreciate you guys. As I mentioned in the audience, I thank you for all the new people who are popping in, but we do have a tone here. It's kind of for the grown and sexy. You know what I'm saying? No, we're not going to that. So if you're going, you can go. Okay. That has nothing to do with the hearing right now. So y'all can update me definitely later. But, as I say, I have to be the real. The same energy that I get from people, y'all have to respect. So when I go over to people's page, I get an attitude. I get people ignoring me. I can't say names. I can't say stuff. So please respect me, because there's a lot of platforms. You could just go over there. Please, I'm being honest. There's no beef, no nothing, but the same respect that you have for other content creators. Like, you won't go, not to you, You won't go to Hannibal page and like, Jedediah is live. You will never do that. So please give us all our respect. I love you guys. Please, thank you. So that's why there are some names that's blocked, but that was because I was being kind of attacked and some people was just really vulgar and I didn't want to have to show, an ugly side to defend myself. So back to what we were saying. I just wanted to break that down. I love everybody, but y'all, the people who know what's going on, y'all know what's going on. It's deep in this Dalton stuff. And that's something we may have addressed too later on another live. People have their tone about what happened at the last meeting, how it should be, how people should act. And I'm not defending Jedediah. I'm just defending truth and justice. It is what it is. At this point, everything politically correct don't work. It hasn't been working, and we have to stand up for our right. I don't promote violence, but I do promote getting the job done. Y'all know I'm from the Levi family. Haitian people move different. So even with that goes to say, I know that we all are headed towards the right direction, which is getting Tiffany out of those seats, and we all doing our part. But as what I said. But thank you guys for being with me because I'm still a little bit under the weather. I took a Tylenol. I don't never take a Tylenol. My temperature was 99.9. And I'm here for it, y'all. Hit the like button with a blanket on my shoulder. Taking notes. I love y'all. I love this though. So anyway, back to the water director. The water bill shows zero consumption every month. You have to use certain amount of water to show usage. And I wish dishes and I wash dishes and take showers every day, but I still don't use enough to register. Thank you for letting us know that because I don't really know how those automated water readings work, but I know Dalton had a serious issue with it, and I know most counties do that. So yeah. Do they act AP? Do they send you something to write in? Because I know you don't want an estimated bill. Because after a while, they'll charge you the top number on an estimated bill because they feel like it may be a leak, maybe some issue, or maybe you broke the equipment. Because in here, you got to hear they mentioned that they were trying to get a service order for Napoleon because the equipment was inside of the house. Did y'all hear that? And they never could get inside of the house. So not to say Napoleon broke the transducer, but it wasn't working. And that's what his lawyer was trying to establish. Like, you're just basing your testimony on an estimate, which would prove that this is not fact. Even if it read zero, it's still not fact because it wasn't actual reading. So I don't know if her testimony is really strong because of that, to be honest. They let you pay a flat rate. What area are you in? Because in my county, I opt for a flat rate because the usage, the wattage was going up when all the gas rates was going up. So I have a set bill, and my bill like $124 for the next 2 years, and I could get out of the contract, but it because the rates was fluctuating, I chose that just in case because we was living in bad times now. So what is your situation where you play a flat rate? Because there's different things, you know what I'm saying, that may apply, but I know when they couldn't get a good water reading on me or my water looked like it was running, they asked to send me a humongous bill until I had to figure out what was happening. Hey there, just wanted to hit the like button. This is the longest territory hearing ever. Yes, I'm here for it, Lady Luck. Y'all see, I'm here like this damn theory. I'm good. We write down notes. We taking our time. It's a Friday. I actually was gonna have a patient today, but because I'm not feeling well, I got to be here with you guys. So you said my water bill is like $50 a month. That's cool. Cool beans. That's cool. Is it you there? It gotta be just you. Okay. You can get a flat rate on your utilities. Yes, I do. They have different programs. So I do understand that. Probably I never thought about what I'm paying for utilities and started following this. Laugh out loud. Right. It make you think about this stuff for real. And I was talking about we were talking about the water bill. So I wonder who's gonna be the fourth witness. We got one more witness and they did win. Napoleon got a 1. Thank you so much. It's working. I'm cooling down. I'm gonna take my temperature. I'll let y'all know. Napoleon got a point because he didn't have to come testify. Exactly. That's what I said. I agree with you, AP. You know, I'm real. Real is real. I don't have a dog in this fight. I say what I say about what I see and how I, evaluate stuff. This right here, as far as like I said, her testimony may not be weight. It might have no weight to it because this is not showing beyond a reasonable doubt. You see what I'm saying? And even though I know there's not no murder trial, there's still room for reasonable doubt because it was an estimated bill and they never got in. So by her showing up, they ain't really do nothing but take a whole another 45 minutes of us. You know what I'm saying? Now, what can be, because there's two things that they're trying to establish. Definitely the address. Okay, so that address was established by way of Napoleon lawyer, and that's the address where they, saying, that's where he lived. So she actually said that that's his address. So that kind of helped Napoleon because it was kind of, I think it was two aspects to this. One, as we told you, the meter running, the validity to show was it vacant because there's a question of vacancy, and also the return slip, and they asked for her to repeat his address and said that that was the bill that you sent. So that was no, I don't. You have to go over there and figure it out, love. I put it up there. But let me give y'all a heads up because that case that Jedediah is talking about, I did get a heads up about it, and it was filed yesterday. I don't have the details on it, but the actual hearing is April. So the Zoom meeting, I don't know what it consists of, but it's not a hearing today because it was filed yesterday. I don't want to drop the bomb on anything that's going on, but y'all keep putting stuff in there, like, So that's with that. And I don't know, like I said, it looks like it is sexual allegations against Andrew Holmes. If y'all would like me to follow up later on, I would, but he is representing that topic and let him talk about it. You see what I'm saying? It is what it is. I'm not lawyer Grace Still right now. I'm Grace Levi trying to hold my platform down, Peyton. Okay? I love you. But that's what happens too. What I notice is that people come over here to make announcements, and I mention that. And then kind of people just run and like, oh my God, because it's drama. So that's why I'd be like, please monitor what you say here because that's not fair to me. And then if I react, I'm looking like the bad guy, the person who's saying bad stuff. That's not what it is. You know what I'm saying? I love everybody doing their thing. But if I could follow up, that's what it was. So the case is actually going to be heard in April. I got it pulled up with my nosy ass. Andrew Holmes, Morris Security Corporation, Aisha Gant, initial tort injury. It was filed 1/3/2024. 25. I do apologize. And the next hearing is first time case management, and they're going to talk about it. It's April 2nd, 2025. Okay, but let's get this started.
You guys had
Not prepared. Not prepared at all. This is embarrassing.
Oh.
As it relates to the exhibits, or
I'll
the
find
documents
it, y'all.
requested under the subpoena, are those what Mr. Lev is getting together right now? Okay. But those were all part of the document disclosure that was done yesterday?
I'll look it up for you, Miss Peyton.
I put my glasses on.
Okay.
When did he file that? That was 2011. No.
I'm not studying.
But you're a witness.
I thought you wanted the documents before I started.
I want the documents before you start, so I know.
I understand that, that's why I'm waiting.
I mean, we got a break.
No, let's start with the witness before documents, but I do want the documents before I do my clause.
Understood.
Waive the scope again, because he's understood, you know, it's a call.
That's right. Okay, counsel for the objector, please begin your questioning of Mr. Smith, or I'm sorry, we gotta swear him in. Court clerk, you please swear in Mr. Smith.
Swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth.
That's the best
Could you
thing.
state your name for the record, please?
Michael A. Smith,
And what is your address, Mr. Smith?
14539 South Moon Avenue, Riverdale, Illinois, 60827.
Is Riverdale in the vicinity of Harvey?
Yes, it is.
And how close is your home to Harvey?
My home is actually across the street, so you have my home and Harvey's right next door.
Okay. And have you ever been to 14633 Gibbons Road in Harvey?
14633 Gibbons Court. Yes,
Court.
I've been.
And when is the first time you went to
Just catch a dog, Smith.
Gibbons Court in Harvey?
The first time was about a year ago.
About a year from today?
Correct.
Okay. So that would be between the period December 5th, 2023 and December 5th, 2024. Is that
Yes.
correct? And you're one of the objectors in this case, correct?
Yes.
And did you have any conversations with Christopher Clark about the contents of the objection before it was filed?
No.
Did you have any conversations with Jerlene Harris about the contents of the objection before it was filed?
No.
Do you know who Christopher Clark is?
Yes.
And how do you know Mr. Clark?
I know Mr. Clark just from being an elected official in Harvey and running several elections.
Okay. Have you ever been involved in a case like this with Mayor Clark?
No.
You've never had an objection filed in relation to Mr. Clark?
I did. I'm sorry. That was the objection for Township Supervisor.
Okay, so who objected to who in that case?
I objected. Me and Keith Price objected to Christopher Clark's slate.
Okay, so you were adverse to Mayor Clark in that case?
Correct.
And are you familiar with Napoleon Harris?
Yes.
How do you know Mr. Harris?
I know Mr. Harris, previous board member of Village of Dixmoor. At that time, he was our senator.
And when you say at this time, what time are you referring to?
At the time, I lived in the Village of Dixmoor and was on the board.
And what
That
years
was
would that
about,
be?
that had to be almost 10 years ago, maybe.
Okay, so you've known Napoleon Harris for 10 years?
Yes.
And are you aware of whether or not Mr. Harris holds any elected offices?
Yes. He holds several elected seats.
And what are those seats to your knowledge?
The Democratic Committeeman for Thornton Township. He is the senator for the senatorial District 15 legislative.
And do you recall when Mr. Harris was elected to the position of committeeman?
Yes.
And when was that?
That was about
years ago.
And has Mr. Harris been elected to that position?
Yes,
And when was he elected to that position?
it was about 3 years ago. The term was coming up for election.
Okay, and did you have any participation in that election?
I did.
And what was your participation in that election?
That election, I helped campaign for Mr. Harris, as well as work the polls for Mr. Harris in the village of Riverdale. I worked precisely my precinct.
And that was supporting Mr. Harris for Township Committee person in Thornton Township.
Correct.
Okay, so 3 years later, you're trying to knock Mr. Harris off the ballot in his race for Thornton Township Supervisor. Why is that?
It goes back to once Mr. Harris got elected to be the committeeman, he asked me to sit on the DOT board, which is the Democrats of Thornton Township. I sat on that board for a brief moment because at that time we were getting ready for local elections. And I indicated to him as well as the board that I was interested in running for Riverdale trustee.
Okay, so my question to you was why you're filing this objection. I think you stopped a little short before finishing.
I'm filing this objection because upon having an interview with Mr. Harris, along with Antoine Russell, we met at Portillo's in Homewood. The meeting was in regards to me running for Riverdale trustee. At this meeting, it was stated to me, why did I want to run? What was my experience? And how long I had been a resident of Riverdale. I gave my experience as well as why I wanted to run. And then questions began to come from Committeeman Harris and Antoine Russell. Questions that came to me was they had other positions they would have liked for me to run for and to ask me to not run for Riverdale trustee. And I asked what were those positions, and they told me in the village of Dixmoor to run for mayor or either West Harvey School District 147. At that time, I told Mr. Harris, as well as Antoine Russell, I'm not a resident of West Harvey School District 147, nor the village of Dixmoor, and I could not run. And he told me, well, I am the committeeman, and
Hold on,
Wait.
there's an objection being made.
I'm trying to figure out who's saying what during this conversation, because
he said to
Yeah, I
me,
mean, hold on, there's still an objection pending. You have to wait till the board rules on the objection. You have to give the other side a chance to respond, and then the board's gotta make a ruling on the objection.
I won't respond to the objection. I'll ask the question Mr. Ladizinski wants asked.
Okay, well, that's.
Okay, when you say, you're saying, he told me,
that-
use.
Sorry, y'all can hear it.
Instead of using pronouns, so that we all know who you're talking about.
Hearsay relevance, his motivation for filing this is not allowed. If there's bias, that's allowed.
I mean, what does the board want to, oh, well, first of all, do you want to respond?
Yeah, I mean, this conversation goes to why he believes Mr. Harris is not a resident of Flossmoor or of Harvey.
You're right to first.
I would say that this the board, I guess, does the board have any thoughts before you want to hear my thoughts?
Let's hear your.
My thought is that to the extent that there's any statements related to Antoine Russell, that's definitely hearsay. I think that falls squarely within the hearsay rule. As it relates to statements from Napoleon Harris, I mean, granted, he is a party, but he's a party that is not here. Subpoena was not delivered. So I personally, I find it to be hearsay. And I also question, I do question the relevance. The motivation of the objector does not matter if he wants to provide evidence, otherwise, as it relates to, I guess, what leads him to believe that Napoleon is not a resident, and that Mr. Harris is not a resident, then I guess he could do that. But to the extent that, I don't know, it is hearsay, I think it fits within the textbook definition of hearsay.
To the extent he's going to testify at what others said, not laying the proper foundation, particularly with Mr. Russell, that I will sustain the objection. You need to sustain that objection on hearsay grounds. Also sustain the objection as to forming the question in terms of eliciting vague answers, but Mr. Mullen understands that. So that's my motion.
Okay, so the motion is to sustain the objection as to hearsay as it relates to any statements from Antoine Russell. Okay. Do we have a second on that?
Second.
Okay, all in favor?
Aye.
Is there a motion to either sustain or overrule the objection as it relates to out-of-court statements from candidate Napoleon Harris? Because if you, the way that, my understanding is Mr. Smith was testifying to, as it relates to the meeting that he had with both Mr. Harris and Mr. Russell, where there were these statements made back and forth. So what is the board's ruling on that? Because I do believe that the objection was to both, correct? It was-
Correct.
Okay.
As to Harris, I move to sustain the objection as to form to elicit a more clear answer.
Okay. Do we have a second on that?
Second.
Okay, all in favor?
Aye.
Okay, objection sustained as to form as it relates to statements by Mr. Harris made to Mr. Smith.
I'm sorry, I gotta get a
In the
better
conversation
view.
you were just referring to, did Mr. Harris say anything about his residence?
Yes,
What did he say?
he told me that he's a resident of Lawson.
And when was this?
This was almost 3 years ago when we had our meeting about me running for office.
Okay. And so the basis of your objection to Mr. Harris today is that he's not a resident of RV and Thornton Township, is that correct?
Correct.
Okay. And prior to filing this, what type of research did you do into the residency of Mr. Harris, if anything?
The first thing was I revisited 14633 Gibbons Court. I went by there several occasions. I've done it in the morning, I've done it in the evening.
That sounds like a
I've done it at night.
stalker.
I've not seen any of his vehicles that I know that he drives. I have not seen any lights on. I have not seen any movement whatsoever at that address. As a matter of fact, I've even gone when it has snowed, and I have seen no footprints or car trails that leads from the garage to show that he lives.
And so, let me just understand your testimony. You said the first time that you went was 1 year ago, correct?
Correct.
So all of those times that you're referring to have been in the past year, is that correct?
Correct.
You referred to Mr. Harris's vehicles. What is your understanding of what Mr. Harris drives?
He drives a Cadillac Escalade with Senate plates 15. He has a Mercedes Benz, which is like a black color almost, or charcoal. And he has a white Mercedes Benz that he drives, which is, I believe it's 2 doors. The rest of the vehicles are 4-door vehicles.
Okay, in all of the times that you visited 14633 Gibbons Court, have you seen any of those vehicles parked in that location?
Objection, can we have as to form? He said several times, no dates, number of times.
I agree. Second.
All in favor?
Aye.
Aye.
Objection sustained.
Have you ever seen the white Mercedes-Benz two-door that you believe Mr. Harris drives at 14633 Gibbons Court.
Objection form. Number of times, when?
Where? The question was, have you ever?
That's okay. You can take a motion overrule. Oh, I'm so moved. Wait a second.
I move to, not hearing a second, I move to sustain the objection as to form as being lacking specificity.
Second. All in favor?
Aye.
Any opposed?
Opposed?
Okay, motion carries. So objection sustained. Be a little more specific.
So do you recall the first time that you went to 14633 Gibbons Court?
Yes,
And when was that?
that would be April,
Of 2024?
yes,
And when you went by 14633 Gibbons Court in April of 2023, or 2024, excuse me, did you see any of the vehicles that you identified as being Mr. Harris's vehicles parked in that area?
No.
Do you recall any other specific times that you went to 14633 Gibbons Court?
after, April, I primarily went every other week.
So he was
to see
definitely stoking.
if he was there, or if I seen any vehicles, if I seen any movement, in between that time.
Okay, other than going to 14633 Gibbons Court, what did you do to determine where Mr. Harris lived?
I did a lot of FOIAs. I FOIA'd the, Senate, I FOIA'd the city of Harvey, I FOIA'd Homewood Flossmoor, I FOIA'd, the Secretary of State, I FOIA'd, the, FEC, I FOIA'd the State Board of Elections, anything that was FOIAble for me to, by law, given, I FOIA'd.
Okay, and in terms of
He
the
definitely a stalker.
responses that you received to the FOIAs, was there anything in those responses that you believe supports your allegation that he does not live at 14633 Gibbons Court?
Objection foundation as to each of the FOIAs, when they were sent and when they received responses and what was received.
Object, sustain the objection as to form.
Second.
All in favor?
Aye.
Motion carries.
Okay, so with respect to your FOIA of the State Board of Elections, what did you receive in response to that FOIA?
I received,
Objection. When was the FOIA sent? And now it's time for these documents. Because there's only one FOIA request that's been produced to us.
Objection is sustained as to foundation.
Second.
All in favor?
Aye.
Motion sustained.
The laugh. Thanks, Hannibal. My first $20.
And as you,
I saw it because it's orange.
as y'all see at the bottom of the screen, this is your favorite survivor tool. You had to jump through, content creators. So she's still there holding in. Shout out to Vivian Allen. This is her clip. She's live. And I think she's live on Facebook.
No, there's no question pending.
I was asking, can I approach my counsel?
Not during the middle of, not while you're on the stand. Absolutely not.
It's so funny. He mad. Thank you, Mrs. Keys. He just tried anything. It's ridiculous. So laughable. Approach the council now so you can get your lives together. Nope. Stay right there, sir. I'm sorry. I was talking to the attorney at first.
Did you give me a copy of that flip?
Yeah.
I'm being quiet. I'm just whispering.
You put FOIA on your phone?
Thank you, Anissa.
So, we are still on the record.
Yes. And this is responsive to Mr. Ladizinski's request, so I want to make sure we have that.
Oh, thank you, Bushmaster and Golfer. I appreciate you guys. This is literally my first live monetized. I can't read the comments because I don't have my glasses on. But I can see those stickers. He's not happy. Let me zoom in so y'all can see. Let me. He in his phone looking for his fake warriors. His attorney, those attorneys for Clark are so unprepared. This meeting should have been ended. There we go.
Madam Chairman, while they're looking for evidence that didn't come to us, and evidence after the petition was filed, verified objector's petition was filed, it's 20 to 4. I mean,
Right.
the chair said 5 o'clock. We have witnesses too, so we
Thank
are
you.
wasting
I think it
time
says
looking
Sandra.
for evidence that has not been submitted.
Appreciate it.
And
I'm concerned about that too.
I mean,
So can we move on?
Yes.
And how much
Thanks,
longer do you
James.
have to wrap up?
I don't think very long.
Thank Bert noticing. Thank you, Tanisa. It's super quiet in here, y'all. I don't think Clark happy. He pissed off right now.
But when is the last time you went to 14633 Givens?
Actually, on yesterday.
And what time yesterday did you go?
Yesterday around 5:30, 6 o'clock.
Okay. And what was your reason for
Morning
going?
or this is the,
Stalking.
And what was your reason for going?
I wanted to speak to several of the neighbors, just to ask about Mr. Napoleon Harris.
Okay, and which particular neighbors did you, how did you identify which neighbors you were gonna go talk to?
Identified by the affidavits that were presented.
Okay, and did you knock on the door of any of the individuals who, we received affidavits from the candidate of?
Yes.
Okay, and, did you knock on the door of Mr. Ralph Bowie?
Yes, I did.
And what, did Mr. Bowie say to you?
Objection, here's.
Objection sustained.
Well, could I respond?
I'll second that too. No.
Mr. Bowie signed an affidavit. This is, what he said contradicted his affidavit. That is a statement against interest under 804B3. It indicates that he signed an affidavit that is not true. That is a statement against interest. It is an exception to the hearsay rule.
No, it's not.
They just said no, it's not.
Well, is he a witness here to testify?
He is going to be testifying by affidavit.
Well, my motion, asking what he said at this point is hearsay. That's, I move with the objection sustained.
You did. We reserve the right to call Mr. Smith as a rebuttal witness after they introduce that, because we have, goes to the,
He may, but the way that question was phrased is hearsay.
Okay, all in favor?
Aye.
Okay, motion carried, sustained.
And have you been to the Flossmoor address that is on? Have you been to the Flossmoor address that we're alleging Mr. Harris lives at?
1405 Dumfries Street, the Flossmoor?
Yes.
Several times.
Okay, and what did you observe there? Well, let's see, when was the first time you went there?
The first time is on my way to church, about the same time. Me going by.
About the same time as when?
April. April.
Of what year?
Yeah, Mr. Smith, if you can be more specific
April of
in your statements.
2023, when I was on my way to church, I stopped at 1405 Dumfries Street, and I observed the Cadillac Escalade in the driveway with the 15 Senatorial District license plate number, as well as the Mercedes Benz, that's the charcoal, and the white two-door Mercedes Benz.
Okay, and this was in April of 2024.
Correct.
And he's, the witness said 20.
Yeah, you said 2023.
I
Which
meant to
is,
say 2023.
Leading,
He said it was the same time he went to the Givens address.
definitely leading a witness.
there's been multiple timeframes.
Right.
And this is why it's very important, Mr. Smith, that you state the year and the timeframe, because obviously you can see the confusion that's being caused.
Not
So
just the
please
year.
be,
Month
be,
So
be
let's
specific.
clarify the record, Mr. Smith. When is the,
Month and day, if you know, at least the month and year.
what is your recollection of the first time that you went by 1405 Dumfries in Flossmoor?
April of 2024.
And you recall the date?
I can't recall the date. Yeah, I can't recall the date.
Okay. Other than the three cars that you identified that were parked there, were there any other cars parked at that address?
No.
Okay, have you, after April of 2024, did you go back to 1405 Dumfries in Flossmoor?
Yes.
And when was the next time you went back?
The next time was 2 weeks after, which would be April again of 2024. And I witnessed the same thing.
Why he keep going over there?
Cadillac Black Escalade, Senatorial District plates, along with the charcoal Mercedes Benz and the white two-door Mercedes Benz.
Okay, this was again in April of 2024?
Correct.
Okay, when's the next time you went back to 1405 Dumfries Avenue?
That will be May of 2024.
Okay, and when you went to the Flossmoor address in May of 2024, what did you observe?
I observed the same thing. Black senatorial, 15th legislative senatorial district truck, Cadillac truck, along with the charcoal Mercedes-Benz and the white two-door Mercedes.
Okay, and after that visit in May of 2024, when is the next time you went by the Flossmoor address?
2 weeks later of May.
That's really
May of
stalking.
2024. I went back again and saw the same thing.
And the same thing being,
The black Cadillac senatorial district truck, 15th legislative district on it, and the charcoal Mercedes-Benz and the white.
I wonder if they have his schedule when he was
and
gone to Springfield.
after the second time in May of 2024 that you went to the Flossmoor home, when is the next time you visited that home?
The next time I visited was approximately a month after, so that would be June of 2000.
Last time you stalked.
I witnessed the same thing. The black senatorial district Cadillac truck, along with the charcoal Mercedes-Benz and the white two-door Mercedes-Benz.
Okay. Did you visit the Flossmoor address once in June, or did you go back in June?
I went back several times in June. So it would be maybe 2 weeks after, just to see if I saw the same thing.
And you did, of course.
The second time you went in June of 2024, did you see the same thing?
Yes.
And the same thing being,
The black Cadillac truck, 15 senatorial district plates on it, as well as the charcoal Mercedes-Benz and the white two-door Mercedes-Benz.
and when is the next time you went back to the Flossmoor address?
After that, I followed back up in the wintertime, which was around, I say, December of 2024. And I saw the same thing, except this time, the black truck was not out there. There was the charcoal black Mercedes-Benz and the white two-door Mercedes-Benz.
Okay, and is that the last time you visited before, in December of 2024?
No, I've gone, oh yeah, of 2024, correct, yes.
Okay, and have you been back since then?
Yes, I have.
And when did you go back after that?
I went back this year of 2025. That was January of 2025. I went and I observed, this was right after the first snow that we had. I observed the charcoal Mercedes-Benz and the two-door. And then there were tracks of the driveway, as well as there was the footprints of going in and out of the house that I witnessed of the snow. I saw the TVs were on at night. Of course, it's
He's
midnight,
stalking.
so you can see because they had no blinds or anything.
That's scary.
The TVs were on and lights were on.
Okay, and have you been back since that time?
Yes, I have.
Okay, and when is the next time you went back?
The next time I went back was about a week after that. This time I observed just the two-door white Mercedes-Benz. The black charcoal Mercedes-Benz was gone.
Okay, and that's the same white Mercedes that you
Correct.
seen previously.
And it was pitch black. The house was pitch black this time I went.
Okay, and when was that?
That was January of this year.
Okay, how long ago was that? How many days ago?
That had to be about
This is
maybe
January, dumbass.
4 to 5 days ago.
Okay, so was that after Saturday of last week?
Yes.
Okay. And is that the last time you were there?
Yes.
Okay. I have no further questions.
Can I have my documents now?
Absolutely.
Yes, we're still waiting for the documents.
They so
Relating to, what?
the FOIA.
Received through FOIAs.
I went with FOIA requests.
FOIA requests we have from the Illinois Senate. Pardon me.
No, this is the response to the request.
The request, no, we're waiting. I'm sorry.
I think we skipped that testimony, right?
Yeah,
That
but
out.
it's, they have not produced those documents.
Those that you subpoenaed?
Yeah. I'm ready to question Mr. Smith.
Let me just make a statement about the documents. We produced the documents that were responsive to the Freedom of Information Act request. With respect to the Freedom of Information Act request, Mr. Smith sent them to us. And when we were preparing them, my colleague said, am I printing out the emails for Mr. Smith to you? I said, no, those are attorney-client privilege. What we didn't realize is that below in those, so it was not an intentional withholding of documents.
Yeah,
We're still
right.
printing them up right now, but that's what the error was. So, because the underlying communications, like from the State Board of Elections, went to Mr. Smith and then Mr. Smith forwarded them to me, we intended to produce the communications beyond that, but it was all just under the umbrella of, well, that was attorney-client privilege information since it had been forwarded to me. That's why that was not produced for you. So what we are getting the copies of are just the questions he posed to the State Board of Elections, which he has here on his phone, and he can show everybody. And the responses to them, which we gave them the attachments from them, but what's missing is that, can I get a copy of the voter registration document? Yes, here it is. That's the only part that's missing.
What about the documents pursuant to Gracelevi's subpoena?
Those were all produced. The underlying documents, like if the State Board of Elections says, here are the documents, we produced the documents in with our evidence. We just didn't produce the emails.
I'm gonna, if I can, Kansas Exhibit number 36, I'm providing Objectors Counsel with a copy, providing copies to each member of the board and copies to each of the attorneys for the board. Pursuant to the rule.
What number was the exhibit?
36. This is the affidavit of service of the subpoena Michael Smith. And the subpoena has a rider, very detailed rider. It was previously approved by this board. All documents and communications relating to reflecting or evidencing when you started your research inquiry, investigation of the residence or residency of the candidate for the period of January 1, 2024 to date. All documents and communications related to reflecting or evidencing your research or inquiry, investigation of any of the facts. All communications related to obtaining that information. It's a very detailed writing.
And some of the stuff we didn't have documents responsive to.
But when he started, and I apologize, but when he started his investigation is very relevant because, for example, if he did send a FOIA out, he would keep that FOIA and then you would get the FOIA response back and would show when he had information at the time he signed this verified petition.
Well, again, the question of the good faith of the petition, as the Nader case says, is not relevant, and he's not able to question him about those issues.
Yeah, but that's
It's
motivation.
outside the scope of.
Thank you, Fab Queen
That's
Warrior.
motivation. The Nader case specifically says that a subpoena cannot be used to bring someone in to testify what they did to compile the objection.
Except when they verify. And that's Daniel versus Daly.
But Daniel did not involve a subpoena. That was a question of a shotgun objection in a signature objection where the board said, well, the person didn't come in voluntarily and explain to us why this was a shotgun objection. There was no subpoena in that case.
Yeah, there was a subpoena. The board issued a subpoena to compel the objector to attend and serve that subpoena. I was there. I mean, you know, with all respect to Mr. Mullen, my concern here is, and I've made it very clear from day one to this board, where I was going and why I wanted subpoena. And the fact that I don't have the initial, we have testimony, quite frankly, I'll say right now, is so outlandish. All right, I have someone testifying from the stand here, and I'll get into my cross-examination, but I want those documents as to when he started his investigation.
That presupposes that the investigation is only documentary and only documented. And that's not the only way that someone can investigate somebody's residency.
But if there are documents related to it, that's what the request is for, as I understand it.
Yes.
Are we ready for the trust?
No.
Are these documents being produced now, photocopy now?
Yeah, that's a good question.
Well, here's the question. As a government attorney, are they being done on Thornton Township machines, on Thornton Township time, by people who work at Thornton Township? Is that what we have here? Is this another chapter of Thornton Township? They're using taxpayer machines to photocopy material to give us that they should have given us so we could be prepared for our case.
For the record, the candidate, the council, had the expense of actually making all the copies that you all received, the council received. Just, that was privately done, which is proper.
Hello.
I'm posing the question, and I think it's a legitimate question.
I think it's a fair question as well.
This is trial by fire. This is, to a witness who works for Thornton Township. That the taxpayers are paying for now, while the council is producing documents off of Thornton Township. And that's why there's no response back, because it's exactly what they're doing. It's outlandish.
Hello.
I personally find that problematic.
I do too.
I don't know what the board wants to do about that. I don't know, I mean, it's not really within the board's scope.
Yes, I got it.
About, the use of township resources per se for a privately funded objection, but I do not think that that's okay in any manner. So I don't know what the board wants to do.
Absolutely.
It's a difficult thing, to say the least. I think we should have a commitment to repay Thornton Township for it. I don't want to spend the rest of the time, I mean, the point is well taken. You're not supposed to be spending money for the private, and that should be repaid. And I think they need to make a commitment, and I want to move on, because we're getting far afield. And I want to know, did Mr. Harris live in the district, or didn't he live in the district? And all this other stuff is just going way off on the deep end about when did somebody look at it, whether it was there, and we still have to get back to the basic issue.
Absolutely.
So make a commitment to repay Thornton Township, and let's keep moving.
We will do that.
If that's what happened, Jeff says we'll do.
If that's what happened, what are those documents that your clerk just came out? We mean if that happened. It's right in front of our face.
Council, what options do we have in terms of moving this along more quickly, or any enforcement or sanction or whatever?
I mean, unfortunately, as an electoral board, you have limited jurisdiction, so you don't have any ability to issue sanctions or any sort of real enforcement on that basis. You could certainly make certain inferences and negative or positive inferences one way or the other based upon some of those actions, some of the documents not being produced, and then, the attempt to produce it now. So I think that that's pretty much what's within the board's ability, because you are accorded limited jurisdiction. But I do think that both parties are certainly making their record, not only for this case, but potentially for the next level, depending on which way it goes. So I'm sure that, maybe the court at that level could do something more about it. But if that is happening, I state that both as the township attorney as well as the electoral board attorney, that needs to immediately stop. So that's my statement. If that's happening, it needs to stop now. So I think that as, I guess, where were we at before that, before we just got caught up?
Cross exam.
Steve, Mr. Levinski, you
I'm
would like
ready.
to start questioning?
Cross
Mr.
examination.
Mr. Smith, I'm gonna show you a copy of Kansas Exhibit number 36. You have, is that the same document you have in your hand? 36? Yeah, that's 36.
Yes,
And that's a subpoena that you were served with, correct?
correct.
And it required you to bring documents here today, correct?
It required me,
Yes. You're Michael Smith, correct?
correct, and I'm
And the subpoena-
represented by counsel. So
Oh.
I tendered my information to my counsel.
Okay, you tender everything to your attorneys and they have it,
Correct.
okay?
And
But I don't have it, correct? You didn't give it to me, right?
I gave it to my attorney.
Now, Mr. Smith, you're not a private investigator, are you?
No.
And with regard to, your investigation, you sent FOIAs out and you got FOIAs back, correct?
Yes.
And one FOIA was to the clerk, no, sorry, Cook County Clerk.
You said for you to go down the clerk?
Did you send one to the Cook County Clerk?
Yes, I did.
For Senator Harris's voters registration, correct?
Correct.
And that's not this document production, is it? Is it?
Yes.
Okay. And tell the board what the voter registration says.
The voter registration, can you rephrase your question?
Where is Senator Harris registered to vote?
14633 Gibbons Court.
Now, you testified that you visited 14633 on multiple occasions, correct?
Yes.
And you also testified that you visited this property in Flossmoor, correct?
1405 Dunford Street.
I'm going to make sure, we're gonna call that Flossmoor, and we're gonna call the Gibbons Court the Harvey residence, okay?
I just want to be clear with the record. So 1405 Dunford Street and Flossmoor is the Flossmoor, then 14633 Gibbons Court is the Harvey.
Now, sir, during the time period of 2024, when you first started this investigation, you have a phone, correct?
You say I have a phone?
Do you have a phone?
Yes.
A cell phone?
Yes.
What type is it?
It's an iPhone.
iPhone. It has a camera on it, right?
Yes.
It also has the ability to take video, correct?
Yes.
Now, for each of these times, you had your phone with you, right? Each time you visited the Harvey residence, you had your phone with you, right?
Yes.
Did you take a phone, take pictures of each time you visited?
Yes.
Did you produce those?
However, my phone was broken, and so I lost my access to those,
iCloud.
to the iCloud, because I didn't have
How?
my iCloud information.
So you just happened to lose all that, right?
I lost it, yes.
And the same thing for the property, the Flossmoor property, correct?
You said for the
Flossmoor, also.
Yeah, that was all on my.
You just happened to lose all those photographs, right?
Yeah, well, you can't get back into your iCloud.
Didn't save them to your phone?
You can't. With iPhone, you can't save them to your phone. Everything's saved to your iCloud. So when you get a new
Mr. Smith,
phone,
is it your testimony that you're required to save everything to the cloud when you use your iPhone?
you have to.
Thank
When
you.
are
I didn't see the
getting
name.
and accessing another device,
For the $5.
it's not like an Android where it just automatically transfers over. Everything is sent to your iCloud. So I don't have access to that iCloud. I lost that iCloud. I don't have the password.
So
I don't remember.
you have no photographs of what you allegedly saw at either location, correct?
I do of the current time.
So what's the first one you have?
The first one that I had
What's the
was
first
back
one?
when I just talked about in December.
Okay. December of 2024 is the first time that you had photos.
Yes, that I have my phone currently.
After the caucus.
Now, take notes? Remember, writing down every time you went to either of these properties?
Did I take notes now?
And I have to tell you, your testimony, you're going by every 2 weeks, right? Is that your testimony, sir? Yes or no? And the purpose of that is to show that Senator Harris does not live in Harvard, correct? And it's your testimony, you took no notes.
No, I took no notes.
Now, sir, where are you currently employed?
So where am I?
Employed. Where are you currently employed, sir?
I'm at home. I work from home.
Okay. Who do you work for?
I work for myself.
Sir,
Can you rephrase your question?
are you supporting Tiffany Henyard
Objection
for the office of
made.
supervisor in this election on April 1, 2025?
You've got an objection.
She has filed intent to be a write-in.
She has. Objection overruled.
You filed what?
Intent.
Intent to be a write-in.
It's a government document, so I think everybody can take notice of it.
Do we need to go on?
Yeah,
Or did we clear?
Well, I didn't, what is the objection? Just that,
I think we then elaborated on the question.
like, are we good or?
Can we re-ask the question, because there were too many people talking and I didn't really
Mr.
answer the question.
Ladizinski, could you re-ask the question?
With regard to who you're supporting for the office of supervisor at the April 1, 2025 election, are you not supporting Tiffany?
I'm not understanding the question. What is your question?
So you're about politics, sir, correct?
I am, but I thought this was about Napoleon Harris.
Are
Where
you,
does Tiffany Henry come in?
sir, are you supporting Tiffany Henyard for the election to supervisor Thornton Township on April 1, 2025?
I'm still not understanding.
What is not to understand?
Rephrase your question.
So I think the question's fairly clear. He is asking if you are supporting Tiffany Henyard in the April 1st, 2021 general consolidated election. Or sorry, 2025. Now I'm backing up. I'm sorry, 2025 consolidated election. Does the board agree that the question is clear?
Yes.
I don't know if it's relevant, but it's clear.
Yeah, but we don't have an objection pending right now, so Mr. Smith, you have to answer the question. It's a yes or no?
No.
Are you supporting Christopher Clark in his effort to become township supervisor for township at April 1, 2025 election?
No.
So, sir, why did you, a year ago, or more than a year ago, allegedly start this investigation?
Hello.
I was gonna answer that when I was going through the meeting that we had and why I was going to do that.
Well, let me ask it this way, sir.
Okay.
With regard to this investigation, you knew it was important, right?
You said what now?
You knew it was important,
Yes.
right? And you knew that you were going to file an objection to Napoleon Harris, correct?
Correct.
And with regard to your FOIA request, the first time you sent FOIA requests out based on your testimony is in December of 2024, correct?
Correct.
And with regard to the investigation that you allegedly put together, it's based on your testimony and whatever documents that you obtained from FOIA, correct?
Not just from FOIA, but just from public lookup as well.
Okay. Well, with regard to lookup, you also found documents evidencing that Napoleon Harris lives in Harvard, correct?
No.
You didn't find any documents at all. Take your testimony?
That's my testimony, I did not.
How did the voter registration card?
That was something that was FOIA. That was not a public search.
Thank you,
What
Mr.
I found by public
I
search
can't even read your
was
name.
that
I'm in.
Napoleon Harris.
I'm sorry. I don't have my
was
glasses on.
At 1405 Dumfries Street. in Flossmoor, as well as he changed his business entity to the Harvey address about a year ago, which he had at 1405 Dunlop Street. That's the beggar's pizza. I also found that it's under a federal lien from the government. I found that document, as well as I found a mortgage, a document, a deed that showed 1405 Dumfries Street was transferred to Napoleon Harris. That was online. I found a tax document that showed Napoleon Harris home at 1405 Dumfries Street in Flossmoor, Illinois.
And what years were those documents?
You said what years?
What years were those documents?
The year for the deed transfer, I cannot recall the date of it.
Was it 2024?
I can't recall.
Sir, with regard to the information that you obtained from all your FOIAs and the investigation you did, you don't have a dispute that Senator Harris owns a property in Flossmoor, correct?
You said I don't have a dispute?
Yeah, there's a property he owns in Flossmoor, correct?
Yes.
You've never been inside the Flossmoor property, correct?
No.
You have no idea who's living there?
That's not correct.
You said what now?
It's not correct.
No, I've never been in the inside though.
I just wanted to clarify your testimony.
No, I've never been in the inside. That's what I meant.
And you don't know who physically lives in that house, correct? From your own eyes. Correct?
I've seen the vehicles.
You've seen vehicles there, of course, you don't have photographs of those vehicles, correct?
I do have the photograph of the vehicles when I went in December. Yes.
And the vehicles in December, I don't see any photographs from December. The only photograph I have from December is Objectors 15. If I may approach, did you take this photograph?
No.
I have no photographs. Are there photographs, councils? For the record, I would request at this time that council put in my hand this alleged photograph that he claims that he gave to, no, we're talking about the Flossmoor property. That's Hardo.
And would that be the group exhibit 15?
He said he did not take those.
Sorry. He getting cooked. Keith looking mad. Keith is not happy. Tell him he not supporting Tiffany Henry when you on the news with her every time she get on the news. Dude is a whole clown for that one. He does not look happy. Y'all want him to be y'all trustee in Riverdale? I'm sorry.
So
maybe
what
she-
I have is I've been tendered a document I'm gonna mark as Kansas exhibit number 48. 48.
apologize, I do not have copies for everyone as this was just provided to me.
That's just the last 3 pages of what was the exhibit. I think the first 2 pages were combined with it, not mistake.
Okay, so I'm gonna break this out as 48.
You're labeling each page A, B, C, D.
I'm just doing this one page that just provided to me. So, it's 48. I'm 4, sorry. Copies for everyone.
We have that as 15.
With regard to Candace exhibit number 48, Mr. Smith, is this the photograph that you took of the Flossmoor property, correct?
Yes, this is one.
Okay, and is your testimony this was taken on January 15th, 2025?
No,
What time was it taken?
this was in December of 2024.
Well, it says Flossmoor, January 15th, 8:12 p.m.
Yeah, but I took a picture in December of 2024.
Is this the picture you took in December of 2024?
This is one of the pictures, but it wasn't done in January.
This is the only picture I have that you took related to the Flossmoor home. Okay, is that correct?
That you had, yes.
You may have more, right?
I don't have,
Objection.
I told you.
He produced everything that he produced to us, and you have more than one picture. It's more than one picture that he produced. It's
So I said, you're exhibit 15?
What's your specific objection?
Because you're asking the witness to ask questions.
Second.
All in favor?
Aye.
Objection overruled. You may continue, Mr. Stein. I'm losing my. I'm just gonna go first names.
Mr. Smith, Kansas exhibit number 48 does not show any cars in the driveway, does it?
That's from that angle.
But I don't have any pictures from you, correct? Showing these alleged cars you allegedly seen on any day at Flossmoor, correct?
You have this picture here, but it's not that angle. There's another angle. It shows the car.
Sir, I'm gonna show you what's been marked as Kansas exhibit number 45. Providing copies to the board, copies to the board's attorneys, copy to opposing counsel, and Mr. Smith. Mr. Smith, do you recognize Kansas exhibit 45 as one of the documents that you received in response to a FOIA that you sent to the Federal Elections Commission?
No, I didn't receive any documents from the Federal Elections Commission.
But you FOIA the election.
Yes, I FOIA, and what they told me to do was to take a look on their website, and I'll be able to find it.
Did
However,
you find it on the website?
I could not find these on the website.
Do you recognize that document to be from the Federal Elections Commission?
Yes, it says it's FEC Form 2,
And who's that for?
Napoleon Harris.
And what's the date of that?
November the 2nd, 2015.
And what address is on there?
14633 Givens Court.
The Harvey residence, correct?
Yes.
Mr. Smith, have you ever been convicted of crime of dishonesty?
No.
You've never been convicted of theft?
No.
You've never been convicted of stealing gasoline from the village of Dixmoor?
No.
It's your testimony, you've never been convicted?
That's my testimony.
Were you fired from Thornton Fractional High School District?
His character.
Second.
All in favor?
Aye.
Overruled. Okay, 2-1, overruled.
Sir, were you ever fired from Thornton Township fractionally?
Can you rephrase your question?
Have you ever been fired? Let's start that one.
Fired from what?
A job.
Yes.
Were you fired for lying on an employment application at Oak Park River Forest?
No.
Were you fired anywhere for lying on a job application?
No.
Were you fired for failing to disclose past history at a school district?
Yes.
And which school district?
215.
And what were you fired for, sir?
Wasn't that I didn't disclose it. I was fired because they said that I could not work within a school that was in the Peter District of 215. That's why I was fired.
And were you fired from 215?
Yes.
What were you fired for?
So what was I fired for?
What were you fired for?
Because of an accusation that was later cleared up by the DCFS.
It's your testimony, sir, that you were never fired. Sorry, were you fired from the village of Township?
No.
Were you ever criminally charged with theft for the village of Township? Any municipality? Now, I think two last questions. That's just that. With regard to your testimony here today, have you had any conversations with Christopher Clark about employment?
Rephrase your question again.
Have you had any discussions with Christopher Clark? If you become supervisor, you'll be employed.
No.
Final question, Mr. Smith. At any time, when you were involved in this investigation, allegedly claiming to perform, did you have anyone with you?
This is my wife. And at other time, Keith Price.
And I've not seen any pictures from Keith Price. Are you aware of pictures from Keith Price?
We submitted our pictures.
Oh boy, here we go. I'm sorry, y'all. More figure.
What exhibits?
The exhibits, yes.
Those are the only photographs that you have related to the Floss Farm property, right? I know.
That's the noise, y'all.
Who's copiers?
I have to put it up record that
That's their copy.
the objectors are copying things that they may or may not use or give or not give us in the back of the room, which is very distracting while you're trying to be able to witness. Extremely, excuse me. But please let the record reflect that objectors counsel are photocopying from a photocopy machine in the back of the room.
They
And
really
I guess
are.
they have, are not using the Thornton Township equipment anymore. Now they're using some other equipment in the back of the hearing room, the trial.
And it's super loud.
It's very frustrating. I'm sure.
Thank you, Dallas.
This is the first time I did hear earlier. This is the first time I've ever seen this happen in a hearing. Let's just try to get through this, I guess.
This is a document that it was responsive to this.
Well, hold on, let me go with the class.
I'm done for talk.
They are very unprepared.
What's going on with this exhibit?
We hope it's gonna be marked for something that's gonna be discussed.
Okay, I can sit back down. Sorry, y'all. That was loud.
For the record, I'm being handed Linda's exhibit number 5, which is the first time I'm seeing it.
5 already has a number. It's
It sure do.
I apologize. I did see exhibit 5, but it's in a different form.
They are not prepared. Is it almost 5 o'clock? It's 4:20.
Mr. Smith, I'm going to show you this from Marcus Plan to do it 6. Have you seen that document before?
Yes.
Is that the picture that you took in December of 2024 at the Baltimore?
Objection, this was not provided to us.
That one might have actually been the document dump.
I don't know.
It was not.
But it's responsive to Subpoena, which is available today. So even if it was not in the documents,
It's returnable before the witness takes the stand. That's why I asked for the documents.
And they first said it's coming to, that they gave it all, and now they're saying, oh, well, maybe we didn't. But that it's returnable mid, I'm read the record. Come on.
What does the board want to do? You want to allow questioning on this document, accept the document, reject it, what do you
I don't
want?
have enough foundation to make a decision on that. I don't know what it shows. I don't know that it's an accurate representation of what it supposedly shows. There's no foundation to admit it.
Okay. Take a look at Plaintiff's Exhibit 6. Is that a photograph that you took?
Yes,
And when did you take that photograph?
in December of 2024.
And what is the photograph of?
It's of the charcoal Mercedes-Benz and the white two-door Mercedes-Benz.
And where are they?
They're 1405 Dumfries Street in Flossmoor, Illinois.
And is that an accurate representation of what you viewed on the evening in December of 2024 when you took that picture?
Yes.
I have an objection. Move to strike all the testimony. This document was not produced. No. You know, this is a residency case, and I would count this as like really critical, testimony and really critical documents that I would want to make sure the other side had.
All right, to the people in the audience, we are streaming off of Mrs. Vivian Allen's page. I cannot control what she says. We are grateful for her to be down there all of these hours. We've been streaming for 5 hours, and I believe she's been down there from the beginning. I'm with you when it comes to talking. I'm saying the same thing in my head, but I have to give her respect. So let's be grateful at least that she's down there. Yeah, and y'all know me. Y'all know Grace. Me and Vivian eye to eye. But come on, be nice. You know what I'm saying? And I understand it's annoying. It is what it is. But we getting the meat of it. So let's play this. I love you guys. Be respectful in the audience. We grown and sexy here.
A second.
I move to introduce this into evidence.
I think that we can take it in. I don't think it provides much support of anything. It's a one-off picture.
A couple of questions. For you, sir. At any time when you saw these Mercedes cars, the dark one and the white one, your investigation, did you know the license numbers of them?
No, you cannot, because it was.
Not on this picture, at any time.
At any time, you cannot, because of the way that it was, and I was not.
What do you mean the way that it was? What does that mean?
Because how you have to get into his property is like he's on a dead end. And so I was not going up on anybody's property. I stayed off because that is trespassing.
When
So I
you
will
saw,
not trespass on anybody's property.
when you saw the cars you identified as seeing at Harvey, did you note the license number?
Yes, I do.
Okay.
Mhm.
What were the license numbers
I have it in my phone, of the picture of the car that sat in the driveway.
in Harvey?
Yes. And it was not a Mercedes Benz, it was not a Cadillac Escalade. I believe it was a Nissan Maxima.
Do you can't read the license numbers on this picture, Exhibit 6, can you?
No.
How do you know they're the same cars?
Because I see that car all the time, that I have been over there several occasions. I've seen it at the Beggar's Pizza, sitting in the driveway. I've seen him personally drive that vehicle. I've seen him at the polls on election
If you
day,
can't identify the license number, how do you know it's the same vehicle?
because it's a black charcoal Mercedes Benz, and it's a white Mercedes Benz with 2 doors.
Okay, I move admission of this photograph be denied.
Thank you.
I don't think the photograph matters. I think he's testified to what he's seen, and we give the weight to the testimony that we give the weight. It doesn't matter.
So you move to admit?
Yeah.
I'll withdraw my motion, I'll second that, and I'll consider it for whatever way it may be worth.
Okay, all in favor?
I,
Motion carries. Claims exhibits.
They don't have no weight.
Is admitted. Real quick before we go on, candidates exhibits 45 and 36, are you guys looking to admit those as well?
Yes.
I move to admit both candidates exhibits 45 and 48.
45 and 36.
36.
but the thing is, I thought you were limiting everything to 2023, and this was 15 is dated November 5 of 2015.
Pardon?
Candidates exhibit
What 15?
Candidates exhibit, the very top.
Are you talking about 45?
Yes, it's dated November 2nd, 2015.
Right, but I think that this was being submitted as number one in rebuttal and
Rebuttal to what?
rebuttal to Mr. Smith's testimony. I don't think that this was being submitted to show that he's,
I think it's being
A resident.
submitted to say that he's renting our property.
Mr. Ladizinski, what was the purpose of candidates exhibit 45?
He said he requested documents from the FEC regarding Napoleon Harris. He said he conducted all this investigation. Here's a document that clearly shows the Harvey address appearing in documents going back to 2015.
So it's in response to his statements related to his investigation. Any response from objectors counsel?
Yes, it's not in the time period that the staff issues relevant.
Except he testified about the Flossmoor property when it was purchased, going back in time. They've opened up this door now, and this was what my whole motion was about, is in a residency, if they're contending there's no physical presence somewhere, that means that he had to abandon something, okay? My argument here is very simply this, is that this witness comes on the stand and talks about what he reviewed, got public documents. He sent FOIAs that go back in time, and he's providing this testimony based on what he reviewed, and selectively omits documents that support my client's residency in Harvard.
We don't have an obligation to provide documents that support his residency. He testified he never received this form. There's no foundation for this form. It's outside of the scope of the time period that the board has determined is relevant.
Okay, so what does the board want to do? We have a motion and a second, but then member Asfeld had pointed out that she felt that this was outside the time frame. So what does the board want to do on this?
I'll go along with that.
Okay, all in favor?
All right.
All right, it's admitted. Okay,
There's one question I have left for the witness. I apologize.
Well, I would object to that. The witness has been excused. accused.
No.
No, he hasn't. He tried it.
Thought I heard that.
No, you didn't.
Getting late.
I think that's it.
I'm gonna provide the board with the actual certified copy of the document, and I'll provide so it goes into the record. And provide copies to the board of Kansas Exhibit number 2.
Thank you.
Objective counsel. And Mr. Smith, do you recognize this document?
Says certificate of registration.
From, you know who the Cook County clerk is?
Sorry.
Yes,
And you've seen these documents before, correct?
yes.
And this is for Napoleon Harris.
Keep
his
still here.
registration. Could you read it out loud for everyone?
His registration is 14633 Gibbons Court, Harvey, Illinois, 60426.
And also has his voting history on there too, correct?
Correct.
And it shows that he's been voting at that address, so let's just focus on the period of April 4th, 2023 to today's date.
Well, I can't say that he's been voting here because we don't have the change history. The change history will show, by me doing objections a long time, they wouldn't give us the change history, which would show, the years that he changed his voter registration.
That
Because
don't
we know
matter.
at, some point, he did change his registration. He wasn't
only
here
1 year.
since 1997, because those were not, built then in 97.
Mr. Smith, did you request a subpoena to the Cook County Clerk for their change record?
Did I request a subpoena?
Yeah.
No, I just did a FOIA.
Thank you, Maria.
Further, I would move Kansas Exhibit number 2 into evidence.
Any objection?
Yes, objections. It's a record that says it's for Napoleon B. Harris, and our objections to Napoleon B. Harris III. There's no birth date on here, there's nothing identified, there's several different Napoleon B. Harris, 1 through 4. This doesn't tie into this particular project.
So you're claiming a different Harris lives at the property in Harvey?
No, I'm saying this doesn't say that it's for Napoleon B. Harris III.
That doesn't matter.
You know how many people in nurses are working for that property? Like,
That's voting.
Because relatives, they have different numbers, at least one before they go.
We accept candidates on exhibit 2 and get
Thank you.
All in favor?
Aye.
Okay, so your exhibit 2 has been admitted.
I will be obtaining, if this goes much longer, I will be requesting the submission of a certified conviction for Michael Smith to present to the board. I would never would have thought that Mr. Smith would have.
Perjured himself under oath.
You have
I mean, I would say. present
I
it
do not
now.
have it ready.
Okay, oh, okay.
Look at God.
Okay, anything further from?
That fool just lied under oath. Y'all see that?
Okay, all right, anything from the board, from Mr. Smith?
If y'all can't see, his temple is raising like he mad than a motherfucker. Excuse my language.
Yes.
He mad.
And I like to.
I hope he show us.
There's no question pending. This is not an open forum. You can speak in public comment.
I
if you
will,
want.
I'll speak in public.
So your excuse.
Thank you for today.
Okay, next witness.
Public comment gonna be lit. He gonna cry in the car. Oh my God.
We're asking to file this.
Do you have a copy for a lawyer?
They don't make copies to save their lives. This is almost as good as the township meeting.
Yes, yes.
Oh my God. He is mad. They sitting over there having a little huddle. Him and Keith Price.
We just received it now.
He mad. Yeah, he is mad. He fuming.
Okay, what's the purpose of this
So
document,
the
Mr. Mullin?
purpose of this is filing an affidavit of service on Dolores McGee. Ms. McGee was served. She was provided with witness fees. I spoke with her at length. She said she was going to be here at 11:30 today. She did not appear. And we're gonna ask the board to enforce that subpoena.
Who is she and what's the relevance of what
She
she would be
is the
testifying
person
to?
that lives in 14637 Gibbons, which is the building that is attached to Napoleon Harris's alleged address in Harvard.
What do you think? And just for the record, I can also state that Ms. McGee did call my office and she was, because everything was returnable to me, so that way, just make things a little bit cleaner and easier. Ms. McGee did call my office on Monday or Tuesday, and she did in fact say that she did plan on being here. I don't know what happened, but she did say that she did plan on being here, just for the record. I just, want to put that out there. But she did seem a little annoyed. But she did say she did plan on being here.
Was she here?
I have no idea. I have no clue what she looks like.
She was not here.
Has anyone called you?
She would not give me her phone number.
Oh, well, we have.
I don't blame her.
Yeah, she said she would be here at 11:30. She said, I told her I would request that we call her first and let her get out so that she could go back to work. And she said she would be here, and she did not.
What does the board want to do? Does it want to?
They subpoenaed
right now,
somebody
where
that
we're at
lives
is
next door to
Mr.
Napo
Right now,
in the Harvey address.
Objectors Council has basically requested that we do a enforcement of the subpoena, which means that I would need to go into court. Going to court, I would have to work over the weekend, and honestly, I probably have to have somebody else go into circuit court because I've got something else that's gonna keep me completely unavailable Monday. That, no offense to anybody, is more important than anybody here. But that said, so the board, does the board want to go forward with the enforcement of the subpoena or no? And again, this would require me to go into circuit court, ask the circuit court judge to enforce the subpoena that would need to be served again, then we would need to get Ms. McGee here. But it all goes to whether the board feels that this evidence would even be probative of anything. So I think that's the first thing that the board needs to see is, do they think that having this individual come and testify is going to demonstrate something based on what Objectors Council has said?
Hear from each council as to what they think this witness would testify to, so determine how probative it might be.
I think that's fair.
So Ms. McGee owns the property at 14637 Gibbons, which is attached to 14633. She has owned that property, she said, for 13 years. I showed her a picture of Mr. Harris. She said she had never seen him before. She said she believed that the unit next to her was vacant, that the lights were never on in the evening, that there was no noise coming through the window or through the wall, and that she believed that Mr. Harris, that I described his cars. She said she'd never seen any of those, and that would be her testimony.
First of all, with regard to this document, we filed all our affidavits in service of our subpoenas. We've identified them as exhibits. What is really troubling is now there's an affidavit from Mr. Mullen that he wants to be a witness in this case and testifying in this case, which is totally inappropriate. They had their chance. You know, this investigation based on Mr. Smith's testimony has been going on for over a year. And the first time there's a conversation with this witness is after they issue a subpoena. I find it trouble.
You know, no one will talk to you before the subpoenas. You know, it's not unusual. And you know, I was there, you know, 36 hours ago. She said she was going to be here. Had a long conversation with her. Made sure that she, you know, had been served, that she had gotten the check. They filed their certificates of service this morning by email. I needed Ms. Kraft-Hepper to notarize it because I couldn't find a notary. That's the only reason it was not filed earlier today, because I went to the notary place on my way to the office this morning, and the notary was not there. Their affidavits of service were filed with the board this morning.
So I find my difficulty with this is we are now at 4:40.
Oh, wow.
PM. This is hearings going to 5 o'clock. And with regard to these witnesses that they claim they have under subpoena and people won't talk to them, I find it very difficult to believe when the attorney was able to simply tell someone from the city of Harvey to show up and talk about water bills without a subpoena. They, you know, the one thing that's very clear, they have no investigator disclosed as a witness in this case, and that's how we prove these cases. Is there an investigator?
Will Major, he's the one who got deposed today and can't be here.
Well, that's about service subpoenas, not about the investigation.
Absolutely.
So what we have here, and I'll go back to it, is malicious mischief. We have Michael Smith's testimony. And now they're saying, well, I've talked to this witness and this witness is going to say this, but this witness won't come in. I already know there was another witness here earlier that had to leave because he's not going to sit here for 5 hours.
You know, that witness probably has more benefit for us than Mr. Smith did. And I think that an affidavit, I hate to see you having to go to court. I hate to see what happens to drag her in here. Can an affidavit, if we can receive an affidavit from Mr. Harris, why not from a witness?
I don't know that she would give it.
The problem with an affidavit, there's no opportunity to cross-examine.
But that's the same problem we have with Mr. Harris. He's not.
I haven't seen the affidavit from Harris.
And we would be objecting to that, but we will because of our inability to cross-examine him. We would agree that they have it, but I don't think we do.
It's a two-way street.
That's right. And Judge, respectfully, you have rules. Rules allow for affidavits. We produced affidavits of the neighbors, not of this lady, but of other neighbors. That's what electoral boards do. You have affidavits. This is not a court of law. Close, but not quite. But you have we produced our affidavits. We stamped them all. We gave it to them. And again, I hate to keep parading this. This is trial by fire here. Again, using Thornton Township material to.
You've made that point.
Thank you, sir.
And that is not using Thornton Township material.
Excuse me, all those documents were on photocopy machines from Thornton Township. Please.
I have not seen the affidavits you just referenced.
And under,
Because they haven't put on their case yet.
under Rule 10 of the board's rules, under Rule 10 of the board's rules, you've adopted rules, and they say the party does not respond to a subpoena, that the board has the ability to require the person to be here. That's what we're seeking. We have a case to put on, we have a burden of proof. We have served subpoenas, and the people haven't responded. So the whole issue about affidavits later, you know, we chose not to produce an affidavit on this person because we believe their testimony needs to be there. And I agree with the comments from the bench that was good for the goose is good for the gander. If we want people here to testify, they have the ability to cross-examine.
Thank you for
We
being
get Senator Harris should be here, so we can cross-examine him. And we have serious concerns about the affidavits that they have produced, and we'll be producing rebuttal witnesses who actually interviewed those employees.
It's Michael Smith.
Michael Smith.
Michael Smith's gonna come in and tell you.
Michael Smith, Nate Fields, and Keith Price.
Yeah, that's.
Malicious mischief.
Yeah.
Okay. All right, now, jump back to the point. So it gets back to
The board,
it gets
the
back,
board is talking.
it gets back to if any person served with electoral board subpoena fails to honor it, comma, the electoral board may seek judicial enforcement of the
Okay,
subpoena.
please stop now. Otherwise,
I'm
you'll
not
be
talking to
removed.
you, I'm talking.
No,
to
you're
Keith
talking,
Price.
you're interrupting the
I'm
proceedings.
talking to Keith
You
Price.
will be removed. Enough.
Leave the room.
So it's a may. And the question is,
Look at them.
I hate to see a citizen being dragged in here, but I don't know what the other options are. If there's another option such as.
We don't have to force it. I don't think her testimony is going to be what you're looking for, considering she won't come in.
Well, I think it could be. It could be, she just doesn't want to.
Right, so she's not gonna say what they want her to say.
No, I think she could say what they want her to say, but she either doesn't want to, or she's afraid to, she doesn't want to be involved. I mean, there are other reasons why she may say exactly what he says, but she doesn't want to be in that situation.
Can we table this until I hear the candidate's evidence?
Our position is we're gonna be moving for directed finding.
That's why we need the ability to actually put on our case. We have the burden of proof. We have witnesses. We have witnesses we've served who have not shown up.
But, so, you can't have the testimony both ways. Mr. Smith testified that he started this investigation over a year ago. His testimony, he's a party, he's a plaintiff. We have no documents from that investigation, but he said it. All right, so what have they been doing for a year? What have they been doing? Nothing.
Hello.
It is a discretionary question up to the board. So Rule 10 provides that if any person served with an electoral board subpoena fails to honor it, the electoral board may seek judicial enforcement of the subpoena as provided by law. So this is completely up to the discretion of the board. I do understand both sides of both arguments. So it's really what the board feels in its discretion as the finders, fact, and interpreters of law.
If we decide we want that subpoena enforced, it is going to be at least a week, I would guess, before anything could be enforced or done. Because you prepare a motion Monday.
Well, no, my daughter's having surgery Monday.
Well, your colleague can. And it would be probably Wednesday at the earliest before we can get before the judge.
Correct.
And take several days before somebody could serve the court order if the judge ever enters one.
Yes, I mean, logistically, it would probably take at least a week as it relates to drafting, filing, getting before the court, and having that subpoena then reserved upon the recipient of the subpoena. So I think, logistically, it would take at least a week.
Well, this would be a court order to be served. And what is the drop dead date for including the deliberations here in terms of rule and getting something to the county for finalizing the ballot?
I don't know that offhand. Let me see if I can find that. Yeah, I believe early voting begins.
In our case, the state's attorney said February 25th.
February 25th, that's right. I knew it was around mid to late.
That's when early voting starts?
No,
That's the date she said the judge had to rule.
So it's got.
Yeah, early voting.
Got an on the ballot or off the ballot decision by February 25th.
So if I may, this actually came up in one of our other cases, and where Maurice DePouza did check in with Mr. Nally, and it said that the clerk is printing the ballots by February 20th, 2025, and I have an email if needed.
February what?
The
20th, 2025.
Right, but they don't print
Thank
all
you.
the ballots at once, right? So they can hold up,
And then the mailing ballots are February 26th.
they can hold up, and it's all done electronically now, so they can have everything typeset. And Marie said, Mrs. Mancuso, the state's attorney, said the 25th. I believe that was in one of our cases.
I could show you the email. Okay, well, so sometime between the 20th and 25th. So either way, it's right around the corner.
Yes.
I think that we can all agree that
If it's between the
time is
20th
pretty,
If it's between the 20th and 25th, that tells me we have to assume it's the 20th.
I would say that that's a fair assumption, yes.
Mhm.
And just for the record, early voting in Cook County for the April 1st election, according to the Cook County Clerk's website, does start March 17th. It goes from March 17th to the 31st. But obviously, there's stuff that needs to happen before that. You know, the ballots need to be printed, they need to be programmed, overseas ballots need to be sent out, military, exactly. So that's, I think those are the dates that they're referring to, is the date of finalization, so that the Cook County Clerk's Office can start doing all those things and get all the people that have requested a mail-in or a overseas ballot or absentee, so that they can get their ballots.
So getting back to the idea of going into court, you're saying that it would be Wednesday before you could go in. So we're talking about, it bothers me that she doesn't show up. And so there's a question as to, it bothers me that she doesn't show up. It bothers me that the sheriff is going to go in and do something. You know, so I'm tossed either way. And then the question is, how many other witnesses are there who would testify to the same thing?
She is our only witness from Gibbons Court.
Well, she's the only one from Gibbons Court, but she would be testifying, she's never seen him there. Are there other people who would be testifying either that they've never seen him there, or they've only seen, you know?
No,
Well,
she's,
we have other subpoenas that they bring up. We have other subpoenas also that we're seeking to enforce, not just this one.
Miss Graham was available. She's not well, but she's available.
I mean, she's available, if she's not showing up.
No, this is the issue of your subpoenas and someone dropping off a check. She's available, but, you know, she stopped by before and it was going on for hours. She's a diabetic. So she's available. They could have had her.
Wait, I think you said that she wasn't here at all.
I didn't
We didn't know
know
she
that
was
she
here.
was here.
And she did not go back in the witness room.
She showed up at the building. Yeah, she, in her car.
Well, we're not told that she did not appear for purposes of testifying.
If she was here, then I would suggest we find a time when she will come back to testify short of going to court.
Can she come back today?
She could be here in 30 minutes.
Dirty.
And she's one of the objector's witnesses, or your wife,
but
How is it the candidate's attorney knows more about this than the objector's attorney?
There's a lot. You prepare for trial.
Well, I know you prepare for trial.
we're all on the record here, so this conversation is still on the record. We have other business we can take care of if you can get her in here in 30 minutes.
Are you gonna vote on the subpoena because for me, Ms. McGee is a more important witness than Ms. Graham.
Oh, I forgot, we're not talking about the same person.
We're not talking about the same person, no.
Well, okay, so what does the board want to do on Ms. McGee?
I don't, we'll have a conversation. I don't know that we need to take that 30 minutes, but if you could vote on the issue about Ms. McGee, and then we'll have a conversation.
Before I authorize, we'll consider enforcing a subpoena against Ms. McGee, I would want to know whether her testimony that you proffered to us might be cumulative, and therefore the enforcement procedure would not be necessary.
Okay. Could we have a minute?
Yes.
Thank you. the record.
All right, guys. So I know a lot of you saying that you can't hear allegedly. Y'all just got to put your Bluetooth on and turn up the volume. Again, I really believe that she is the only one that's down there right now. I know people in my audience not feeling all of that, but at the end of the day, you know, I'm for the people, and wherever I can get my clips from, I get it. So I hope she don't give me any attitude or anything. But with that goes to say, there is a lot of information being put out here, and this shit is long. We've been on for 5 hours. So what I'm doing, as y'all see, I'm in the audience breaking things down as it happened because some of you guys can't hear it allegedly, but I can hear it really clear. But I am just to give y'all a small breakdown. She's on the screen, so I know my audience not too, you know. I heard y'all talking stuff, but y'all know I'm a real person. You know, people are who they are. And I deal with them accordingly. So, with that goes to say, y'all done watch what happened. Catch a Dog Smith. Let me put his ass on the screen. They doing a little break. Catch a Dog Smith was the number 4 witness. Put that little monster on the screen. And basically, Catch a Dog Smith went up there acting like he was an investigator. Shout out to all the audience who is on it like kryptonite. They were saying, is he an investigator? How has he been going to Napoleon House when, you know, all this time? So allegedly he's been stalking Napoleon, trying to see if he lived in that false mall address. And he's saying that he didn't. He used a lot of contradictory statements. And then lied and said that he had pictures on his iCloud. Shout out to the audience member. I don't have your name right now. Please bear with me, y'all. My temperature went up. It's 100.3, and I'm still rocking out with you guys. I don't even know why I went up, but I'm doing good. Love y'all. Hit the like button. It's all worth it. But with that goes to say that our cloud can be retrieved. So this buckets basically lie, you know. But then I want to re-listen. Hopefully we could hear it louder. They did allegedly said that Clark, which was, I think he was number 2. Let's put him on the screen. This freaker, the Harvey Mayer, the monster looking all scary. Allegedly he lied, and I would assume that has something to do with him making his statement that he heard or have third-party knowledge of Napoleon living in that particular area. Remember, if y'all wasn't here, basically he said that he has direct knowledge, and he is the one that is contesting. So one of the audience member did say, hey, how is he contesting, or how is Catch a Dog Smith on the stand, and he's one of the objectors. So basically, he did the same thing with the Nate case, where he went and testified like a damn fool, making a fool of himself. I don't understand why Catch a Dog Smith, him looking all disformed here, think that he's so smart and his testimony is actually like word, like his word is born, like it's credible. It's really not. So all that he's doing, that this goon is sending him to do, I really believe is obsolete. And this is just in regards to everything they've been doing. It's obsolete because that man is retarded. She could have did better if she had KP. But y'all been watching just like me. KP kind of falling back, trying to figure out what the hell going on. I think we'll just keep our eye on what's happening with him. So, number 3, if y'all don't know, that witness was the water director. We went over the water director. They were trying to establish if that was Napoleon address. And as I mentioned to you guys, she did admit that it was Napoleon address. But what they established is that they were getting estimated bills. So those estimated bills still don't reflect if someone actually lived there. And allegedly at them times when they were getting estimated bills, they had it as vacant. So just keep that in mind. That was the 3rd witness that was up there. 1 point for the objectors for that one. It says, because the water bill, they added the water bill. They added that bill as proof. As well as they added the work order. But like I said, I think that was 1 point. Honestly, it kind of went both ways. I think it was for Napoleon because they did admit that the billing address that we're using for Harvey Water bill was going to the address where he was claiming. So even if they're trying to establish that nobody lived there, that's what they were trying to do with the lady. And now the lady who showed up, it's still, that testimony is not strong at all Let me put this back on the screen. She's not on the screen, so please, y'all don't get dismayed. I know it. We just all work together. Y'all over there catching the fit on me, and I'm just trying to work with everybody. I love you guys. All right, so number 4, going back to Smith. So he testified and lied. Y'all think he lied? Y'all remember when he just said that he never got fired from a school by putting a false application out? This was something that was reported allegedly, and he's saying it didn't happen. He's such a liar. And then also, Catcher Dog Smith did not provide none of the FOIA requests that he said he was looking for. Now, why is it on your iCloud when you can literally just go to your email? A lot of the FOIA requests, even if you write it on a separate piece of paper, y'all know I have been getting well-rounded in that. I could always just go to my email where I sent it. You get a notification of receipt, or you sent it straight from your email. So another thing, he's just lying. I really think that's why that Napoleon's actually going to win this, just because of the lies. You know what I'm saying? Just once people of a panel and a jury see that things are being cut through and lies are being told, no matter if the person may not live there, all it is that people are lying, so they're making the whole stance uncredible.
Thank you.
So I'm still listening. It don't look like they started right back yet. They talking to each other. And as I mentioned, guys, we've been on this for 5 hours. The first live started with Critical Smoker, and he had to go to work. And then I went to Reality Check TV, and he had to get out of there. And then I did see Miss Vivian was on, so I had to just say, bump it. Let's get it, because I want to try to get a full broadcast. And also, I like to break things down in the middle of the intermission. It's all about us, having critical thinking skills and coming at it like an adult. So shout out to everybody in the audience, adding your two bit. Y'all talk about me making predictions. Y'all asses down there making prediction. Like I told you that this monster. Can I put the real picture of Keith Smith? Sorry. Keith Smith. I merged their asses together. And that's this probably the picture represent them, because this is a light-skinned version of Catch a Dog Smith. Check it out. That's how Catch a Dog Smith. I didn't get a chance to merge them pictures yet, but he done fucked up. He done messed up. So let's listen. Let's see if they're going to get back to it. Again, thank you for all the super chats. Everyone who has been supporting me today, thank you. This hasn't been an easy broadcast. I'm going to be honest. I haven't been sick in years. I don't get sick. So I took Tylenol and my temperature went up to 100.3, and I took it as 100.5. We almost through this, though. I'm a trooper. You know what I'm saying? I'm over here, dehydrated. I love you guys. Please just hit the like button. Keep us in the algorithm. I have some things to share with y'all next week. I appreciate you. I'm feeling good. I'm feeling achy. I didn't even know that my temperature went up. So I'm over here tripping because I'm pushing through like a nurse would. We just like, boogie. And I'm so intrigued. You know what I'm saying? Catch a Dog Smith and all his ass intrigued me with his lying, filthy, McNasty self. So it's definitely keeping me going, and all of your love and support as well.
Oh my God, that was so.
And please, y'all, I think they're coming back.
Oh my God, that dude lied up under the oath said he ain't been fired.
Yep, we just talked about that.
He ain't did none of those things that was written about him.
Yeah, I'm going to take a chill back.
Out of the meeting. I'm here in Thornton Township.
Thank you for your concern. I appreciate you. I'm a little thrown off because I never get sick, but I'm here for it. I'm fighting, solid like a rock. I'm sorry, y'all.
Right, and he lied about not supporting Tiffany. You right.
The last time I did this was like 2 years ago. She did it. I called on the morning and she had it issued by 3:00 in the afternoon. Well, there's a woman, Kelly, who's a clerk, and so I just emailed her and I said, hey, I need to enforce an electoral board case, and she.
see what the board decides, but that's good to know for the future. 'Cause my experience, well, I haven't done.
I did it many years ago, but
I think that lady really wanted Napo to come so she could see him. I think she was a fan. She really wanted him to be cross-examined. They're gonna Lansing Journal leaving.
Even the Lansing Journal, like this mad
We
hours.
going skating tonight.
I will hope that this is it. They have to move this on to another day because this is long as all hockey sticks. And I mean the proceedings are pretty clear though. Pretty straight to the point.
We're gonna go back on the record.
Come on.
We're gonna take something a little out of order. Earlier in the meeting, we did talk about 2 decisions that needed to be issued in 2 other cases. Mr. Price, wait, don't go anywhere. I got to give you a copy of the decision. So we want to go ahead and give these decisions. So the first case is Soup 01C, and this is the written decision of the board. This matter was dismissed. So if the board members could sign. The printing for some reason.
Y'all know I'm only gonna do content. I ain't skating tonight.
Your name's on the other side.
If I fall in this forehead, please. I'm not going back into surgery for no skate.
So again, just for the record, this is the written decision and the Soup 01C case.
No, I told my son I was gonna take him skating. I'm gonna take him.
I'm with y'all. I'm trying. I want to hear the proceedings too, y'all.
I'm not skating no way when I get.
Come on, Vivian.
Written decision in order.
So move on 25 TOEB Trust.
Soup 01.
Soup 01.
Second. All in favor?
Aye.
Motion carried.
It was denied anyway.
Okay, the next one we're gonna do, and we'll do that.
And y'all, Vivian is not supposed to be saying I. So I just have to tell you that I don't know why she keep doing that, but she's not supposed to do that, y'all.
A copy, a receipt of a copy of the decision.
Verbally or I gotta sign?
No, you just gotta verbally say, I accept
I accept
service of the
receipt.
decision.
I accept receipt of the service of the decision.
Thank you.
And that was decision to pull back, I believe, on their objection towards Napoleon because they had that missing paper. Y'all remember? You can hear me? They had that missing paper. So he pulled his stuff back and they still took him through the ringer and shit. You remember? So that's what they talking about.
Fully executed ones. Thank you. There you go. Mr. Price, would you also mind handing Mr. Ledezinski one?
Anybody? No.
Okay, Mr. Ledezinski.
I now
do you
proceed
have-
from Mr.
Thank
Price.
you.
Cordially.
Yeah, you can keep a copy.
I need some ice.
Yeah, his stuff was
I need-
denied.
Yeah, I need a copy for us. Okay.
Oh, yeah, we got it.
Oh, sorry, y'all. Sorry, I'm drinking.
Okay, the next one we're gonna call is trustee 01C, and this is the,
That's
objection
drinking.
against
Thank
Lord
you.
Baker. The objector withdrew the objector's petition, so we just need to do a motion to approve the decision acknowledging the withdrawal of the objector's petition. Second, please.
Second.
All in favor?
Aye.
Motion carries.
I'm practicing in case I do run for trustee one year.
You straight go to the end of the line.
The pay for supervising starting off is like 59,000. I want to say it's not what Henry gets.
Napoleon didn't get back on the ballot yet. They're talking about the other objections that was withdrawn from KP and Smith. So that's what they hit. That's the decisions. But this one is still, I think we still just waiting on one more thing with this current hearing.
He don't look happy.
Thank you very much.
Like his hips hurt.
All right, now we're gonna move back into
That goes Michael Smith. Michael.
Thank you to the parties. Just wanted to take care of that order of business real quickly. So when we took a quick break, the issue that was, prior to the break, rather, the issue that was being discussed was the enforcement of the subpoena to Dolores McGee.
Just say no. She don't want to come.
And, you know, the parties wanted to take a quick break and possibly have some discussion. Is that still where we're at? We're still talking about the enforcement of the subpoena for Dolores McGee?
Yeah, we're requesting the board issue that subpoena, and we're going to complete our day with that and not call Ms. Graham to diabetic come in.
Okay, I think that she might already be coming in though.
You don't want her now? That's what we went out to talk about. Okay, you don't want her?
I believe it.
Sorry.
He don't want the witness because he know that she ain't gonna say what they want her to say.
We will email, I'll make sure Hannah and I will email it once out to you guys, so you guys have your own copy. It's honestly most important for me to get a copy, so that we can put the record.
Oh, do you have everything?
You have a trustee of the suit? Okay, all right, perfect. And then I have my, if somebody wants to answer.
So while we're still off the record, can we try running through what accepted into the list thus far?
Yeah, that's fine. Real quick, the items that have been entered, at least from what my notes say, are candidates exhibit 12, objectors exhibit 15, objectors 1, candidates 7, plaintiffs 3, which I think is objectors basically. I think used interchangeably. Plaintiffs 6, candidates 45, candidates 36, and candidates 2.
Do you have a plaintiff exhibit? Do you say plaintiff and or objectors exhibit 5 utility history? Yes.
I'm sorry, utility history? Oh,
That's a,
was that moved in?
yeah,
Okay,
that's
I
a
missed that.
summary. Yes.
Okay, thank you very much. Is there anything else that?
And you said objectors / plaintiffs exhibit 1 photo I've accepted.
Yeah.
Okay, thank you. That's correct.
Okay, thank you.
Just so my list is correct. We admitted objectors 1, denied 2, admitted 3, denied 4, admitted 6, and admitted 15.
And 5.
And 5?
Yes.
And candidates exhibits admitted 2, 7, 12, 36, and 45.
That's what I have.
And what do we do with 48, the most vision of the cars?
I do not have that.
I believe that the board decided not to accept that.
Did not, okay, that's what I thought, okay.
Okay, so, all right, back on the record. So as stated, we are, the issue before the board right now is whether to enforce the subpoena against Dolores McGee. Both parties have offered some positions on that. Unless there's anything else that the parties think that they need to add to what they've already stated, I would ask the board where they lie on this.
Where are we with that witness? She said she could come back in, is she coming in?
No,
That's a different one, that's Ms. Graham.
they said they withdrew her.
Nina Graham has entered the building. They are withdrawing their request. So
Nina.
Is she gonna be recalled at another date?
No, we will withdraw our request to
Ms. Graham.
yes.
Okay, because I just don't want later
No,
on for
no,
her to be
I-
called
I-
to come
I
in.
would
I think that would be grossly inconvenient.
Again, audience, guys, that's not my commentary. That is Vivian. Please be appreciative that she's letting me stream. I know that you guys not interested in her commentary, but I'm trying, y'all. So don't put that under the comments because I don't want them to, I don't want y'all to think that is me. It's not me. It's her. Okay? Please.
Does the candidates council, do you plan on calling her for any reason?
I have no reason to call her.
Okay.
She has no.
Okay, all right, then, and what does the board want to do? Is it okay if she leaves?
They don't want to call her, sure.
Okay, all right. Ms. Graham, wherever you are, thank you for coming.
That's Nina from the school board, right?
That's bogus. She done came all the way back up here.
That's the one Hinger was yelling at. Y'all remember? Nina, that's you. I'ma shut up.
So we were told that Nina Graham would know information about where Senator Harris lives, and so they're withdrawing their request.
Yes, that's what we're, okay. Yeah. So Ms. Graham is not gonna be called.
What she come up there for?
The subpoena you want us to enforce, how many other witnesses are there likely to be? 0. This is your last one.
Oh, wait, is she here? Okay, no. What?
McGee is your last one, right?
Yeah.
Mr. Razinski, you envision how many witnesses?
I envision looking for directed finding.
We can't do that until if we enforce McGee's subpoena.
Right. So I can't tell you how many.
So I think the board has a few options, obviously. One option is to send me to court to enforce the subpoena. That's certainly within the board's wheelhouse. The other option is to deny it and say no. And then I believe that they would rest. And then the burden would then shift over to the objector, to the candidates. Or the other option, I think, the board can just, take notice as to what it thinks that, based upon the representation of the parties as to what Ms. McGee was going to testify to, and see if that makes any difference. So, and it's completely up to the board, but I just want to lay out what I think your options are.
Can there be any stipulation as to what her testimony would be?
The problem is, she's what, 90?
I believe she's an elderly lady. That's all I really know about her. And we have no idea what she knows, what she doesn't. We know nothing about her.
I've never seen my neighbors.
Is she
My
elderly?
new neighbors.
Because I'm
Elderly
elderly and
or
working.
confused to me at all.
So I don't know.
When you said elderly, not confused.
Well, you didn't say she didn't know what was going on at all.
She didn't.
So there's no chance of a stipulation.
I've not interviewed her. I mean, I interviewed every witness that we've tendered, including witnesses that they tendered that are not here for a reason. I have no idea what she's gonna say.
Well, I go back to, it sounded like she would say something relevant. In which case I would go to enforce the subpoena.
I'm opposed to enforcing the subpoena just because of the timing. They're just expedited election cases are just unlike that. I mean, whatever evidence you can enter, you enter, and what you can't, you can't. This is a 2-week delay.
Yeah.
I seem like I'm gonna be the tiebreaker. So, Mr. Mullen, I've got a question for you. How much of what you envision her testimony being would be cumulative of what we've already heard?
I don't believe it would be cumulative at all, because none of the witnesses that have been called thus far actually live on the block that Mr. Harris claims he lives on. So she's there every day, and at all different times of the day.
And here's in the unit attached to his purported residence.
My grandma don't go outside.
Then I'll vote for enforcement.
No.
Okay, so we have so let's take the formal motion in second. So we've got discussion. So Member Osfeld, are you making a motion to enforce the subpoena as requested?
Yes.
And specifically for Ms. Dolores McGee and,
I will second.
okay, all in favor?
Yes,
Yes.
no,
All right, I was gonna say any opposed. So we've got a 2-to-1 related to enforcement of the subpoena.
Then what do we do for scheduling down the road?
Simply because I'm the one who suggests we enforce it, and I won't be here next week. You know, but, it's the Monday the 10th.
Let me double check.
If not the 10th, first day of the 11th.
I cannot do it on the tenth. I have to read a book to a class of second graders that
And how is that different than this?
There's more maturity there.
Let me go off the record.
Absolutely, yeah, let's go off the record to discuss scheduling.
So are
The
we,
11th, I cannot at all because I'm in arbitrations all day.
so you're out the 10th and the 11th?
Yes.
Are we canceling February 4th?
I mean, they're still in their case in chief. You can't, the burden doesn't shift. And they're asking for enforcement of the subpoena, so since we're gonna be enforcing the subpoena, I mean, yeah, we can't do anything.
February 4th.
We can't do anything until.
I'm not putting anyone out of order.
Okay.
You,
I just asked. since
it's already 5 o'clock. Mike's testimony is going to be longer than anyone wants to stay here.
Longer than what?
Anyone wants to stay here.
Oh. So how about the
So we
12th?
will do mine tonight, or we?
No.
Wait, Mike, who?
Door is here. Are we gonna hear him?
Not today.
You're gonna make him
It's not-
here again?
It's not,
That's what
the
happens
burden hasn't
unfortunately in these
shifted to them.
cases.
The burden hasn't shifted to them. They do not have to do anything right now except respond to everything that the candidates or the objectors are putting on.
And perhaps
Yes,
we'll
the
stipulate
objectors-
this
If Judge Ward Kirby rules as quickly as you indicated, Mr. Mullins used on other occasions, we could keep the afternoon of the 4th.
I don't, that would require her to rule
So
and then
that's
you
not
get,
the-
and then to get the.
No, we'll cancel the 4th.
I'm fine with the 10th, 11th, or the 12th. I know you're not, but the 12th is fine with me.
What time is your, you said you're reading with the kids on the 10th in the
I
morning,
could
or
do
the afternoon?
I could do it in the afternoon of 13th.
The 12th. Oh,
12th.
I'm not, are we allowed to?
State holiday.
It doesn't mean,
That doesn't mean anything. I'm not a state.
Well, I mean, it does though, because isn't there a provision in the Open Meetings Act that says we can't hold meetings on state holidays? In fact, I believe that there was a case that a few years back, they invalidated an electoral board decision or something because it was given on Martin Luther King Day,
They didn't invalidate it.
or they tried to.
And I'm out of town starting February 16th.
The afternoon of 10th seems to work for everybody though, right?
The afternoon of the 10th, I could be here.
Okay, then let's do that, Lynn,
That's fine.
Ellen?
Yes.
Okay.
What
I
time?
think you did,
The earlier the better.
On the 10th.
Okay, what time is your reading with the kids?
It's at 10:30.
Downtown, like where at, whereabouts?
In the western suburbs.
Okay.
And I'm an hour away from here when I get done there. So I probably, maybe could be here by 12:30. 1
Okay.
o'clock, sir.
Why don't we set it for 12:30 and if it's?
I
oh,
have
you can't?
hearings in the morning. I could do the afternoon,
Okay,
but it's going to be on the 10th. I'll try to move one of the hearings up. So the earliest I could be here is 1.
okay,
And I'm nearby for the hearing, so it's not like I have to travel.
okay. How about you guys?
1 o'clock.
1 o'clock on the 10th?
Okay, 1 p.m. on the 10th. Michael Smith came back.
So all that's left in the objector's case in chief is Ms. McGee.
Well, do we want to go back on the record now, or? we
Yeah,
go off the
yeah.
record?
Go back to the record.
Okay, back on the record. Go ahead, Mr. Levzitsky, you have a question?
I'm trying to think scheduling because I have to worry about my witnesses. If they are done, except for Ms. McGee, I can schedule.
Well, if we have the other date though, can we have our other subpoenas returnable for that date, continue for that?
What other subpoenas?
the ones that we have not been able to serve because we don't have the service.
Well, they.
If we can't get them served, we can't get them served, right? Napoleon Harris and his wife. There are other key essential witnesses.
What does the board want to do? To the third board, I suppose. You're still your case in chief, and that afternoon is blocked
Well,
out.
it's 10.
So,
The 4th is off.
oh, the fourth is,
We're not meeting till the 10th.
that's right, the fourth is off.
Yeah, but it,
Well,
Well, I never saw the proof. I'd still like to see that service was attempted and failed.
And we will get that for you.
But, so here's the problem I'm having with this, is that this trial was scheduled to start. Okay? The subpoenas were, returnable. It's clear, and now I'm starting to think that all that went on today was to delay this, because I really didn't hear much relevant probative testimony.
At all.
And that's what my concern is here, is that they didn't do what they're supposed to do this. If you recall, we were doing one of the hearings with one of the attorneys for the objectors in Springfield, because she was down there on government business, meeting with township officials. Mr. Harris's schedule is pretty well known. Okay, I just they just want more time to do what?
Well, if you're referring to me, I was speaking at the Illinois Association of Park Districts conference in Chicago. I wasn't meeting with township officials in Springfield. But we have subpoenas that we have permission to get issued. We have a continued hearing date. There's no prejudice. This is a party who would be significant testimony, in our opinion. If we can get them, we can get them. If we can't, we can't.
And again, this was the day for trial.
It was.
They have said, and we will sit here, I'm happy to finish this tonight if they want to do that. But we're accommodating the objectors in trying, and now the board's going to enforce the subpoena. It's fine. But that's an accommodation. They've indicated and said that this was the last witness that they had. That was it. And then now magically that we're gonna have a new date and we're canceling a date that was going to be for the issuance of the final decision. That's what we scheduled February 4th for. And that's why respected member Oswald didn't need to be here, because it was just gonna be signing the final decision. And now we're kicking this out to February 10th. And just so that they can have the one last witness, and then if necessary, because we'll make that argument at the proper time of why that likely will not be. But if necessary, then we'll put on his case in chief. But that, to now say, oh, well, we get more bites at the apple because we didn't do our jobs initially, and now we're gonna try to fix that later. And I bet you they would also try to have another whole round of document dumps and do whatever and get new pictures, and magically all the things that have already happened at this hearing, we're gonna get more of that, because if they want to use this more time, and it was a tactic, it is very clear, as Mr. Levinson said, that this was a tactic to delay these hearings to try to get this extra new date. And I strongly object to that they're being able to continue and extend their case in chief beyond what they've already represented that their case in chief is going to be.
as far as I'm concerned, the representation was that this McKay was the last witness. That's what we'll hear in the defendant's case if we get to it on the 10th.
Okay, so your opinion is no continuance on the subpoena?
That's right.
Okay, other board members?
I'll agree.
Okay, so is there a motion, member Swanson?
Yes.
And a second, member Esco?
Second.
All in favor?
Aye.
No. Okay, I'm sorry, and so opposed?
Yes.
Okay, so 2 to 1, so member Reagan, you would in fact continue the subpoenas?
Yes, because if they provide proof that they said, I mean, I don't think avoiding service of the subpoena is an excuse for not coming.
Exactly. So I want to clear something up in the record. Okay? They know where Senator Harris was. Okay? They know where he was. He's in Springfield. Okay?
They said they tried to serve him in Springfield.
They said,
But I don't have any proof of any.
Right,
exactly.
It's insinuating that he's dodging service or something like that is just improper, and it's unfounded, and there's nothing factual in the record or otherwise that actually establishes or hints at that he was dodging service. He was doing his job at Springfield, and that they failed to do it and failed to actually serve him is on them.
Hello.
I would say both positions are noted for the record, so, I don't think that the board is making a determination one way or the other, but the vote is 2-1 to not enter and continue the subpoenas. So we will return on the 10th, and between now and then, I will be, working on the enforcement of the subpoena for Miss Dolores McGee. Is her name Dolores? Okay. Dolores McGee. So I'll be working on the enforcement of the subpoena for Miss Dolores McGee. If she does not come on the 10th, which is always a possibility. I mean, if she avoided the subpoena once, even though there's been an enforcement of it, there's a possibility she doesn't come again. You know, the board will have to decide what it wants to do at that point. But we will return on the 10th at 1 p.m. Is there any other business that either parties want to handle before we call for public comment? Okay. Then at this time, in accordance with the agenda, let me ask this, are there any other items that the board wanted to address before I call for public comment? We do have an opportunity for public comment. Public comment is allowed under the Illinois Open Meetings Act. We do ask that everybody limit their comments to 3 minutes in accordance with the rules adopted by Thornton Township. Mr. Smith, you stood up and want to give public comment?
Yes, I want to put on record that I received an expungement of my record December the 2nd by Tommy Brewer of the Circuit Court of Cook County. And so I have no right to say that I've been convicted of anything because I have a full expungement, which I will provide in documentation to this board from Cook County Judge Tommy Brewer on December the 2nd here in the Circuit Court of Cook County in March. I will be providing.
Okay, thank you. Is that the conclusion of your public comment?
No, I got my hand.
No, ma'am, I wasn't talking.
Oh,
I
I
haven't
also
called on you
want to
yet.
say, I would like to mention, throughout these hearings, I do not appreciate the fact that we do have a chair of the electoral board. I understand the electoral board rules. And if any way I disrespected the electoral board rules, I want to apologize. But we have a chair of the meeting. And Ms. Raymond is our chair of the meeting. Am I correct or not? Ms. Raymond is the chair. I just want to put that on record. She is the chair of the electoral board. Thank you.
Mr. Lynn Harris, I believe that you wanted to make a comment.
This honorable council board, you know, as a taxpayer, as a voter, I'm 78 years old. And I think as a voter, I should have the right to hear what Senator Napoleon Harris III had to say about these residents. I think it should have been at this council meeting, coming from him. Where does he live? And only he can tell you where he lives. And I think he should have been here, or should be before you, to answer that question as a taxpayer. Because now I am just totally dissatisfied. That he's not gonna be forced to be here. You got all these electronic devices. How come he wasn't put on electronic video and speak to this council?
It's not
and
allowed.
to the citizens of Harvey and to the Thornship citizens.
Thornship.
That's my comment.
Thank you, Ms. Harris. Any other persons wishing to give public comment?
Can I just say, as a registered voter of this township as well, Vivian Allen,
I just feel like just watching the attorneys, they wasn't prepared. And like he said, they was using our tax dollars to print out materials, which should not have been allowed. So I'm a voter as well, but if they wasn't prepared for their case, you can't force someone to come in because of their neglect. So I just feel like it was on the attorneys, not on NAPO.
Thank you, Ms. Allen.
Thank you.
And sorry, I forgot your name. I know you
Yeah.
make an appearance in Harvey Historical Society. I know
Right.
that.
Oh, you remembered. Yes. Sorry, I don't have my gear today. Ryan Cybulski, Harvey resident, Thornton Township resident. I run the Harvey Historical Society. Thank you all, for being here. Glad to be here. Unfortunately, I feel like there's just a lot of wasted time and resources. We have, and we've known for a long time, probably since April 22, I want to say, there was an incident with Christopher Clark with his security guards in Chicago. And where he noted to Chicago police, it was near his residence in Chicago. Christopher Clark does not live in Harvey. Napoleon Harris has not lived in Harvey for years. He does not live in either of his districts, by the way. He's the Democratic committeeman for Thornton Township. Flossmoor is outside of Thornton Township and I believe outside of his Senate district. So that is the great irony, is that it is indeed possible, because Mayor Clark doesn't release finances for the city of Harvey, that our taxpayers could have been paying these lawyers this whole time. It's very possible, because he doesn't release them to us. He actually has arrested me and others who ask. So the irony is that they're both duking it out. I hope they both get knocked off the ballot, because neither of them live in the district. And the lawyers don't care, because y'all are happy. You're just getting paid. But the sad thing is that we're probably paying for it. And you guys certainly have a lot better things that you could do, I'm sure, on a day like today. So the whole thing is just slow and dragging out. And it's wasting our tax money. And the politicians and a lot of the lawyers just think that this whole thing is a joke, that we're a joke. I'm not a joke. Like, we have residents being killed, freezing in the streets. We don't know where our money is going. These are serious issues. You all go back home and you probably have communities that are pretty chill, but I guarantee you in this township, it is rough and tumble. It's rough and tumble. And these politicians, it's just all a game to them. But I guarantee you, neither Clark nor our Harris live here, and neither of them really want to do good for the township. So I just had to get on record to say that.
And thank you for your comment.
I am. School district.
Just one thing I did want to know for the record, and I neglected to say this before we started public comment, is that public comment is required under the Open Meetings Act. We do have to have public comment for every board meeting. Electoral board is included. However, the board cannot take any statements made in public comment into consideration in its deliberations. So the board cannot make any of those. It appreciates your comments, but it can't take it into consideration from anybody as it relates to the merits of the case. So I just wanted to make sure that was clear for the benefit of the public. There being no other business before this board today, I would suggest a motion to recess until the 10th.
It's at 1 p.m.
All in favor?
All right, y'all. All right. Let's take this off the screen. I want to first and foremost say thank you to everyone who's been here from the beginning. It was a few of you guys here, at least 80 of you guys that was here from the beginning. This has been a 6-hour live. I can't put myself on the screen, y'all, for the people who are just coming in because I'm a little under the weather. I didn't know that I was going to get sick, and my temperature has been increasing the whole time since I've been on this live, but we did it. Okay. So the first, content creator I want to shout out is Critical Smoker, because he was there first. And then the next content creator that I want to shout out is Reality Check TV, because I jumped onto his live because Critical Smoker left. And then when Reality Check left, I had to jump on Vivian live. I want to say thank you for everybody who tolerated this live. I know we all have different audience and we have different ways of looking at things, so it was hard to swallow, but we did what we did and we got a lot of information. So I have to give a shout out to Miss Vivian. She was my co-host at the end. I'm saying, hey, I let her rock out, because at the end of the day, I wasn't feeling totally well. And as people listen, I think that helps them, but we don't do a lot of that during the live. But it is what it is. So we have to follow up on February 10th. Oh my God, this is being dragged out. Fucking ridiculous. And we're looking forward to seeing Napoleon's neighbor. Allegedly, this person wasn't even on the list. That's why I put in the audience. I'm like, oh my God, it's supposed to be 4 witnesses. Where we at? but they were even going to let Miss Nina come in there. And I don't know why they play with that old lady life, going to get that lady to come down there knowing she ain't know nothing. Nina plead the fifth, as someone said in the audience. Shout out to you guys for being engaging, critical thinking skills, looking at everything objectively. That's what the hell we here for. So Nina turned around like, no. So I do agree with the audience member that says they are creating contentious relationships. But these people in Thornton and Dalton, these whole, I think, Chicago politicians, they actually going in and out of their feelings. Honestly, they don't hold grudges. It's all about who you align with for the minute, because they just need to stay on top and control the narrative and the people. That's just being honest. So it's like they cool today, mad tomorrow. Cool tomorrow. If you saw Hinyard kicks Zuccarelli back in and she was under him, he mentored her. He really helped her ass out. And the same with other people. So just keep your eyes on the prize. I don't think that everybody should put their guard down during election time when people claim to be part of certain, how can I say, parties or whatever, because they be changing shit like tomorrow. Y'all already saw what they did to Miss Wells. Now, Miss Wells walking around with a bodyguard, allegedly. You saw her at the caucus with the police there. And y'all saw what happened, the setup with Jedediah. No matter what, like I said, I'm a lonesome dog. I do my thing, but real is real. So I saw what I saw there. This monster is really causing mayhem. So I do want to get to something that's in my inbox before we get off of here. There was an announcement made by the trustees. Allegedly, they're looking to petition Governor Fitzer about the situation about Hinyard attacking residents, because you know what we saw. But honestly, they're going to leave that in the courts. I think that at this point, it's only 4 months, less than 4 months, and these people don't want to have nothing to do with Hinyard. They never did. So I'm not being funny, but I do think that's a publicity stunt, because at the end of the day, either that is to circumvent the bad talk that's going on with Jedediah, which is understandable, to call her outrageous on what she's doing. But do I think it's going to get to Governor Fitzer? I really don't think so. Let me just get to this paper that they have. And shout out to one of our residents in the background. She's been helping me out, sending some things to me. So I appreciate you. Thank you so much. And as I mentioned to you guys, Grace Levi, I do be skeptical. So y'all got to bear with me. I'm just keeping it real. Y'all know what I do. Hold on one second. Let me put it on the screen real quick. I'm going to get dots off of there. Y'all saw Hinyard in the building over there talking to Keith Price? She came in there. So she's not, I don't know if she's totally mad at Keith Price right now, but I know KP he's hurting. Like physically, he's going through whatever he's going through. His body can't take this shit. So global call to action, mega Zoom call to demand Governor J.B. Fitzer remove Tiffany Hinyard today at 3 p.m. So that was going on while we were live. Thank you to everyone who respected the chat. I don't want to disregard no one else's thing and things that go in Dalton, because I'm here for it. But it's just a time and place. I didn't want to distract the audience with this, because I think that this is something that they're going to be addressing over the days. So Dalton, the business, Dalton and Thornton trustees stand united with the outraged residents, community leaders, and local officials in demanding Governor Jay Fitzer, Attorney General Kwame Raoul, and Cook County State Attorney General Elaine O'Neill Burke take immediate action today to remove Tiffany Hinyard as the mayor of Dalton and supervisor of Thornton Township, following her last public display of violence and abuse of power. At Tuesday now viral board meeting, Hinyard, her boyfriend, and accomplices physically attacked residents and audience members, escalating years of alleged corruption. Intimidating and financial mismanagement. For 3 years, Dalton and Thornton Township has endured her reckless rule, with tax dollars funded her lavish lifestyle while residents suffer. Despite over 56% of voters recall Hinyard in 2023, an appellate court overturned the decision, leaving the community trapped in crisis. State leaders must step in now. So I was looking at it, and this Zoom call wasn't held by the trustees, but I think it was released by the trustees. I did see Zoom call for Jedediah. So when I looked at it, I was thinking that, like, because somebody was like, Governor Fitzer is going to make an announcement, but that's what they came in the chat and said. That's why I was like, don't do that, because then you have people running after that information and it's not true. So I did my little short research, and then one of the residents put this in my inbox for me so we could be aware of what's going on. So this is something I think they're going to follow up with. But if he ain't do nothing before, all of them didn't do nothing before. They've been watching this. I just think that this is just something to counteract what happened with Grace Still's client, Jedediah. I'm just being honest. It is what it is. So it is a good thing. People need to unite, because I do think that the mainstream media is trying to change the narrative, despite which I believe or no matter what, Grace Levi is truth and honor. So I have been under people, big channels, under TMZ. No, it's somebody else. It's three people I was under they video, basically correcting them, making them see that it was Tiffany Henyer who set some things up. The TMZ interview with Jedediah didn't seem like it went too well towards the end, because they were trying to make him seem like he was a starter, someone who's looking for attention, and that's where it went down that route. You see what I'm saying? But honestly, they don't know the deep down nonsense and horrific things that went on. They're not taking into consideration all the lawsuits, all the people who she disrespected from the beginning. She been calling people bitches, making them lose their jobs. So for someone to come out their face and say that, I think that's another form of gaslighting. That's what politicians do. So they're like, oh, you didn't say it right, and that's why Grace Levi fought for my freedom. Y'all can see I was the first and main content creator that said, y'all, I'm not going with the narrative. You're not going to control what I say, because that's a dangerous position to be in. So it's good that everybody now is fighting for their rights, speaking up on how they feel, and no one can control the narrative. They control the narrative by being politically correct. And that's what I'm telling you, that's what I suffer in nursing. That's why I came out like a banshee at the beginning, just talking, because I was so suppressed. And everything I said had to be politically correct, knowing people was dying. People's life was on the line, and it was like, it's not what you say, it's how you say it. If the doctor don't know how to intubate, and I'm like, let the RT intubate, please move over so we could save him, how the doctor mad at me? This is some of the shit I went through, so I understand how politically correct bullshit could really hurt people. So that's why I'm here. I appreciate you guys. I'm glad the tone is out there. I'm not saying what we say, we'll shut shit down. But I'm not saying tear everything the fuck up. Excuse my language. But I'm saying stand up. Follow through. Don't just yell and scream. Follow through with your words, your actions, petitions. Follow through on your public officials. Come up with your own agenda. I seen a resident, thank you, Jesus, and I'm going to say it. He in Thornton, one of the Thornton groups, basically is coming up with an indigenous people's party, and he's talking about economic sustainability, things like that, and basically coming from the residents' perspective. And I was like, that's great. You see what I'm saying? But shit like that can be half-assed. So I basically told him that's amazing. The only thing that I did not agree with was calling it indigenous, because everybody don't know their nationality. I am well versed in nationality. A lot of people don't know who they are. So that in itself, I just said, be careful with that. But the idea of having a social economic forward, how can I say, organization for the people that they're putting together, it makes sense. So that's what he's doing. If I could help, like I told him, I just left a message, but they try to ignore me till shit hit the fan. I told him I'm very versed in economics, social economics, financial stability, and group diversity, highlighting money management. That's what I really taught myself a lot. Like, so if anything I can do for people who are really trying to get together and make shit happen and don't have this ulterior motive, like they want to be number one and all this bullshit, and y'all really want to do something, I'm down. That's one of the things I'm gonna just get off on this, that Miss Cara fell in love with me. I'm gonna be honest. She respect me. I make people uncomfortable. I think I make Miss Cara uncomfortable too. And I want to say happy birthday to her today. Today is Miss Cara's birthday. But she never disrespect me. She never disregard the work that I put in, and she knows that I'm going to be me. And while her letting me be me, literally we are making footway on this Alexis Wilson case. So if y'all don't know, I had read an open letter to the Dalton trustees about basically turning Melanie Fitness into a YMCA type of organization to commemorate the memory of Alexis Wilson and use the cop forfeiture money. You see what I'm saying? I'm not going to just throw shit out there and not have no idea. So that's what I'm pushing. So at the bottom of this video, I'm just going to ask for you guys to sign a petition that I have at the bottom. Today is Kara's birthday, y'all. Please help me out. This has been an uphill battle by myself. No one has been helping me. I never get donations. She never gets donations. And I can't lie to you guys. It bothers me, but I give donations every month. I haven't made more than $120 on YouTube. And I'm not going to cry because I love Cara and I feel so bad for Lexi. But I haven't made more than $120 on YouTube. And every month I make a donation. And I just ask for y'all to do the same. I know my heart is in it, but I'm going to keep pushing. And I'm going to keep keeping y'all informed. So let me get off of here because I'm getting sentimental. I want to say happy birthday to my sister from another mother, Miss Cara. I want to say thank you to everybody. We made it through this long ass live. And thank you for supporting Grace Levi. It is time to vote. It is time to get this bitch, excuse my language. I know I had to flip it. Get her out of here. She's terrible. And with that being said, let's put the monster on the screen.
Leader, they want to hear from the mayor. If y'all ain't learned that yet, the mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, no work.
I'm Cara Wilson. I'm the mother of Alexis Wilson, killed by Dalton, Illinois police. At the time that my daughter was killed, Tiffany stood in front of a microphone much like this and said that she stood with the cops and they did do the right thing by killing my 19-year-old child. Not only did she not take those words back, she didn't offer her condolences. She's never said anything. The first thing she did was hire this group of security guards to surround her and PR. So the real reason Tiffany has security is hiding from accountability about what she said about Alexis Wilson when she was killed. Now, if you watch the coverage of this murder, these officers violated her rights, reached in her car, jumped in her car, and put 7 bullets in my child. 2 in her head and 5 down her side. And the next day, you guys tried to spin it like she did something. Watch the video. She did nothing to deserve this. And again, last time they brought up Alexis, she's doing what she does now. Look this way, look that way, every way, but at the person talking. You don't give a damn, and you never did, and you never acted like it. She called out a whole press conference to call my daughter a criminal, and Homewood Flossmoor graduate with no criminal record. But Tiffany, you have one, because we used your mugshot to protest in front of your house. And that's why you hid. That's why you have security. So let's tell the truth, which I know you're incapable of. I wouldn't trust this woman if she stood on a stack of Bibles and had her tongue notarized. Not a damn thing she says comes out her mouth is true. Thank you.